Hello, everyone. Welcome to Uncivil Law, and I hope you're having a great day. I'm having a wonderful day. We turn our attention once again to the Sarah Boone trial. You remember Sarah Boone? She got her boyfriend into a suitcase and then refused to allow him to leave, and then kept him there by flipping over the suitcase and using a baseball bat, and otherwise taunting him, and otherwise being a total horrible, horrible monster, cold as ice. Yesterday, we heard from Sarah Boone herself in the form of her interrogation videos, both in the car, when she was initially interrogated by the police briefly, and then a longer interrogation session at the police station where she was arrested. And she is a horrible, horrible monster of a person and deserves the worst fate known to man. We are expecting, or at least the way things seem to be going, the state looks like it might be wrapping up today. We might have heard from the last witness already. We didn't get cross-examination of that witness yesterday. So it looks like we're going to begin this morning with cross-examination by the defense of the detective who was present during the interview. And then it looks like the state might be resting their case, which would be interesting and certainly an exemplar of the way of doing this in the most efficient way possible. It is a very lean prosecution. No muss, no fuss. Just get the witnesses on and don't overstay their welcome. Sometimes ask them literally 5 questions because that's literally all you need. They're on all, they're there all 60 seconds and then they're gone again. And then we're on to the next witness. And that's some of the things we've been doing in this presentation. And the state, if anything, has been backloading the most interesting stuff with the video. It also has the interesting factor that not only do they appear to be mic dropping their prosecution with the confessions of Sarah Boone, which is a pretty strong choice, I'm not going to lie. It's a pretty strong choice. The only way this could have gotten any better would have been, or arguably different, would have been to mic drop the video of him begging for her life. But since the interrogation video included that video, I think you kind of had to do it the other way around. So that was probably kind of forced by just by that consideration. But in any event, the way that they've backloaded all the videos so that basically the words of Sarah Boone are the last thing that come out of the mouth of the prosecution is a very, very interesting move. And the more I think about it, the more I like it. And the more I think about the fact that it's so clean and so efficient, the more I like it. So while I still have my criticisms of the state, I think this might be a new exemplar. Not necessarily the only way to do it. There are other ways to do it, but this might be a new exemplar for at least how to do a case very efficiently and with a minimum of fluff. And just get to the point, sir. Because how many times and how many trials do we were like, please get to the point, and they just won't get to the point? It happens all the time. But fortunately, for today's purposes, we're getting to the point, which is nice, and I'm here for it. So that is what we're expecting. We seem to be anticipating, based on everything, the state may rest today, and that means that we very well might likely hear from Sarah Boone herself today, because she has to take the stand first in her own defense. Because if she wants to try this self-defense battered woman syndrome theory, which seems to be what she'd like to try to do, she has to provide the predicate for the theory, because she's an essential witness, because obviously she's the only one there. She's the only one who can possibly testify to what happened in the moment, because she's the only one there. So she's a necessary witness. Plus, we need to talk about what the overt act was. And there isn't one, incidentally. But she's the only one in principle who could offer that. So she's going to get on the stand and she's going to give her testimony. And then there's a pretty decent chance the state is going to object at the end of that and be like, she can't offer self-defense. She can't offer battered women. And I think there's a pretty decent chance the judge is going to agree. I think there's a pretty decent chance the judge is going to say, you can't offer that defense, having just testified, because you did not provide the burden of production. You did not provide the minimum scintilla of evidence to provide a basis for the defense. So I think there's a very strong possibility the defense gets excluded. And the judge has already teed this up, by the way, so it wouldn't be a surprise. The judge has already told them that this is what they have to do. They have to provide this evidence. They have to provide the overt act. The defense so far has suggested that him trying to escape from the suitcase was the overt act, which makes no logical sense. It can't possibly be the overt act, because if he got out of the suitcase, we know what he would have done. That doesn't work. That doesn't work. It doesn't make any sense, because he has every right to leave the suitcase, and you're holding him there, and that's not good. So, yeah, we'll see. We'll see, but that's where things are heading. Thank you for joining me this morning. Glad to have you here. Tell your friends. Tell your friends that we have the best commentary over here. Yeah. One does not simply exit the suitcase, says Marco in chat. Pretty much. Sarah Boone's Flat Dr. Pepper joins us. Good morning, chat. If she can't manage a scintilla with her rambling, that'd be something. I don't think she can. She can't provide the factual predicate for it, because it doesn't make any sense. Her story doesn't make any sense. How can him trying to escape from the suitcase be the overt act? How can him trying to poke his fingers out of the suitcase be the overt act? That doesn't really make any sense. Doesn't he have the right to try to escape from the suitcase? Doesn't he have the right to try to leave the suitcase? So how can him trying to leave the suitcase be the overt act? It doesn't really make any sense. Good morning, Northwest. Snacks for all. I appreciate it. Class last night went fine. Thank you for asking. I was about 10 minutes late, but otherwise was fine. So thank you for asking. You'd like to see her own up to it on the stand and show some decency, Paul says in chat. Yeah. No. I don't think decency and this woman know each other very well. It makes sense to Sarah, and that's why she refuses to admit any other viewpoint, according to Sarah Boone's Flat Dr. Pepper. It doesn't make sense to law. It doesn't make sense to law. Like, how can me doing something I'm fully entitled to do be an overt act that threatens you? It seems odd. There's probably some hypothetical I could try to put together if I really thought about it where that could be true. There's probably some overt act where there's probably some situation where someone's completely righteous overt act nevertheless triggers a right to self-defense. But it ain't this. This one doesn't make any sense. If she hadn't recorded it, would she have gotten away with it? If she hadn't recorded it and she hadn't talked to the police, I think she'd be probably, I don't know. It's hard to say. But I think we'd be looking at a manslaughter trial at best rather than a murder trial. So I don't think they would have proposed murder. I think they would have proposed involuntary manslaughter as the top count without that evidence. They still had the evidence of him being beaten, with fresh bruising. And they had the baseball bat, so they had the weapon that did it. So they still had a circumstantial case for something, but probably not second-degree murder. You can't unintentionally self-defend yourself. Yeah, that's challenging. If she made him mad by not letting him out, isn't that provocation anyway, says Mark? Kind of, sort of, yeah. So assuming that he was going to get out and beat her ass, she arguably provoked it, which arguably precludes self-defense anyway. You can't provoke someone and then claim self-defense. So, yeah, there's that too. Wade Wilson was in Florida and had 13 jurors? No. Why 6 in this case? You have 6 jurors in any case except a capital case. In a capital case, you have a jury of 12 because it's Florida. This is not a capital case, so it's a jury of 6. In a capital case, it's a jury of 12. Because it's Florida. Now, 6-person juries are used in other states for misdemeanors. But what's really strange about Florida is they use 6-person juries for all the felonies except for capital murder. So that's really strange. So, yeah. Not every state, by the way, does. Just some states use 6-person juries for misdemeanors or other offenses, but Florida has gone the furthest version of this, so it's very weird. Yeah, 8 alternates is also weird. More alternates than there are sitting members of the jury. She shouldn't have worn black. Yeah. I feel you. Florida has some weird rules. The one that I always thought was kind of weird, and I don't know if Florida is unique in this one, but Florida is also notable in that it doesn't have a dram shop law. In most states, it is illegal for a bar to overserve a customer, but not in Florida. Not in Florida. So that's strange to me, but okay. All black because she's a grieving woman. You think it's because she's going to testify today, so we put her in black so she can grieve in all black? I don't know, man. Florida also has depositions for criminal cases. I don't know how odd that is. I don't know how odd that is. I don't know criminal procedure well enough to know how odd it is for there to be depositions for criminal cases. So yeah, I don't know how odd that is. I think I've heard about that before. It might be unusual, but I'm not sure. You'd have to double check on that one. Good morning, John Kavanaugh. Good morning, Rowan. Good morning, Burke and Mimi. Law Erie. Good morning. Good morning, Tony, of course. Our mod, who makes everything better.
Sure, on behalf of the state. William J. for the state.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
Ms. Boone, raise your right hand to be sworn, please. Do you swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Ma'am, good morning. Can you state your full name and date of birth for the record for us?
Sarah Boone, 10-10-7-7.
All right, Ms. Boone is seated at counsel's table wearing a black blazer and a dark blue blouse. She is in custody. However, she is not in any restraints, so we will continue to stand while the jury panel enters and exits. My understanding is that our panel is here this morning. State, do we have any housekeeping matters we need to address before we bring back in our panel?
Yes, sir. 3 discovery issues, and then I filed a motion late last night requesting an in-camera inquiry into a potential conflict of interest. I copied your J.
I did review the motion.
Okay. The 3 discovery issues are these. One, on October 5th or October 4th, I believe the defense was provided with the body-worn camera 911 calls from the prior incidents, and there was a request made to tell us what, if anything, should be redacted from their point of view so that we could either reach an agreement or use the court's resources to decide any conflicts in those issues. Yesterday morning was the first actual response I got from the defense team, and it was incomplete. It was about 3 of the 5 incidents. I do agree with 2 of the redactions, and we're getting those taken care of. But obviously, just like connecting to the court's screen, it takes time, and I'm not the person that's going to be doing it. Somebody else in the office has to do it. The 3rd incident, I think we're still not on the same page as to what the state's planning on introduce. So I resent the email with the screenshots of what files the state plans on introducing to the defense team again this morning. I have not heard anything yet from the defense team about the 4th and 5th incident. I was told that Attorney Beck was going to handle it. It is now Tuesday, day 7 of trial, and he has not handled it. The 2nd discovery issue is Friday, I was given a hard copy of the 119 pages of the 2nd copy of the Winter Park Advent Health records.
On 10/18? October 18th? That would have been the preceding Friday.
I was given the hard copy after court at about 5:30, 5:45. I emailed the PDF of those records back to the defense as they requested. I put Bates numbers on them. I understand from court what pages they indicated that they want to use and what pages the court indicated should be included at the state's request, which is pages 26 and 48 out of the 111. I would just appreciate if I could get a copy of the intended exhibit as it shall be introduced into court so I can confirm those things ahead of time and not in court. And then the 3rd thing is, I believe we had a discussion about the plethora of pages regarding the victims' hospital records, and that there was some sort of discussion we had that they were to narrow it down, and I have not been given any narrowed down version of that so that we can confirm we're on the same page or use the court's time if there's a conflict. Thank you.
Okay. Responses to the 1st discovery issue regarding body-worn camera and 911 calls is to the, my understanding, 5 prior incidents. Defense.
Judge, I can speak to 3 of them. There were 3 of them that I reviewed, and I believe I reviewed them on Sunday. I had made the decision for what I thought needed to be redacted. I think the first 2, if I remember correctly, I said that was fine. We didn't even have any redactions to it. I think it's 1 that I said redactions to, and I think the state agrees with that. The specific one that I didn't quite know, and I think that has to do with a body cam where it comes to, and I believe it's Mr. Torres' mother. I can't quite be for sure, but she's been asking questions and all, and I think it's about, if I can recall correctly, about Mr. Torres's whereabouts at that time. I didn't know the relevance of that at that time, but that was the only part of that, to let the state know. I just don't really know the relevance. It could come in at a different point and become relevant. But as to the other two, I think we were on page with. I had been out to the jail that day, it was late. Then I asked Mr. Beck to do the other two redactions, but I hadn't had the opportunity to talk to him about that since, so that's where we are there.
So is the third incident that the state has identified for which there's no seemingly no responses to redaction, is that the body-worn camera purportedly between law enforcement and Mr. Torres's mother?
That's what I believe it to be.
Mr. J? Bless you.
We're just not on the same page. On that third incident, which I believe was June 15th of 2019, the state only indicated to them that we were intending to introduce one video file. It is not of the victim's mother. It is of them at Sarah Boone's house. And the objection to the files that they were objecting to, which we don't seek to introduce, just said ID, and I don't know that as a legally recognized objection. So I'm confused. I'm not sure. I'm just trying to make sure we're all on the same page. We understand which file the state wants to use regarding the third incident, because he's describing files the state does not intend to use. The first couple of incidents, we agree. There's a 911 call that seemingly cuts off into an OPD call at 3 minutes and 51 seconds. We're cutting that to the end. The second one, Ms. Boone at like 3 minutes and 43 seconds indicates that she had been arrested prior. So we cut that out at their, we're going to cut that out at their, that cat's out of the bag. So what we're looking for now is just making sure we're all on the same page about the third incident. I sent screenshots. There's a tool called Snipping Tool in Windows. I literally create a rectangle around the files that I'm intending to use, their file size, and the folder that includes the OCSO agency case number incident, so we could be as crystal clear as possible. And I'm still getting objections about things we don't want to introduce on that incident, and I've gotten no response with the fourth and fifth incidents.
All right, addressing the third incident is the specific portions of the June 15, 2019 incident, seemingly the body-worn camera that you're making reference to, Mr. Henderson, the state has no intention of utilizing.
Yes, sir. And Judge, just it's a lot, so if I could have one more
Sure.
to isolate which incident it is. That's not the one. My understanding is the state is talking about the third incident. That would be June 18th.
Here's the problem. I sent these pictures over with the OCSO case number, and then I get a response based on incident dates. So we have to kind of cross-reference. So we can just make the record entirely clear. OCSO incident 18-067501. There was no 911 calls and apparently no objection. So they have no redactions requested for that 2018 case. Then the next response was 6/15/2019 case. And that, for the record, is OCSO 19-054917. Their request on that one was the 911 call that we just discussed, indicating that at 3:51, well, I had to find it, 3:51, it turns into another case, and to redact that to the end. We agreed. Video 3 in that file, again, no file name, indicates At 9:40 to 9:43, there's a redact request with paren previous arrest. The state agrees to that. We heard her quickly say that at 9:43, and we will get that taken care of. Then their next response was 6/18/2019 case, which I had to cross-reference back to show that it is OCSO 19-055572. And in that particular case, what I sent them was a screenshot that includes the OCSO case number 19-055572, and it indicates there is an intent by the state to introduce 2 911 calls and 1 video file labeled axon_flex_2_2019-06-18_1330. My response that I received from them was video 3 in file, 2 minutes 7 seconds to 2 minutes 18 seconds paren ID, and then video 4 in file, 2 minutes and 4 seconds to 2 minutes and 16 seconds paren ID. So my confusion lies in I did not indicate 3 or 4 files, it was just 1 file. And then again, with the other 2.
I don't want to address 4 and 5 yet.
Okay.
It's my understanding there's no response. We'll address that momentarily. Responses to the clarification as to what it is the state seeks for incident 3.
No redaction.
Okay, all right. With regard to incidents 4 and 5, Mr. J, could you place on the record what it is specifically as to those incidents the state may be seeking to introduce?
Yes, sir. So what we're calling incident number 4 should be OCSO 19-078009, August 28th, 2019. We indicated the desire to use axon_flex_2_video_28-08-28_2024. And then at their request, they had desired to get photos of Ms. Boone's injuries from that case. There is a 19-page PDF file, which has pictures taken by law enforcement of her injuries. I don't see anything else in there. One picture of Mr. Torres, a couple pictures of Mr. Torres, but nothing that the state was objecting to. So that was at their request that they wanted photographs in. So that is incident 4, which is labeled OCSO 19-078009.
With regard to seemingly the body-worn camera that the state seeks to enter into evidence from August 28, 2019, what say the defense?
Well, Your Honor, I don't know about the state's position on this. There's a portion of this video at the very end that's very personal to the investigating officer that they may want to redact. We're not asking anything to redact.
Is the state seeking any redactions?
I'm just clarifying what their redaction requests are in that particular file.
Okay.
If they don't have any, then
So are there any redaction requests with regard to that particular file?
No, Your Honor.
Okay. I'm just keeping notes. Give me a moment, y'all. As to the 5th incident, Mr. J.
No redaction request, Your Honor. I do want to point out that we were apparently advised yesterday that the state was only going to use the 3rd video possibly. And so we haven't really spent a whole lot of time worrying about it since then.
Let me clarify as to what the 5th incident is, just so that we're all on the same playing field.
Okay.
Judge, the 5th incident is OCSO 19-079759, and that was on September 4th of 2019. Within that screenshot that I sent to them, Friday and then resent it this morning. Was photographs of the defendant taken at that time. At their request, shows a cut in her ear. It's 3 photographs. Then there is also one body-worn camera labeled 1924755. Oh, strike that. 192473549_GEN_INV, and then the 911 call from that incident.
Any redactions sought by the defense with regard to that specific body-worn camera or 911 call?
Well, we're not necessarily seeking redactions, Your Honor. However, there are 2 separate videos. One seems to focus on Jorge Torres, one seems to focus on Ms. Boone, and there is clearly some redundancy. They're both body cams. One went upstairs where Mr. Torres was found hiding in the shower for master bath. And so some of that's redundant, but there are actually 2 separate videos pursuant to the fifth.
Mr. J, are there 1 or 2 videos that the state's seeking?
There's one, the one that I listed, found not important for her.
Okay. Do you know if that's a... Bruce, can you find out what counsel's here for? Is that the video from the perspective of, as identified by Mr. Beck, one more geared towards Ms. Boone or one more geared towards Mr. Torres?
My interpretation of both of them is there's interactions with Ms. Boone, and then there's interactions with Mr. Torres upstairs after he's located.
Okay. Mr. Beck, the specific file number was identified. So just to confirm, no redactions? Okay, all right. So just as a recap, with regard to the first incident, the 911 call, the parties have agreed to redactions at the timestamp of 351 towards the end. With regard to the second incident, body-worn camera, a redaction from timestamp 940 to 943 has been agreed to. With regard to the June 15, 2019 incident, there are 2 911 calls and 1 body-worn camera sought by the state to which the defense has no redactions. The August 28, 2019 incident for which there is no redactions to the body-worn camera, but there is a 19-page PDF with photos that the defense intends to be included with that submittal, to which the state has no objection. As to the 5th event, 3 photos of the defendant, body-worn camera, and a 911 call for which there are no redactions. Does that clarify everything for the state?
Thank you.
Is there anything that I stated incorrectly, Mr. Beck, Mr. Henderson, or Mr. Owens?
No, Your Honor.
Okay, thank you very much. Moving to the next issue with regard to the 119 pages from Winter Park. Defense, are you in a position to provide, I believe we discussed it either Friday or I think it was last week we discussed it as to how it was culled down. Yes, because we had the Richardson hearing on Friday. How that list was culled down and the additional pages that the state was seeking, and then if they were able to find, I believe it was page 68, we would readdress that. Have you provided that finalized exhibit to the defense as to those specific Winter Park health records from the 119 pages that the defense may be seeking to enter into evidence?
I believe they've received everything from us, Your Honor. We identified those documents that were not specifically addressed by the defense, that the state wanted extension out of the rule of completeness. I believe we're...
But my understanding from Mr. J was that they were looking for the tangible copy of what it is that you were actually looking to move in, those 12, 14, 15 pages. Okay, if you could provide that to them by noon, I would appreciate it.
I'm not sure it exists, Your Honor. That's what we're saying.
But if it's going to be moved into evidence, we have the, I mean, is it going to be moved in paper form, or is it going to be moved in digital by virtue of a CD?
We can get it, Judge. We'll work on it.
Okay, perfect. Just get it to the state. It doesn't have to be intangible. Just get them what it is that you're, if it's in electronic format, that's fine. Just the state should be entitled to know what it is that y'all are intending to move out of those pages just to confirm it. Lastly, with regard to hospital records of the victim, I I know there were conversations and discussions about that list being narrowed down. The state has advised that details as to those narrowed down records has not yet been provided. What say the defense?
The hospital records for the victim, Jorge Torres.
That's my understanding.
We need to do that, Judge. We've got to do that.
Okay. My understanding is that the experts are potentially teed up to testify tomorrow. I don't recall if those records are a basis of the experts' opinions.
The second expert, not
The
likely
experts are teed up to
testify
talk.
Thursday.
Experts are teed up to testify tomorrow.
In Bay County tomorrow. I will be here Thursday. I spoke with Dr. Brandon.
That's a
last
pretty
night.
big clue.
He'll be present tomorrow morning, as soon as he gets here from Coral Gables.
Did either Doctors
Will they
Brandon
actually
or
testify tomorrow?
Harper rely on those
Be
medical
allowed to
records?
testify tomorrow.
Yeah,
Tune in next
Dr.
time on
Harper did.
Dragon Ball Z.
It's in her deposition that was taken a couple of weeks ago. I think the question was posed.
We should take a
Perez.
bet on the
Good morning.
over-unders on
If
the
you're here for
experts being
pretrial, 19
allowed to
Alpha,
testify.
Judge Myers is covering.
I went up there.
Okay, thank you. You may continue.
Dr. Julie Harper, I know she considered the records of Jorge Torres, and we took Dr. Harper's deposition, I believe, a couple of weeks ago. She was asked by the state.
You wonder how Kurt would do representing Sarah? Kurt would get his ass handed to him.
That, are we going to use or attempt to introduce those records?
The problem is the state is so well
You've
prepared.
got till 5 p.m.
And
today.
I
to
don't
advise
have
the state
any
as
criminal
to what of
defense
those culled down
experience
records
worth
you're going to be
speaking of.
utilizing. So they have the opportunity to review
I'd be
those in
running
advance of
to
Dr. Harper
catch up.
testifying.
I'd get my teeth smashed
I
in.
apologize to Madam Court Reporter for speaking on top of each other.
I'd be getting my
Dr.
teeth
Brandon
smashed in.
testified as a subject matter expert who does not have specific familiarity with this case.
The
So
state would make me
there's
their
no medical
bitch.
records or any other records that he has relied upon, other than his knowledge and expertise.
Okay, all right. State, any other issues we need to address with regard to the discovery issues that you brought to the court's attention this morning?
No, sir.
Okay, all right. Moving now to the motion. I have reviewed that motion.
Judge, we were not aware of the motion until he made mention of it, so we need some time for the lawyers.
Especially this state. This state is so well organized and so efficient.
And to see whether or not it has merit
Yeah.
or not.
Okay. It was e-filed last night, looks like 9:37, and then sent courtesy copy to myself through Ms. Barrios and you, Mr. Owens, at 9:38 last night. I'll give the opportunity to review that, and we can address it after the lunch hour.
I'll tell you
That'll give the
this,
court the opportunity.
though. I'll tell you this. If Sarah Boone wanted to testify about this being self-defense, battered woman, if the state hadn't asked for it to be narrative, I'd be asking for it to be narrative. Because I'm not sure that as her lawyer, I can keep a straight face and ask the questions that I need to ask for her to give the testimony she wants to give. Putting aside whether or not supporting perjury or not, I'm not sure whether or not I could keep a straight face because it's so ridiculous. So I'd be like, you know what? I think Sarah Boone testifying in the narrative form makes a lot of sense to me, Your Honor. I'm just going to sit back here at defense table and eat popcorn while she's testifying, if that's cool with you. Yeah.
To do any research during the lunch hour on it as well. All right, anything else, Mr. J, that
I'm not, I looked at it briefly. I'm not for sure exactly what the allegation is. I don't know if we need to talk about that. So excuse me?
I'm not.
Can we approach the bench?
Sure, come on up, yo.
Yeah. Your Honor, what's your policy on us having flasks in the courtroom? Is it okay as long as I don't tell you what's inside the flask? Yeah. This is too much. On the plus side, she's so incredibly guilty that, you know, if I lost and she was found guilty, it probably wouldn't harm my reputation very much as a lawyer, even if I did get my ass handed to me. The expectations for me as a lawyer would have to be so low. So there's that going for me, right? If I were her lawyer, the expectations on me are so low that it's like, well, you did okay, Kurt. Yeah, it went all right. Man. She is too much. The criterion becomes don't make a total ass of yourself rather than any form of success. See, it just, how do we measure success? How do we measure success? A defense lawyer could very reasonably measure success as her not getting maxed out. Like anything less than her getting maxed out is a win. I won today. My client only got 40 years in jail. Wow, that's awesome. I must be the best lawyer ever. My client only got 40 years. I'm the greatest. You're the best around. No one ever gonna keep you down. You're the best around. No one ever gonna keep you down. Yeah.
All right, thank you all very much. With regard to that motion, we're going to table that for now and address it potentially this afternoon. State is advised they're ready to proceed. Mr. Jay shook his head yes. Defense, you ready to proceed? Mr. Owens, you ready to proceed, sir?
Yes.
Thank you. All right. Ms. Boone, are you still satisfied with your lawyer's representation of you in this matter?
Absolutely.
Are you still on board with the strategy that they have employed in the use of your defense?
Yes.
All right, let's go ahead and stand and bring in our panel.
Help. Help. Criminal law, I don't think really is for me. Civil law is more interesting. Criminal law is like, yeah. I'd rather talk about Chevron or talk about, you know, some sort of double jeopardy issue or talk about a Second Amendment issue. I'd rather talk, or maybe even a Fourth Amendment issue. You know, I'd much rather talk about a civil, like, even a civil rights issue rather than crim pros. You know, it's like, okay.
Jury entering.
And if Sarah Boone ever sends me a letter, if Sarah Boone ever sends me a letter, I've got a song for her too. Return to sender, address unknown, no such number, no such code.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
All right, everyone will be seated. Thank you. Members of our jury, good morning. Welcome back to 12 Alpha of the Orange County Courthouse. Thank you again for your time, your attention, and your sacrifice in this matter. Just by a show of hands, if you could confer that you complied with the court's instructions last night. The record will reflect all juror members have raised their hands. All right, State, if you could please recall Detective Kepsel.
State would call Detective Kepsel.
I don't recognize this jury. Never seen these people before. I'm pretty sure if you tried that in court, the judge would beat you to death.
Please swear or
If I ever become a judge, I just want to have like a literal mace, like a literal mace, like on the bench, as just in case of emergency break glass. You know, I will take this mate and I will beat you to death.
affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Ma'am, good morning. Again, could you state and spell your name for the record?
Yes. My name is Chelsea Kepsel, Chelsey, Koepsel.
All right. Mr. Cacciatore, you may proceed.
Your Honor, we had tendered the witness to the defense.
Okay, thank you. Mr. Henderson, you may proceed with any cross-examination.
Good luck.
Good morning, ma'am.
Good morning.
Now, it's my understanding that on February 24th of 2020, you responded to this crime scene. Is that correct?
Yes.
Were you the first officer to respond to the crime scene?
No.
So there were other officers who were there prior to you arriving. Is that correct?
Yes.
Were you the first detective to respond to the crime scene?
Myself and my partner, we all arrived at the same time because we left from the same location at the same time.
Okay, and who is your partner that day?
Detective Scott Lowen?
And throughout the whole time, you and Detective Lowen worked on this case together, is that correct?
Yes, he assisted me with this case.
Now, when you arrived on the 24th, approximately how many other officers were there?
Including like deputy sheriffs, like in uniform?
Yes, ma'am.
Yes. Approximately 4, maybe, I would assume.
Had it been designated a crime scene at that time, and had tape or security measures been taken to protect the scene?
Yes, they had.
So that had already been done by the time that you arrived, is that correct?
Yes, that's correct.
Okay. Now, in the investigation, one of your, or what you're trying to accomplish in the investigation is basically get a basics of what took place. Would you agree with me there?
Yes, I would.
All right. And you can do that one or two ways, or a combination of ways. One is to take testimony of potential witnesses, is that correct?
Yes, it is.
All right. On this day, did you in fact do that?
Yes, I did.
And one of those potential witnesses was Sarah Boone, is that correct?
Yes, it was.
And you took a statement from Sarah Boone because we've all seen it, is that correct?
Yes, we have.
And at that point in time, Ms. Boone did not have to talk to you if she didn't want to, did she?
No, she did not.
So she agreed to talk to you at that point in time?
Yes, she did.
Okay. Were there any other witnesses besides Ms. Boone that you talked to on this initial date of the 24th?
Just Brian Boone.
And Mr. Boone told you what? You had a chance to talk to him. He told you his involvement. Is that correct?
That's correct.
And in fact, wasn't Mr. Boone's testimony, was that recorded too?
I conducted an audio recording, yes.
Okay. Is that standard procedure when you do your interviews to try to record the interviews?
Yes.
What's the benefit of that?
So I know what was said.
Okay. So, and if something goes on for a long time, you can refer back to it. Is that correct?
Yes.
Okay. All right. So, and out there, that
Revelations are happening right
or
now.
potential witnesses. Okay. Also, it's your job too to identify potential physical evidence in a case.
Yes, it is.
And in fact, on the
I feel like I'm being talked down to by the defense right now. I feel like I'm being talked down to by the defense. It's like, can you tell me something I don't already know? Please. That'd be great. Thanks.
Investigator.
all right, and was Miss Melissa Rothengarten, Is that how it's pronounced? Pronounce it for me.
Rough Garden.
Rough Garden. Okay, thank you. Did she help you in that area?
She was the lead crime scene investigator, yes.
Okay. So were y'all walking around together? Give the jury an idea how that process takes place, please.
So yes, when I initially arrive on scene, I introduce myself.
I mean, I can answer this question. I've never done it before. It's like, I can answer this question. Can you tell us the standard process for what happens when you arrive on scene? Yeah, I make sure that the scene is secured, and if it's not secured, then I secure it. If it is secured, then it depends on what happens once I get there. Sometimes I need to look for things or objects, or sometimes I try to talk to people first, kind of depends. By the end, hopefully I've seen everything that needs to be seen. I've talked to everyone that needs to talk to, try to get a pretty basic idea of what happened, like you might do in an investigation. How was that answer close to what she said? I probably, okay.
There's like multiple occasions where I would have met with my crime scene investigator inside the residence.
So this is an ongoing process during that day. You get information, you consult with them, they have information, they consult with you, and you're making a determination of what potential physical evidence that y'all at least like to document by camera, correct? Or pictures.
Maybe I'll just answer all the questions.
To take away.
I'll just answer all the questions
Yes, that's
myself.
accurate.
All right. In that case,
I can answer these questions.
The suitcase was some evidence that y'all agreed on that we need to take this suitcase from the scene. Is that correct?
Yes, it was.
Okay. How about the baseball bat? Was that done that day?
The baseball bat was collected, yes.
All right. In your viewing of the suitcase, did you view the suitcase while it was unseen?
Yes, I did.
All right. Did you notice that if there was any items, other independent loose items in the suitcase?
There were, yes.
Were those items collected?
Some of them were, yes.
Who made the determination what items of that suitcase would be taken or collected and what would not be collected?
I would say that I have the final say on what is to be collected or not collected, but we do discuss it together to make that determination.
See, I like that. She takes ownership.
Final yes or no.
That's nice. I
do
like
you
that. She takes
recall
ownership as opposed to Trooper Proctor. Well, it's a team decision. It's a team decision. We come together as a team. It's like, we work together in the team. We work together as a team, but in the end, it's my call. Yeah. Thanks for just answering the question honestly. What a nice thing. Just answer that she takes ownership of it. It was my decision. Thanks. That's great.
And she decided to collect.
Jesus Christ.
Do you have the property form that I can refer to?
No, I'll try to find it.
It's so much easier when you're
Some of
just
them, but-
honest. When you're honest and you don't have to evade everything all the time. Damn.
Ma'am, I don't have it, but to the best of your memory, can you tell? And I would understand there would be some stuff that if you had the property report to refresh your memory, you can give me more detail.
Yes, to my understanding and to my recollection, we collected things that had blood left over on it. I want to say there was like a necktie potentially. I do recall there being a small amount of clothing and miscellaneous paperwork, but I do not think that we collected the paperwork. There was also a cell phone in there. It was not, it was dead, the cell phone. And then, like I said, there might be one, I think we collected 5 to 6 items from the suitcase itself, but obviously the property form would tell you specifically, but that is what I recall.
Correct, and I understand, and that's fair. Okay. So potentially you collect these items because you believe they're evidence for the case potentially, is that correct?
Yes.
And some of these items you actually collect with the potential that you might need to have them examined in greater detail, is that correct?
Yes.
An example of something like that would be in this case, if you found blood on something, you might want to potentially examine that. Is that correct?
Yes.
And also the stuff that you're learning outside of these items also helps you in making that determination. Isn't that correct?
What am I doing wrong?
I'm sorry, one more time.
Am I in Firefox?
The stuff that you learn, the information that you're getting or you're receiving.
Excuse me. I'm going to switch browsers real fast so I can boost the court audio a little bit, because I think I'd only have the booster inside of Chrome. Give me 1 second. I'm just going to switch browsers real fast. This court audio is a little soft, so I want to use Chrome to boost the audio a little bit. 1 moment, please. Talk amongst yourselves. Let's see now. Where were we?
Yes.
And some of these items you actually collect with the potential that you might need to have them examined in greater detail. Is that correct?
Yes.
Okay. An example of something like that would be in this case, if you found blood on something, you might want to potentially examine that. Is that correct?
Yes.
And
there we go.
Also, the stuff that you're learning outside of these items also helps you in making that determination. Isn't that correct?
I'm sorry, one more time.
The stuff that you learn, the information that you're getting or you're receiving about what happened at that time will lead you to determine what items might need to be collected and what items might need to be tested.
Correct.
Is that correct?
Yes.
Okay.
That's a little bit better.
All right.
A little bit cleaner for you guys.
So out of the items that were collected at the house or the apartment, at those items, was anything to your knowledge sent off for further examination?
I believe so, but if it was, there would be, they would be sent to the Florida Department of Law Enforcement for further testing.
Okay. And do you have an independent memory of what items that were collected from the house that were sent to FDLE for further examination?
I don't recall specifically without looking.
Okay. Now, are you aware at one point in time there were some fingernail clippings or fingernail swabs taken from Miss Sarah Boone? Is that correct?
Yes.
All right. In fact, that was done on her interview date, on the, would have been the 25th?
Yes, sir.
Is that correct?
Yes.
Okay, and that's what we witnessed in the video.
Yes.
That's what they were doing at that time, correct? And I'm sure at the autopsy, which you were present at, is that correct?
Yes.
And those, there would have been some fingertip swabs of Jorge Torres. Were you familiar with that?
They do swabbing of the hands, to my understanding, and clippings of his nails.
Okay. Do you have an independent memory of the fact that Sarah Boone's fingernail swabs were sent to FDLE for comparison?
I would believe so.
Okay. How about the ones from Mr. Torres? Do you have knowledge that those were sent to FDLE for comparison or identification?
Well, they would have come from him, so I'm not sure what we would have compared him to.
Okay. Were they there to see, or at least they're sent there to see if they can extract DNA?
Oh, okay, yes. I mean, I'm not sure if they did that testing for his nails clipping specifically, but it would be in the report if so.
Okay. Who would make the decision about sending his finger swabs to FDLE for comparison or evaluation?
I would request it I would request it to the crime scene investigator, and she would author the, I guess, procedure for them to do so.
Okay. And then as to Sarah Boone's swabbings, who requested that those be sent to FDLA for evaluation?
Again, I would assume that I would have done that. I would have requested the CSI to do that.
Are you aware of the results from those evaluations? I'm not asking you for the results, just if you're aware of the results.
I believe I'm aware, but would love to see a report before I specifically answer.
Yes, I'm not going to ask you a specific question
okay.
about it, okay? All right. But basically, you're aware that it was done, the procedure was done?
Yes.
The analysis was done, okay. Now, ma'am, so you're through the first day, then we get to the second day, which would have been, I believe, the 25th of February, is that correct?
Yes.
And on the 25th of February, was Mr. Torres's autopsy done at that time?
Yes, it was.
Were you present during the autopsy?
Yes, I was.
Okay. And did you communicate with the medical examiner at that time?
Yes, I did.
Okay. During the course of things, is that where you found out through the medical examiner at the autopsy that there was blunt force trauma injuries?
Yes, that is where I learned more about his injuries.
Now, initially, when you were on the scene on the 24th, did you view Mr. Torres's body?
Yes, I did.
All right. Did you notice in and of yourself on your own something that caused you concern that there might be blunt force trauma injuries?
Yes, I noticed injuries to him, yes.
Okay. So after the autopsy, you had additional information, is that correct?
Yes, I did.
Okay. Now, there was an interview, well, I don't know if it was an interview, there was a meeting set up for Sarah Boone, is that correct?
Yes.
On the 25th? Is
Yeah.
that correct?
Yes.
Can you tell me how that meeting was arranged or how that meeting was set up, please?
So either before I left the scene, the night of the incident, I obviously met with Sarah and told her that we were leaving. We had to go make next of kin notification, and I would have either at that time said I would like to meet tomorrow and arranged it then, at least to like let her know that I would like to meet after the autopsy, and then obviously from watching the video towards the end, she said something about like recalling a conversation that we had, like calling me. So there may have been a phone conversation that occurred later that evening where I either would have confirmed the time or told her the time then. I just don't have that like on an audio. But I know it either took place before I left the scene because I obviously would have, said my goodbyes and told her, hey, we're leaving, we're going to make next of kin notification. She was very concerned about that, so I would want her to know that we were doing that. So it either took place then or it took place on that phone conversation that we had.
Okay. All right. The day prior to that, on the 24th, ma'am, you received Sarah Boone's phone, is that correct?
Yes, her phone was on the scene, yes.
And when you received that phone, Sarah Boone had given you that phone, is that correct?
No, she was not allowed in the apartment to give me the phone.
I'm sorry. Did she give you permission to take the phone?
Yes.
Okay. Is that correct?
Yes, I was given permission to go through her phone, yes.
Because at that time, you hadn't applied for any type of search warrant to get or search the phone. Is that correct?
No, it was based off of consent.
Okay. So she had consented to you for you to have her phone. Is
Yes,
that correct? She also provided you the code to get in the phone. Is that correct?
yes,
So at this point in time, Ms. Boone is cooperating with you, isn't that correct?
yes.
Now, ma'am, do you recall telling her, Ms. Boone, that she could get her phone back the next day?
I don't recall specifically telling her when she would be able to get her phone back, but I did say something along the lines of we were now going to be taking the phone. I obviously had digital come out for consent to go through her phone. There was evidence on her phone that I needed to be downloaded, and at the time, I was willing to give back her phone before going through it, and then once we had gone through it and those videos were found, I felt like this was very different, and it changed my
Yeah.
perspective on
I mean, that's a
consent.
pretty good answer, right?
And I decided at that time that it was best to write a search warrant. So consent couldn't be, basically, like, I knew I was going to take her phone. So consent has to be basically given to me throughout the entire period. So she would have had no way to contact me to tell me she no longer consented. So therefore, because there was evidence on the phone, I took the phone. Basically, I potentially told her, maybe.
I like this on a procedural level. I just like the belt and suspenders approach. It's probably unnecessary, but it does make the lawyer and me happy because it's just covering the bases, and that always makes me happy. It's like now I have two arguments, right? I had consent, which was already a winner, and now you also gave me a warrant. Now I'm a very happy lawyer. So the prosecution's got to be very happy lawyers today because they're like, we got so many choices. I like this procedurally. She's very thorough. I appreciate it. It's very good.
Search warrant being received, is that correct?
Well, while I was on scene, but at the end of the day, there was evidence on the phone, so I knew I could get a search warrant to go through the phone based off there being evidence.
Yeah, it's pretty good basis. Yep.
Like the 911 calls.
Yep.
And her explaining to me that they had spoken to family members.
Please silence your cell phones.
Since they had explained to me that they spoke with family members the night prior. So I wanted to obviously corroborate her statement. So I knew that I would be able to get into the phone through a search warrant. But yes, she could have not consented, and she could have not signed the paper consenting while we were on scene.
Okay. But before you left scene, you knew that Sarah Boone was not going to get that phone back. Is that correct?
Yes, that is correct.
Okay. So when Sarah Boone called you the next day, asking you about bringing her phone back, did you just tell her, Ms. Boone, you're not getting your phone back?
There was not a conversation about her not getting her phone back. She may have inquired about her phone, and I would have explained that we will talk about it when we meet that afternoon.
Okay.
The cop may have tricked her a little bit. Dun, dun, dun.
So,
Dun, dun, dun. Just come down to the few stations.
reach out
Just
to
come
Ms.
down to
Boone
the station. A
that
few
day?
clarifying questions. No fuss, no fuss. Just a
I don't
few
recall
minor
a specific-
clarifying questions.
if
Would
she
you mind
reached out
coming
to
down to the
me
station?
The night of the 24th or before the interview on the 25th. I don't have my call records for that. I'm just basing it off of the interview where she had basically said that, yeah, I have your business card and I can contact you like I did. So my assumption would be that we did have some sort of conversation either the night of the 24th or before the interview on the 25th.
on the 20th, did you make arrangements with Sarah Boone to meet with her on the 25th?
So I either made arrangements on the 24th with her before leaving the scene, and I would have told her I would like to meet with you the next day, or I said, and I may have given her a specific time at that moment, or when we spoke later that evening on the phone, I may have confirmed the time or given her a time then. But she definitely knew that we were meeting at 3 p.m. on the 25th at Orange County Sheriff's Office Central Operations.
And ma'am, you just don't remember at what point in time you informed her, set up this meeting with her. Is that
Does it
correct?
matter?
It's
Does
one
it
or the
matter?
other
It does
that I
not
would-
really matter that much.
Okay.
Who cares?
As it to it being one or the other, you did the, you prepared the investigative
Meeting, it
report
wasn't
in
one.
this
The
case,
meeting
is that
was at
correct?
1. The meeting was
Yes,
at
I did.
5. Fine.
And the investigative report, you basically summarized everything that took place on this case, up to a certain point.
Yes,
Correct.
it was a summary, yes.
All right, as far as evidence, as far as witnesses who were talked to and synopsis of what they said to you at that time, is that correct?
Yes, things that I did specifically. It was a summary of that.
I found your investigative report to be in great detail because it helped me track this case from basically beginning
Okay.
to not to the
When
end.
the
but
defense
to the
is
point
praising your report,
where we stopped.
I don't know what we're doing
And
now.
it seems like in your investigative report, you are very thorough about details. Is that correct?
Yeah, I try to be.
I would say I'm a detailed person, yes, thank you.
Okay. So being the detailed person you are, and absolutely doing your law enforcement training, they tell you, or they train you that your report should be very much in detail. Is that correct?
Yes.
Okay.
Isn't it true you
But
left something out of your
refer
report?
back to them
I
at a
guess.
later time. Is that one of the reasons? Is that correct?
Yes, and to prepare myself for depositions and trials.
Okay, and just to give an accurate picture of what you did and what took place and what people told you. Is that correct?
Yes.
Okay. Being as thorough as you are with these contacts with people, I didn't see in the investigative report when the arrangement was made
You've
with
got to be
Sarah
fucking
Boone
with me.
to meet you down and where?
What
I'm sorry, where
a
did y'all meet?
fucking
The Orange County
question.
Sheriff's Office Central Operations.
All right, to meet you at the Orange County Sheriff's Office.
Your
I did not
reports are
see
so
that in the
detailed.
report.
It didn't
Do you
mention
have an
the exact
explanation why?
humidity outside
It's
at
not
the
typically
time.
something I would put in my report.
What phase of the moon was it? Wasn't mentioned in your report.
Do you remember in having the conversation with Ms. Boone about this meeting that was supposed to take place, that you said that you could not return the phone to her that day because you were not feeling very good? You remember telling her that?
That never happened.
Okay. Ma'am? Judge, if I could have a moment.
Yes, sir, of course.
This is, yeah. You did put in the report exactly when you scheduled the meeting. You didn't put down it was 2:30 in the morning when I called her and scheduled it for 3 in the afternoon. I guess I didn't mention it in my report. I guess that's true.
Ma'am, during
Okay.
this time
Noted.
frame, were you pregnant at this time, at that time?
Yes, I was.
Okay. All right. Well, anyway, Ms. Boone,
Well, that was a productive question.
there was a meeting arranged. Is that correct?
For the 25th at 3 p.m., yes.
Yes, and Ms. Boone showed up for that meeting.
Were you pregnant?
She did.
Yes.
Yes.
Oh,
We saw.
moving on.
Okay. Now, ma'am, I'd like to talk to you about some other investigation.
Yeah, Lord.
On witnesses, other witnesses that you took their testimony or statements, recorded statements at different times. Okay? Do you remember Abraham Marino?
Yes.
Okay. Did you take his recorded statement?
Yes, I did.
All right. At the time that you took Mr. Marino's recorded statement, was there anyone else with you?
My partner should have been with me, Detective Scott Lowen.
Excuse me?
My partner should have been with me, Detective Scott Lowen.
Okay.
This isn't going really great, by the way. I don't think I would have asked the
As to who was with
question.
you, would it help refresh your memory if you were to see your investigative report as to that interview?
Your Honor, I would object. She hasn't said that she needs any aid in refreshing her memory.
Objection sustained.
Yeah.
Ma'am, was Detective Scott Lowen with you during that interview?
Yes, I believe so.
May we approach?
Yes.
Lord, who cares? Why does it matter? Are you going anywhere with this, sir? Does it matter whether or not the other detective was there, sir? Why does it matter? What does it have to do with the price of tea in China? Why are you asking these questions? I don't understand. What are you hoping to gain from this, sir? Please explain it to me like I'm 5.
Ma'am, do you have an independent memory of Detective Scott Lowen being with you at that interview?
I believe my partner was with me on the interview. Yes, I typically wouldn't go and do some follow-up without my partner being with me.
Thank you very much. Now, ma'am, did that interview, what date did that interview take place on?
I believe the 26th, February 26th of 2020.
Okay, thank you. Ma'am, was that interview recorded?
It was audio recorded.
Was the entire interview audio recorded?
Yes, the entire interview was audio recorded.
Wow. Wow. Amazing.
Ma'am, are you familiar with a witness by the name of Brandon Motes?
Yes, I am.
On February the 27th of 2020, did you interview Brandon Motes?
I believe so. It was either the 26th or 27th, yes.
Do you have any relevant questions, counselor?
If you were to see your investigative report, would that help refresh your memory?
All right, I would again object. She hasn't indicated that she needs assistance with her memory.
Approach.
Who cares? Why does it matter? Where are we going? What are we trying to accomplish? This woman's face is me right about now. This woman's face is me right about now.
Objection sustained.
Yep. Okay. What are we doing? Why am I here? What's happening? I feel you. I feel you, woman.
Ma'am,
I
if
feel
it was
you.
the 27th, you would not disagree with that, would you?
Well, I just stated that it was either the 26th or 27th.
Okay, thank you.
Does it matter? Is it important? Why does it
Ma'am,
matter?
Mr. Motes, he was the neighbor living in the apartment, or the connecting apartment, wall apartment, with Ms. Boone and Mr. Torres, is that correct?
Yes.
And he's the one who told you about the loud noise, is that correct?
Yes.
Okay. Did you interview anyone else in reference to that loud noise?
So I was interviewing Brandon, and then my partner was interviewing Vincent, the other witness, and I came in at the end of the interview with Detective Lowen.
Okay, so that's Vincent. Do you know his last name?
I would butcher it.
Me too, but Tagalilo, something like that. We're talking about the same person?
Yes, sir.
Okay. And did that interview take place on February the 27th of 2020?
I believe so. I interviewed witnesses after I interviewed Sarah. The 26th or 27th would be my memory.
Okay, thank you. And then, did he also talk to you about a loud noise?
I believe that I was refreshed on the conversation, and yes, he expressed hearing a loud noise as well.
Okay, thank you. Now, and those interviews were actually audio recorded too, is that correct?
Yes, they were.
Okay. Now let's go to Ms. Boone's interview. And that would have took place on the 25th, is that correct?
Yes.
Okay. And Ms. Boone came down, and ma'am, prior to Ms. Boone coming down for the interview, had y'all made the decision that Ms. Boone was going to be arrested?
Yes, I plan to arrest Sarah Boone.
Okay.
Wow. Great. Moving on.
Did you tell Ms. Boone in arranging the meeting that when she came down there, she was going to be arrested?
Your Honor, I'm going to object this to relevance.
Approach.
No. No, we probably didn't mention that one. Nope. 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 Police probably didn't tell her that if she came down, they were going to arrest her. Why do you think the police might not tell her that? Why do you think the police might not tell her, hey, when you come down, we're planning on arrest you? Why do you think the police might not necessarily mention that piece of information? Anyone have any guesses why they might not mention it? Oh, Lord. Yeah. No, I didn't tell her that I was going to arrest her. Because that would be extremely counterproductive. And if you ask me why, I'm going to ask you, can you think of any reasons why? Can you imagine any reasons why it might be counterproductive? I know you can do it. I believe in you.
Objection's overruled.
So, ma'am, at that time, you did not tell Ms. Boone prior to coming down there that she was going to be arrested. Is that correct?
No, I did not.
Okay. Why did you not tell Ms. Boone that she was going to be arrested?
You've got to be fucking kidding me. Why did you not tell her? Why the fuck do you think?
We plan to meet at 3 p.m. and go over the autopsy and have another interview. So, I mean, I'm not sure why I would tell her that she's going to be arrested. That would potentially cause her to flee.
Yeah.
You know, not come.
Wow.
And then we have to go find her. and
Wow,
make it more
yeah,
difficult
that
for
sounds
her.
like a pretty good answer. Wow, amazing. If we told her, hey, when you come down, we're planning on arresting you, she might not come down. She might try to flee. Wow, what a revelation. Amazing.
Or potentially get an attorney to come with her.
She was read her rights that said that she has a right to an attorney, and if one cannot be provided for her, she will be appointed one.
I understand that. You read her those rights when she got there, is that correct?
Yes, I did.
You didn't read those rights to her before she got there, though, did she?
I wasn't in contact with her, like physical contact with her.
Okay. So, but you said potentially for fleeing. My question was, potentially she could have got an attorney too to come with her. Is that not correct?
I misunderstood your question. I didn't hear.
She could have gotten an attorney to come down with her in any event, by the way. You can always have an attorney come with you. If the police want you to come down, bringing an attorney with you, assuming that you're going to go, seems like a really good idea. You know? So you could just call an attorney. Oh, Lord.
Potentially bring an attorney with her, but yes, I guess she could have potentially brought an attorney with her.
This is painful to me.
So Ms. Boone shows up, and you tell her that some things.
And really, I mean, in this situation, if you don't know that you need an attorney, I don't know what to tell you. Like, even if somehow you were perfectly innocent, I'm not sure what scenario this is, but somehow you were perfectly innocent. Your boyfriend just wound up in a suitcase without your knowledge, and you discovered him the next day, and you are the person who found the body. Okay? If you don't know that you should call an attorney, I don't know what to tell you. You're too dumb to live.
Things that we need to talk about. Is that correct?
It's specific verbiage. I know I said something along the lines of, obviously the autopsy had been conducted, and there were things that we needed to talk about in regards to that.
And prior to discussing it with her and asking her questions, you did read her Miranda warnings. Is that correct?
Prior to, I'm sorry, one more time?
Before you started asking her questions, though, in this interview, before you started asking Ms. Boone's questions, you read her Miranda warnings. Is that correct?
Yes, before I started asking any sort of potentially incriminating questions, she was read her Miranda warnings, yes.
Okay.
Which we saw on tape, by the way. We saw you do it.
Do you remember, as part of the Miranda warnings that you read to Ms. Boone, did you read her the one that states that if you decide to answer questions but want to stop answering and consult with an attorney, you may do so? Do you independently remember reading Ms. Boone that instruction?
I don't recall that specific, but I do have my Miranda card on me, but I don't recall that that's what that says. But it is on audio and video recording.
Okay, thank you.
You're welcome.
Now, ma'am, at that point in time, Ms. Boone wasn't under arrest. Is that correct?
That's correct.
Ms. Boone was not going to be free to leave once she was in my custody.
That's
At that
a
point in
bad
time,
answer.
Had you told Ms. Boone
That's
that
a
she
bad
was
answer.
not free to leave?
No, I did not.
At
At
so
that
she
point in
wasn't
time,
under
had
arrest.
you told Ms. Boone that she was under arrest?
I told her at the end of the interview.
Yeah,
Okay,
right.
Before the interview.
No, I did not tell her before the interview.
Right. So she
ma'am,
wasn't under arrest yet, which is better for you, the government, by the
Why didn't
way.
you tell her before the interview?
Your Honor, I'm going to object.
That's
It's been asked
dumb.
and answered.
Overruled.
So I have to read her Miranda warnings, and that's what I did. I do not have to tell her that she is under arrest at that time.
Was there a
Right.
reason?
Correct.
Could you have told her that she was under arrest before me reading her Miranda warning?
Your Honor, I'm
suppose I
going to
could have.
object as it calls for speculation.
Sustained.
Why would I do that? Why would I tell her
Ma'am,
she's
was
under
it a
arrest?
strategic decision not to
Objection.
tell Ms. Boone that she
Thank you
was
for the
under
10 pounds.
arrest
Appreciate it.
prior to reading her those Miranda warnings?
Your Honor, I'm going to object as to relevance.
Approach.
Yeah. Why? This is a dumb question. You know the answer to this question. You in chat know the answer to this question. Why didn't the police tell her that she was at arrest at the start of the interview? You know the answer to the question because she might have stopped talking. So they're not going to tell you because they don't have to. They're not going to tell you. They don't have to because if they did, you might stop talking. So they're not going to tell you. They're going to wait and tell you later. Surprise. So this is some bullshit. It's like, yeah. Thank you very much for the 10 pounds, Daniela. That's very nice of you. I appreciate it. I appreciate everyone who supports the channel. I appreciate everyone who helps to donate to the channel financially. You make it very possible for me to continue doing this. Your support is, of course, extensively appreciated. We have 492 viewers in chat. If we get up to 500, I'm going to give some memberships myself. So we're just 8 viewers away. Well, now we're 12 members away. Some people clicked off. But if we get to 500 viewers, I will donate some gift memberships myself. And I do appreciate you being here today and spending some time with me. Oh, I'm sorry, I had to pause that whole time. I thought I was wondering what's happening. I had to pause the whole time. I was confused.
Ma'am, and we were able to see the video of the interview. As a process of interviewing people such as Ms. Boone, or let me specifically. In the process of interviewing Ms. Boone, is law enforcement free to give information that might not be accurate or true during the interview process?
Yes, we're allowed to lie.
Are you asking if we're allowed to lie to her?
Yes.
Yes, to an extent.
Yes, that's true. And to an extent is correct. There are limits.
Was that done at any time in this interview?
Did I lie to her? I don't recall lying to her, no.
Police are allowed to lie.
Yes,
There
sir.
are some rules. There are some boundaries. But, you know, they can't lie about the law. And basically, the other boundary is basically they can't shock the conscience. Is the other boundary. They can't
Thank you,
do
ma'am. I
things
have
that
no
shock the
further
conscience. Oh, that was a really productive cross. Good
Need
job.
redirect examination.
Brilliant.
No, Your Honor.
Good job.
Can this witness be released? State.
We have her subject to recall.
Okay.
Subject to recall.
All right, ma'am, you're released subject to recall. Thank you.
Great, thank you.
State any other witnesses, evidence, or testimony to be produced?
Your Honor, at this time, the state would rest.
Okay. Members of the jury,
Booyah.
it is 10:22
Booyah.
a.m. I have some
I
matters
love
with
this.
counsel that I need to address. So we're going to excuse you for a short while. It's a great opportunity for us to take our morning break as well.
I love
Similar
this.
instruction that I've given to
I'm
you over
falling
the
in
last
love
couple
with
of
this
days.
prosecution
Please do not
more and
discuss
more.
this case amongst
I'm
yourselves
falling
or
in love
anyone
with this
else.
prosecution
Do not
more and
conduct
more.
any independent research or investigation as to the person, places, things, or charge involved in this case.
This is so
We'll bring you back
efficient
in
and
as
so
promptly as
tight
possible.
and so
Thank you.
no nonsense.
Jury exiting.
It's glorious. Plus, it's also strategically well crafted. They know exactly what they're doing, and they put it together in a strategic way. And they're backloading this. They're end loading the whole thing, which is fine. And also probably for the better, all things considered. I love this prosecution. It might be my favorite prosecution in recent memory.
Go ahead, be seated. Thank you. Defense, any motions?
Judge, we do have some motions, but my client needs a.
Would you like to move for a directed verdict? Would you like to move for a judgment of acquittal?
Let's go ahead and take that break. Court's going to be in recess.
Would you like to move for a judgment of acquittal right about now? They didn't prove their case.
Any motion practice at that point in time.
You want to do that?
Off the record.
That'd be good. All right, good. All right. So we're stretching. We're stretching. All right. Good times. We hit 500. Excellent. I only see 4. Oh, no, we did hit 500 viewers. Okay, so I have to give you guys some gift memberships. No problem. So let me figure out how to actually do that. Let me give you some gift memberships because you guys are the best. Let's see. Okay. So okay. Do this. Super stickers, super chat. I don't think I can actually gift memberships from my main account. So I have to log into my alternate account and gift from there. That's fine. I'll do that. Let's go into my alternate account. I wonder if I can gift from my shorts account. That'd be cool. I'm not sure. I've never tried. Let's find out. Alternate account and gift from there. Let's see. It would be a good way to promote the brand. I cannot gift from my shorts account. Lame. All right, so I have to gift from my alt account. All right, let's see. There we go. Membership gifting. Okay. All right. Thank you all for being part of the channel, and thank you all for being with me. I do appreciate it, of course, as always. Thank you for the 476 of you who are currently here and spending some time with me. So the state's case was done with great efficiency. The state's case was done with great strategic flow. It was done with, in retrospect, it was done with, the interesting thing was the really slow burn is an interesting choice. But I think they did the really slow burn because they wanted to end load basically all the really good stuff. So they were going for the pure recency and not so much on primacy. But I think you kind of, I don't know, that might be a bit of a mistake. I don't know. I'd have to really think it out because you definitely want to make sure that you have the jury's connection, and you also want to have the jury's focus and their interest and their emotional investment right from the start. So I think perhaps it's a slight error, but I do like the way that they end-loaded all the evidence and they end-loaded all the video in particular. And I like the way that they basically ended with Sarah Boone's confession. And I think that this last witness was a very, very good choice to end with Sarah Boone's confession. I really like that strategically. So I'm trying to think what I could move around that would be better. Maybe if I could present this physical suitcase like first, maybe that would be the way to go. Maybe if I get that witness, then present the physical suitcase first as the place where he died. So I introduce the murder weapon first. Maybe that's the way to go. And then I go back to a sequential order. So because, although it did have the benefit of what's in the box being there for a long time. So like, what is this mysterious box? And that mystery. So there's that element too. So maybe that was even correct. I don't know. I'd have to really think about what I can move around to have a more front-loaded focus. I'm not sure. But it was good. And then the defense's questions are like, don't go anywhere. And then, of course, by ending with Sarah Boone, the next witness is Sarah Boone. So it has that great flow as well. So that's nice. So, yeah. So we do appreciate you being part of it. I think they're going to get into a lot on rebuttal. Yeah, the case is a slam dunk. How could you go wrong with it? You can always fuck it up. The state, you can always fuck it up. You can fuck up a slam dunk too. You can absolutely fuck it up. But these people did not fuck it up. These people ran an incredibly tight ship. They basically did it in 2 days. You know, there was a little bit of carryover to this morning. Well, actually, it was all cross that was carried over. So it wasn't even due to the state. So the state finished their case in 2 days. They finished it in 2 days. I mean, that's pretty damn efficient. And I'm here for it. I'm here for it. Pretty easy when the facts and evidence are so heavy and damning. And not only the crime, but the suspect implicating themselves was all on video. This is a fair point, Lisa. This is a fair point. They had the fact that they had the video of the murder basically happening, taken by the defendant. The defendant basically videoed themselves doing the murder. You know, that's not everything that every prosecution normally gets. That's definitely an abnormal thing for the prosecution to get. But yeah, and the confession, which is not that atypical, is always nice too. So yeah. While you were not a fan of the interrogation techniques, I was certainly impressed with the testimony skills of the detective. I thought the interrogation worked fine. I mean, you know, there's different ways to go about it, but, you know, it was effective. It was effective. It allowed Sarah Boone to be Sarah Boone. And what more do you want from an interrogation than that? So, although I think Sarah Boone is irrepressible. So, I could have done the interrogation and probably gotten similar results. So, yeah, they expect to wrap up the case this week. Yeah, that seems like that's where this is going. Yeah, we'll give the case to the jury on Friday. They'll convict her on Friday. And then at some point we'll have sentencing and she'll get, what do we think? 30 years? 40 years? Life? I don't think she's getting the minimum, guys. I don't think she's getting the minimum. Deliberation will be about 7 minutes. We all hope it will be about 7 minutes. Yeah. She's a woman, so probation? Nah. I don't think so. This woman is cold. I don't think she gets to play the woman card. I think she gets to play ice cold murderer card. Now, do you think the defense can actually make the motion for a judgment of acquittal right now with a straight face? That would be tough. I don't know what, yeah. That'd be tough. Your Honor, I move for a judgment of acquittal. The state has obviously failed to make its prima facie case, and no reasonable jury could possibly convict on this evidence. Is the judge allowed to take into account that she didn't take the plea? No, not explicitly, no. No trial tax. So they're not allowed to explicitly take it into consideration. But judges probably do take it into consideration, but they won't tell you that. So yeah, there is. I think more to the point though, it's her total lack of remorse, her total lack of care, her total lack of any consideration whatsoever that of whatever's going on. So yeah. Women get harsher sentences historically? No, they don't. What history have you been reading? Women absolutely do not get harsher sentences. Women get lighter sentences. They tricked me and it wasn't intentional. I don't even know why I'm here. Yeah. panel thought it was poor because at one point the male interview went across Sarah giving access to his gun. I missed that. Yeah, you probably shouldn't do that. You probably shouldn't make it so that the person has access to your gun. That's a bad pool. Is the defense allowed to wait with judgment of acquittal till after Sarah's testimony? Sure, but you typically make the motion. You typically make the motion at the end of the state's case, and then you make the motion. You may usually make the motion a couple times. You make the motion at the end of the state's case. You make the motion at the end of the evidence completely, and then when they're convicted, you ask for a judgment of acquittal. Then, although at that point it's called a JNOV, so you usually ask for it like 3 times. It's typical. So, but I don't know how you make the motion with a straight face in this situation. So, you hate the state and even you might go vote guilty. She is incredibly guilty. She is all the guilty. She is so incredibly guilty. She is evil incarnate. She is evil incarnate. She has committed a fundamental evil. In fact, in Latin, they'd call it malum in se, as opposed to malum prohibitum. Malum in se are those category of crimes that are inherently wrong. Murder being a pretty good example. It's like we don't need a statute, malum prohibitum. We don't need a statute that says murder's bad. Murder's bad. We don't need a statute. In fact, murder, of course, is illegal at common law and defined by common law. And I might be mistaken on this, and Natalie, the lawyer chick, at some time might school me, but I believe that typical murder in Maryland is not statutory. Now, Maryland does have capital murder, although they don't have the death penalty anymore, but they have capital murder on the books, right? Even though they don't have the death penalty, but the category of murder is on the books. But I think it's true that, and Natalie would correct me because she would know, but I think it's true that like a second degree murder is not on the books. I think it's still common law in Maryland. So, we don't need a statute. It's just inherently wrong. So, yeah. Have I tried Claritin Ready tabs? I've never heard of those before. I've been using Nasacort recently, and that's been helpful. But I will take a look at the Claritin Ready tabs. I've never heard of that before. What's the difference between that and normal Claritin? It's the same thing. It just dissolves in your mouth, melts in your mouth, as opposed to taking it by pill. Okay. But I've been taking Nasacort recently, and that's been helping. I know a certain chat thread that might disagree with you. Okay, well, people are allowed to have a different opinion on me as long as that opinion is well informed and has a basis in reason. So if they can make a reason to argument why they disagree with me, then, I'm happy to hear it. Fast absorption? Okay, fair enough. But I've been taking Nasacort for like the last 10 days, and that's been helping a lot. The sinus issues are definitely less pronounced. Gets in the system faster and you don't need water to take it. Okay, I'll look into it. What would I advise her if she didn't speak with detectives and I pointed to her case? Well, she had never talked to detectives. she would almost certainly being charged with a lesser crime. If she's being charged with anything at all, she'd probably be charged with, well, because the evidence of the baseball bat, right, would be the problem, which suggests that he was beaten at some time. So you're looking much more like a manslaughter case. I don't know what I'd recommend, because it would change the posture so much that it would change the entire way of framing the entire thing.
We're back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. Appearances for the state.
Yes, sure, on behalf of the state. William J. for the state.
Defense.
James Owens for Ms. Boone. Tony Henderson.
Tony Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
Do we have any motions?
We do, Your Honor.
You may proceed.
If I may approach podium, Your Honor.
Yes, sir.
You know, at this time, the defense would move for a judgment acquittal.
There you go.
I'm going to start with just a real quick couple of comments, Your Honor. We know that JOA motions have become essentially pro forma, which may be why I've been assigned this responsibility today. But in this instance, I want to make an argument that I think has some merit.
Okay. Sell me.
I've been paying close attention to the testimony in this case. And I want to point a couple things out. First of all, we know that the court has essentially has assumed the role and is assigned the role of becoming a gatekeeper in this matter. We know from the testimony that's been presented in this matter that not only did law enforcement, but also the Office of the State Attorney had knowledge of these parties prior to the event having occurred. And despite that, the state has proceeded with this prosecution based upon a criminal information as opposed to having taken it to the grand jury. That kind of places the court in a special position to evaluate the nature of the evidence that's been presented. I want to focus on the second-degree murder allegation. And one thing that occurred to me while watching the evidence as it was presented, watching the videos, particularly of the interrogation, was part of the dialogue between Ms. Boone as well as Detective Scott Lowen at the end of the interrogation. And I'm going to paraphrase. I apologize. I should have written this down verbatim. I did not. But she's advised that she is being placed under arrest. Something to that effect. And her response is, "Why are you doing this?" The detective's response to Ms. Boone is, "Because George is dead."
I'm sorry.
Because George is dead. That's not enough. It's not enough to support a second-degree murder.
Wow.
Prosecution, conviction, or should it even be enough to allow this matter to go to the jury?
Wow.
Now, there are three elements of the second-degree murder information. The first is that the victim is dead, that Mr. Torres is dead. We stipulated to his identity. There has been no argument to the fact or the idea that he died in this incident. However, the state also has to show that it was caused by a criminal act and that the act was imminently dangerous and demonstrated a depraved mind. Now, the fact that it was imminently dangerous, I think, is belied by the fact that Jorge Torres voluntarily entered the suitcase, albeit under the influence of alcohol. But the perception of dangerousness that's attributable to the victim, apparently he did not perceive it to be a dangerous or an imminently dangerous situation in having entered the suitcase, possibly because of the influence of alcohol on his capacity to make decisions.
Yeah, there were some other things that happened after that, though.
But I also want to focus on the depravity issue, which the state must prove, and pursuant to the jury instruction in this matter, depravity is is made the equivalent of ill will, hatred, spite, or evil intent. And that's not enough. Not only does the state have to show depravity, but it has to show, because it's in the conjunctive, that the act demonstrates an indifference to human life.
I think you're there.
The state has presented testimony and argument in this matter, not argument, but testimony that in fact George Torres was suffering. Suffering does not equal hatred. It does not equal ill will. And
I don't know,
even
she
if they
said
were to
F you a
establish
lot.
negligence, that's not homicidal. We know that
This is too funny.
suffering.
I mean, I have to say this. I do appreciate that he's able to say this with a straight face. I don't know where he gets it from. Maybe he's just been doing this so long he's dead inside. Maybe he's just resolved himself. But I do appreciate that he's apparently able to say this with a straight face. This is amazing. This is amazing.
Is something that the courts have been very, very cognizant of and very sensitive to. We know it from the field of capital punishment and incarceration. The idea that somebody suffers is not in and of itself homicidal, nor should it support the idea that there was indifference to the life of George Torres.
In and of
by
itself,
Sarah
you're
Boone.
correct. That's true.
Was she angry? I think there's clear evidence that she was angry. But that's not hatred. And that's the element that has to be proven here. And I don't think that there is a prima facie case that, in fact, she demonstrated hatred so much as she demonstrated anger. Doesn't establish a prima facie case of second-degree murder. It's for those reasons, Your Honor, that I think that this matter should be, the motion for JOA as to second-degree murder should be granted.
Big balls on
And
this guy.
matter should be allowed to proceed solely on a
This guy's my
manslaughter
hero.
charge, because, in fact, they have not established prima facie elements as required by law. Thank you, Your Honor.
Thank you. Response.
Yes, thank you.
Do we have to respond, Your Honor? Do we have to actually say? Do we actually have to?
Standard this time is just a prima facie case, whether any trier of fact in taking all the facts in the light most favorable to the state and the inferences drawn from them establish the elements of the crime. There are 3 elements to this crime. George Torres is dead has been established by a prima facie case. The death was caused by the criminal act of Sarah Boone that has been established. There was an unlawful killing of George Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. It's not Ms. Boone's subjective statements on February 25th. I had no idea you could die from being zipped into a suitcase for 13, 15 minutes before she goes to bed. 2, is done from ill will, hatred, spite, or an evil intent. We heard what she said. The 2-minute video starting at 11:12 p.m., 45 seconds, should be linked in Merriam-Webster's digital dictionary for the definition of depraved mind.
I like that answer. That's very good. It should be linked in the dictionary.
I
That's
don't
good.
care.
Very much.
Laughing.
Very nice. 10 out of 10.
Is of such a nature that the act itself indicates an indifference to human life. Sarah, that's my name, don't wear it out. Judge, there's no question that a prima facie case has been laid. In addition to the 2-minute video and then the 22-second video 11 minutes later, we also have the defendant's inconsistent statements that she has made in regards to these events. And therefore, we have that factual issue for the jury to decide. She made statements on the 911 call and to law enforcement, both on the 24th and 25th, that I have no idea what happened. I just went to sleep, everything was good. And then when confronted with her video on the 25th, we see that there are 2 distinctly different sets of statements that were made. So this is sufficient at this stage in time for a jury question. Thank you.
Thank you. Any other additional argument, Mr. Beck?
No, Your Honor.
All right, thank you. Thank you both for your arguments. The court, in viewing the light most favorable to the state, the court finds that the state has presented competent but rebuttal evidence to establish each of the elements of the charge contained in the information to the required level of a prima facie showing. As such, the defense's motion for a judgment of acquittal is denied. Defense, do you intend on putting on a case?
Yes.
Ms. Boone, I have a couple of questions to go over with you.
Judge, if I may.
Yes, sir.
In a normal criminal trial, my position has always been to put on the defendant last.
Yeah, but we already know you can't do that.
Put on the photographs, and then the client would be the last person to testify. Because of the nature of this charge and our defense, self-defense and battered spouse, we understand that we have to put on her first, Sarah first, for the court to then consider whether or not we've established enough evidence for self-defense instruction. So she's going to have to be going first as the witness. I'm going to need a few moments with her based on everything that's going on and based on that denial of that motion for judgment of acquittal.
Really? You need a few minutes based on that?
Just go through it again because I know you're going to ask to colloquy about all that. So I'm going to need a few moments with her. I don't know if it's 10 minutes maybe for the 4 lawyers to meet with her. I don't know if we can do it here or maybe back there, but just a short meeting.
Sure, I'll give you that opportunity, but before you do that, ma'am, I don't want to go into any specifics of any conversations that you've had with any of your attorneys in this case. Mr. Owens has identified for the court his normal practice of calling a defendant last in a criminal case. In this case, he has advised that he wants to call you first. Without going into any discussions of any strategy that you've had with your attorneys, do you understand the strategy that Mr. Owens and your team will be utilizing in your defense?
Yes.
And are you in agreement with that strategy?
Yes.
All right. Counselor, you can have that opportunity to speak to her. The court will remain here. I don't know if they can, Officer Jones, can we let them back to have that conversation? Okay. All right. You can go back and have that conversation. The court will remain here. We'll be in a short recess for approximately 10 minutes. Thank you.
Yeah, you have that 10-minute come to Jesus meeting. You have that 10-minute come to Jesus meeting. I don't know what you're going to say to her. If you haven't been able to convince her at this point, I don't know what you're going to say to her. Good luck. That motion for a judgment of acquittal, 10 out of 10. Slow clap. 10 out of 10. Best motion for judgment of acquittal ever made from the bench. The greatest motion for acquittal I've ever seen in my life. 10 out of 10. Outstanding. Very good. Wow. Wow. So they're going to have a 10-minute, I don't know, come to Jesus meeting or something. And I don't know what they're going to try to tell her for 10 minutes, but, you know, good luck. And, you know, if it were me, I'd be trying to tell her, you are fucked. That'd be lit. It's like, as your one of my roles as counselor is to tell you how fucked you are. Oh, Lord. Okay, yeah. So you're going to get up there and say some bullshit, and the judge is probably going to deny our defense completely after you've testified, and probably not allow any of our other witnesses on the stand because the defense won't be allowed, because that seems to be the direction things are going. And then I'm going to have to pretend to be all surprised Pikachu face about it when the judge says, oh, your defense is denied and you can't call any other witnesses. Oh, my God. Surprise Pikachu. I didn't see that coming, Your Honor. I'm totally surprised. I had no idea that you deny us our defense. This is a travesty. We're entitled to offer any plausible defense, Your Honor. I can't believe you're denying our defense. This is a total shot out of left field. It's a bridge of all that's good and holy. And, you know, all right. And then, you know, then I guess I get to tell the Court of Appeals all about it. Should be exciting for them, I'm sure. They can call other witnesses, not just self-defense battered spouse ones. I suppose that's true in principle, but what other witnesses do they have beyond that? So sure, yes, it's true in principle. They could call witnesses that could provide a testimony that would not speak to a battered spouse or, or self-defense. That's true. They could call those witnesses. But who are they? Who are they? What do they have to say? They don't exist. So sure, they can call the non-battered spouse defense witnesses. I'm sure we look forward to that long, long list of potential witnesses. Should be really informative. I'm sure they've got 30 witnesses that have nothing to do with battered spouse that we're going to hear from. Defense tried to get the charges lowered. The state offered them manslaughter. The state offered manslaughter. That's a pretty good deal, man. You would have been out in like 6 years. That was a pretty decent deal. I don't think there's really much of a deal left on the table. If there is a deal on the table, it's like, how about you plead? The only deal that I could imagine the state offering at this point would be a sentence recommendation. How about you plead to top counts and we'll agree to recommend 30 years. But the judge can still sentence you to whatever they want. It's just a recommendation. But that would be the only deal I could imagine the state doing at this point. If they're even willing to do that. If they're even willing to give a recommendation at this point. It would probably be a pretty big number. So, yeah. Yeah, she doesn't have any that aren't abuse witnesses. She can't do character witnesses because she can't impugn the character of the victim unless she can offer a battered spouse, right? So she can't offer character witness in the naked abstract. She can only do it because battered spouse, but if she's denied the defense, she can't offer character evidence. She can't offer expert testimony. So she's got nothing. She's got no defense. She's got no defense. So, except of course, the always residual defense of the state, you should find not guilty because we believe in proof beyond a reasonable doubt. Right? The last defense, ladies and gentlemen of the jury. At the start of this trial, you promised to believe in innocent until proven guilty. It is the forestone of our country. It is the backbone of everything great and right we believe in, because we all understand the great and mighty power of the state. And if you don't hold them to that burden, you could be next. Proof beyond a reasonable doubt is proof of an absolute moral certainty. And while the state might have given some shade and some light, credibility issues, there's nothing in this case approaching beyond reasonable doubt. The only just verdict is not guilty. Thank you. Thank you, members of the jury. Can I please go home now? That's all you have left. That's all you have left. The last defense. The last defense is all you have left. Good luck. A conviction in this case would be a travesty. It'd be a travesty. Blah, 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 blah. And then, of course, is the state. My entire rebuttal close might literally be just the video of him begging for his life. That would be the ultimate mic drop moment as the state. My entire rebuttal close is literally just pressing play. Sarah, shh. Thank you. Mic drop. Yeah, that's probably how I'd play that as the state. Just play the video. I've got nothing else to say, man. Got nothing else to say. Yep. Good times. Gwendolyn in chat says, I think she can I believe she believes she can actually convince the jury of her innocence. She's been waiting for this moment to prove how right she is for 4 years. It was unintentional. Uh-huh. Well, you know, stranger things have happened, I guess. Maybe all 6 members of the jury fell off a turnip truck today. You know, I hear the turnip truck problem in Florida is very real. Maybe all 6 members of the jury fell off a turnip truck today. I don't know. So we'll see. Yeah, not malicious. This testimony, guys, I don't know. Should I get a cocktail? It's 10 in the morning. It's 10 in the morning. I think it's too early for a cocktail. I don't know though, but it's like, if you choose to drink, I respect your choice. This testimony is going to be a thing to behold. This is going to be surely the greatest testimony of this year. It's going to be infuriating. It's going to be very unintentionally hilarious. I may break out in laughter at several points because of how absurd it is. It's going to be the most gaslighting ever in the history of time. This is going to be gaslighting on levels. This is going to be gaslighting on levels, baby. Oof. Get a mimosa. I don't have any orange juice, nor do I actually have any champagne at the moment. But a mimosa actually does sound pretty good, to be honest. I'm not going to lie. She might outdo Amber. She's absolutely going to outdo Amber. I have no doubt in my mind. She's going to outdo Amber. I have no doubt in my mind. Yeah. 100%. 100%. By the end of this video, we'll probably be saying to ourselves, you know, Amber Heard, she wasn't that bad. That's how I think this is going to end. That's how I think this is going to end. By the end of the day, we're going to be saying, you know, Amber Heard, she wasn't that bad after all. She was all right. Yeah, that sounds about like where this is going. Yeah. Amber Heard did not kill anybody. That's a very fair point. So that's true. Amber Heard did not kill anybody. That's true. Amber Heard confuses the difference between donate and pledge. Sarah Boone confuses the difference between intentional and guilty. They are not the same. They are not the same. Yeah. Sarah Boone is potty trained to the best of our knowledge. Although, if our knowledge is incomplete at this point, it wouldn't completely surprise me. You think, Sarah, have you thought about throwing yourself on the mercy of the court and showing contrition? Have you thought about showing some kind of contrition? If she doesn't at least attempt to offer contrition, although I'm not sure that she can, like literally, I don't think she's capable of it. But if she doesn't at least attempt to show some sort of contrition about the fact he's dead on the stand, I'm actually not sure what's worse at this point. I'm actually not sure if it's worse if she does it or if she doesn't do it. Because if she doesn't do it, she's all the monster that we know. But if she tries to, she's going to fail so hard. But I think you've got to try to show some sort of feeling that this person is dead. Even if you think you're justified. It's like, this is a human being. Even if it was him or me. Some sort of something in your soul that is damaged by the fact you've taken a life on some level, even if you're justified. I mean, this person is dead. That's not great. Now, maybe it's necessary, but they were a human being too. So I'm not sure how I prep her to show contrition though. Because if she tries to cry on the stand or something, if she tries to cry on the stand or invoke tears, I don't see how that's going to work. Not well. Yeah. You would think there'd be some part of her, if she was human, which, kind of is the problem, I think. But if she were human, you would think there would be some sort of problem or some sort of part of her that would be like, another person is dead. That is sad. Now, maybe they needed killing. But, I couldn't say for sure because I've obviously never been in the situation. And, God willing, I never will be. But I imagine that if I took somebody's life, even if it were self-defense, even if somehow it was not my fault, but I was somehow involved, right? Even if it wasn't my fault legally, but I was somehow involved, I imagine that would, mess me up a little bit inside. Even if I did it because the person was a threat to me, I imagine it might be a bit traumatic. I don't know. Maybe I wouldn't feel that way. Maybe I'd feel just lucky to be alive. Maybe I wouldn't feel that way at all. Maybe I'm wrong. But, I would think I'd feel something. I have margaritas I could make. Oh, we've got 509 people in chat. Okay, I think it's time for another gift memberships. I think it's time for some more gift memberships. Here's some more gift memberships. Courtesy of me, Blackleaf, which is also me. Thank you for being part of the channel. Dear Florida, we were both drunk. I thought he was joking. I fell asleep. I'm sorry. That might have been, I think that's still her, I think that's her best hope. That's the best hope you have, really. But that requires contrition. I'm not saying it would work, especially like, we had been through a lot. There had been a lot of problems in our relationship. And, I said some things because I was frustrated and angry, but I didn't really realize that he was in so much distress. I thought it was just him. I was too drunk. I just too whatever. I'm really sorry this all happened. That's the best version. That's the best story you've got. Now, the problem with that story is, the tape and, the police interview and, everything else that's happened. But that's the best story you've got. Somehow try to sell the jury on that, despite every evidence to the contrary. Who do you believe me? Who do you believe, me or your lying eyes? Right? That's all you've got. It won't work, but it's all you've got. But of course, it requires you to show contrition. And that you're actually sorry. And you feel like dirt. Because you're, yeah. So, yeah. It's a better story. It's a better story than self-defense, which I don't even know. When the judge inevitably, because I think the odds are pretty high. The judge is not going to allow the defense. So it's like, I've now completely exposed my client. She's now gotten on the stand and said everything she's going to say. Plus, she's now going to be denied the defense based on what she said. So, like, I've just basically bought the worst possible ticket as a defense lawyer that's possible to buy. My client has gone on the stand and testified and said all the things they've said, and now she doesn't have any defense. This is not a good situation to be in as a defense lawyer. And it's like, but I can't make it. I can't. What's the overt act? Him trying to escape from the suitcase? How does that make any sense? How does that make any sense? Especially when he isn't saying things like, I'm going to kill you. If you don't let me out, I'm going to. He wasn't threatening her. And even if he was, incidentally, I'm not sure it would do it, but at least it would be something. But he wasn't threatening her. He was just begging for his life and trying to escape and trying to survive. I hate this woman so very much. I hate this woman on levels that are hard to fully appreciate.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State, appearances for the record.
Dave Kester on behalf of the state. William J. for the state.
Defense?
James Owens from Ms. Boone.
Tony Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
Ms. Boone is seated at counsel's table wearing the same black blazer and dark blue blouse from this morning. She is in custody, however, not wearing any restraints, so she'll be able to stand when our jury enters, and if she is called to testify in this matter, she will be able to walk to the witness stand. Ms. Boone, I have a couple of questions to go over with you. Similarly to our conversations earlier today, I don't want to know about any of the substance of any conversations you've had with your attorneys, just whether or not you've had certain conversations. So far, you've been present throughout the entire trial process. You've been seated at counsel's table. You've had the opportunity to observe the evidence presented by the state, as well as the direct and cross-examination of the state's witnesses. Are you satisfied with your attorney up and until this point?
Yes.
Now, I'm going to ask you some questions again about specific conferences and conversations you have with your attorneys. I don't want to know those specifics, just whether or not those things have been had. Have you had the opportunity to discuss with your attorneys whether or not you would like to testify as a witness in this case?
Yes.
Do you need any additional time to discuss that matter with your attorneys?
No.
Have your attorneys discussed with you the potential benefits and potential harms of testifying as a witness in this case?
Yes.
Are you satisfied with the advice from your counsels?
Yes.
Do you understand that attorneys can make most of the decisions about trial strategy? They cannot determine whether or not a defendant testifies or not. Do you understand that?
Yes.
Not even the court can interfere with the defendant's right to make that decision. Do you understand that?
Yes.
Do you understand that it is your decision and your decision alone?
Yes.
While counsel can give you advice on whether or not it would be wise for you to testify in this case, do you understand that you can ignore counsel's advice because the final decision is yours?
Yes.
Do you understand that you have the right to remain silent?
Yes.
Did you hear me explain to the jury at the beginning of the trial how the right to remain silent is absolute, and the fact that a defendant did not testify cannot be considered as evidence of guilt or influence their verdict in any way?
Yes.
Before a jury begins its deliberations, the court will read another jury instruction if you decide not to testify. This instruction orders the jury not to consider your silence as evidence of guilt or to consider your decision at all. Would you like me to read that instruction for you at this time?
Yes.
It is instruction 3.9a, entitled Defendant Not Testifying. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that a defendant did or did not take the witness stand to give testimony in the case. Do you have any questions about this instruction?
No, Your Honor.
Do you understand that if you choose to testify, you are waiving your right to remain silent?
Yes.
That means once you begin to answer questions, you have to answer all questions unless I instruct you not to answer a question. Do you understand that?
Yes.
You cannot pick and choose which questions you want to answer and not answer. Do you understand that?
Yes.
Do you understand that if you refuse to answer any questions, the court can impose sanctions, such as holding you in contempt, striking your entire testimony, and instructing the jury not to consider any of your testimony? Do you understand that?
Yes.
If you choose to testify, you will also be subject to cross-examination and impeachment. That means the state could ask you about any prior felony convictions or convictions for crimes of dishonesty if you have any such convictions. If you have any such convictions, the questions will be limited to whether you have such convictions and the number of same. Do you understand that?
Yes.
Are you aware if you have any such convictions?
Yes.
State? Are you aware of any felony convictions or convictions for crimes of dishonesty?
No, I believe she's answering in the affirmative. She's aware that she doesn't.
Okay, so you have no such convictions. Okay, thank you for that clarifications, ma'am. As there are no convictions, and that number is not in dispute, the state will not be permitted to inquire into those matters. Have you had enough time to discuss your decision to testify or not testify with your attorneys?
Yes.
Again, do you need any additional time?
No.
Has anyone forced you, threatened you to get you to testify or not testify?
I think
in
the
this
judge
case?
is. I think the judge is very much. I want to get
Has
this on the
anyone made any
record.
promises to you to get
I think
you
the
to
judge is
testify
very,
or
very
not
much. I want
testify
to get
in
this on the
case?
record.
No.
Yeah.
Are you satisfied with your counsel's advice so far in this case?
Yes.
Are you making
Wow.
this decision freely and voluntarily?
I am.
Did anyone force you, threaten you, or coerce you to testify in this case?
No.
Would you like to testify or not testify as a witness in this case?
Testify.
Okay. And ma'am, similarly, after you've had the opportunity to converse with your lawyers again, I want to confirm that you're on board with the strategy that they've utilized in your defense in this case,
Yes, I understand.
including calling you first.
Yes.
Okay, all right. I want to remind you, ma'am, that you can change your mind. You just have to let your lawyers know before the jury comes back in. Do you understand?
Yes.
State, anything else we need to address?
Just that the law of the case is that there should be testimony from the defendant of an overt act that particular day before there is testimony about reputation evidence, prior instances of violence, or any of the ancillary things that come with self-defense.
Holland case speaks for itself. Anything further?
I do want to talk about that, but as it relates to her right to remain silent or testify, I have nothing about that.
Okay. Then what do we need to address with regard to Holland?
Well, I've got three issues. One is Holland. The other is I've got these gloves. My client and I would like to take a few moments to look at the suitcase and to look at the bat. And then the third thing is that the state had filed that motion for the in-camera hearing. I don't know. Maybe we need to hear that before she testifies.
The court's not going to address that at this time.
Okay.
We'll address that later in the proceedings.
So the two things, number one, of course, I've got a lot of photographs about the prior violence that Jorge Torres committed on Sarah Boone, and there's a dispute about whether or not I have to establish an overt act that
You
she
absolutely do.
responded to, that she considered an imminent threat, and that she took evidence, or she took action to either block or physically restrain Jorge Torres from committing an act of violence on her. But Judge, if you'll remember, during the 2-hour interrogation, the officers make mention that they are aware of the prior incidences of violence. So I believe the door has been open, that I can go into that based on those statements by the two detectives.
Bullshit.
If you remember, they introduced this 2-hour video. She says, he comes at me all the time. I think eventually Sarah Boone realized that they had her phone and they were going to see pictures, they were going to see videotapes of evidence that Jorge Torres committed acts of violence on Sarah Boone. I think at that point she changed her tone about Jorge. She was trying to protect Jorge, but then she realized she would have to disclose some of the acts that had been committed on her by Jorge Torres, and so she did talk about him coming at me, and we've had issues before, and the officers gave, I can't remember exactly what they said, but yeah, we're well aware of, I don't know if they said the prior acts or we're aware of the domestic violence, whatever the case may be. I submit that opens the door. That was during their case in chief.
You
They
wish
chose to
it
play
opens
that
the
entire
door.
video.
You wish
So
it
I
opens the
think
door.
I can talk about the prior bad acts
Bullshit.
before the event in question chronologically, and I've got a bunch of photographs that go into physical evidence of her injuries as a result of George's.
Absolutely. You can't bootstrap this.
violence.
You're trying to use your client's own
Response,
statements
if any.
to
Judge,
bootstrap
we're asking
this?
The court to maintain its ruling.
Wow.
We already read an instruction.
Balls.
We're allowed to tell her things to try and get reactions from her. She affirmatively denied there was an overt act that night to the police. And the court, in its ruling pre-trial, I'm trying to get some guidance on this.
Oh no, as a judge, I'm absolutely shoving this Holland case right up her ass.
Overt act.
Directly up her
Testified to.
ass.
So we are hopeful that we will maintain that.
100%.
ruling. I don't know how it prejudices her or her team in any way to establish an overt act on February 23rd, 2020 before we go into reputation evidence, prior instances of violence, or battered spouse income evidence.
Any other further argument, Mr. Owens? All right. I don't find that the officer's statements are character evidence, and you're looking for specific instances of conduct, which are going to be utilized for those specific purposes for reputation or violence to establish the fear component that the case law speaks about. Florida Supreme Court decision in Holland is clear that that overt act needs to be established before any of that evidence is submitted. I don't find that it's an opening of the door.
You tell
I'm
him.
going to rely on what the Florida Supreme Court has told us.
Yeah, you shove that case right up the defense's ass.
Judge,
100%.
I've got to get the clerk to mark some photographs, and then my client and I need to take that suitcase out of that box and
To what end?
inspect it, play with the zipper a little bit, and then
You want to play
also
with the
take
zipper?
that bat out of that.
Do you want to get
paper
inside
bag
the
and
suitcase?
Inspect it.
If you want to get inside the suitcase, I think the court could
Any
arrange it.
response?
I'm just confused why we haven't utilized the nearly half an hour or more that the court has been off the bench to get these photographs marked. The defense team has been on board for quite some time. They did not request a second evidence view of the physical evidence that Ms. Boone already had an opportunity to do while she was pro se. It's 11:25. we need to try the case.
Judge, I think that she had that evidence view, I think, with Billy Lane. I believe that was the day after I filed my notice of appearance, or maybe it was the
She
day
wants
I
to see the
filed my notice of
suitcase. She wants to
appearance. I
play
don't
with the
remember
zippers.
Exactly, but it had already been previously scheduled. I was in Milton, so they went ahead and did it that morning, I believe at the jail. I believe the evidence,
Any particular reason why it hasn't been done in the last 45 minutes?
because
When I sent my jury out?
I've been meeting with my client about
Okay.
her rights to testify or not, and other related matters. So in terms of not giving her this evidence,
In terms of anything that the state just discussed?
I've just been busy with my client.
Okay. How much time do you need in order to pre-mark these exhibits and look at the baseball bat and the suitcase which have been entered into evidence?
I would think 15 minutes.
I'm very concerned because it is 11:25 and I discharged our jury some time ago, and I don't want to be in a position where we have to break in the middle of testimony.
May I
Go to
suggest
lunch.
that we just take an early lunch? It's 11:30. Let's take an early lunch. We've got witnesses coming this afternoon anyway. If her testimony ends before 5, we've got 1 or 2 witnesses that are here, and then I believe tomorrow is Wednesday. We've got Dr. Brannon that's going to be here first thing Wednesday morning, and then I believe Dr. Harper's not going to be here till Thursday morning. So we're going to have a little gap in time unless we've got to put on several officers about prior acts and all that. But I think for purposes of this, Judge, in the abundance of caution, I feel like I need to go over this evidence with my client before she testifies, and I have not had a chance to view that evidence other than seeing it here today, but I think I need to do that with her before she testifies.
Okay, can the parties approach for a moment?
I think he's going to get a slight tongue lashing right now. I think the judge is a little bit irritated. But I think they're going to get their early lunch because that makes logical sense. It makes logical sense to bring it on, do the lunch now, and then come back earlier. And that gives them time to play with the suitcase and mark the thing and have whatever last minute come to Jesus meetings they need to have with their client or whatever else it is they need to do. So yeah, they'll probably get their early lunch, I would imagine. So we might have to wait till after lunch for the grand reveal. She comes out. She comes out like the star she is onto the stage. It is a mess. Yeah, it is a mess. Also, to be slightly fair to the defense, obviously, these lawyers have had this for a very short time. So they've had to. Now, they did buy the ticket. So there's that. But still, we can show a little bit of compassion because this is a lot. They've had to get done. They've had to get prepped for a murder case in 2.5 months. That's a lot. Now they do have like 20 plus years experience, so that's got to help, but still. So, we can give them a little bit of a break. We can show them a little bit of kindness. And plus, they also have Sarah Boone as a client. And, that's got to be worth something. So. The jury gets snacks. The jury does get snacks, I think. Yes. I think they get coffee at least. And they might have a donut back there or something. I'm not sure. But I think the jury does get snacks. Yeah. Knew what they were walking into? I mean, yeah, fair. But still, we can have a little bit of mercy. A little bit of mercy on them. Just remember, guys, the lawyer is not the client. Okay, the lawyer is not the client. So your feelings of Sarah Boone should not necessarily radiate onto their attorneys. So we can have a little bit of mercy. Oh, we got a nice little shot of the audience. Do we see anybody we recognize there? pink blazers a lot. That is a very pink blazer, man. Damn. I didn't know you could buy blazers that color. Shit. Notorious. Notorious. Jules. She's the notorious. Notorious. Jules. No, I think it's going to be, I think we do need a full Broadway introduction. We need a full, who was that? Mark and Warnstein or something like that, who was famous for those like really theatrical Broadway plays. We need like the old school light bulbs, you know, that they had like around the marquee, you know, the really big ones that, you know, like those old fashioned dressing rooms. We need those like really big light bulbs. And we need, you know, some grand staircases. Rodgers and Hammerstein, was that who I was going for in that analogy? It might have been. Rodgers and Hammerstein. Was that who I was going for? Rodgers and Hammerstein? Okay. Rodgers and Hammerstein then. Yeah. I thought it was Mark for some reason. But Roger and Hammerstein sounds right. Yeah. We'll go with Roger and Hammerstein. Yeah. So some really Bernstein. Yeah. I think maybe I got some names confused in there. I did my best. I have failed you. I am sorry. We have tested the limits of my theater knowledge. Yeah. Maybe she'll get cold feet. No way. She's committed. She's 100% committed. Not a chance. She's taking that stand. This is you. Maybe we can get Trey Parker and Matt Stone to do it. They did really good with the Book of Mormon. I saw it once in Baltimore. It was very good. Hello, my name is Sarah Boone. I'm very happy to meet you. Or how do I Sarah Boone, who would have thought the bastard daughter of an orphan? I can't do it. Sarah Boone. It's not working. I'm trying. This is Sarah Boone land and we live in it? Yeah, 100%, yeah. Do they still make Lifetime movies? This is a great Lifetime movie. This is a fantastic Lifetime movie. This is a great one, yeah. Let's talk about plays we like. I always like the play 1776. Very Americana. I liked, I very much liked,
It is 11:35. Councils have matters that they need to address with Madam Clerk for the pre-marking of exhibits and along with the review of the suitcase and bat which were previously entered into evidence. I'm going to bring based on the agreement of the parties, I'm going to bring our jury panel in at this time, release them for lunch, give them a similar instruction to the instructions they've been provided earlier, and we will commence promptly at 1 o'clock this afternoon. State, any disagreement with the battle plan so far?
No, sir.
Same question, Mr. Robbins. All right, let's go ahead and stand back, bring back in our panel.
I never saw Phantom, but I'd like to see Phantom on the offer. I never saw Phantom. I always wanted to see Avenue Q, but I missed that one. So I've seen like excerpts of it on, but I've never actually seen Avenue Q in theater. I don't think they're even performing it anymore, which is sad for me. The producers, I've seen the movie version of, both of them. So I'd love to see that. And Chicago, the movie, I think is great. I love Chicago. It's a great musical. So I'd absolutely see that in the theater. That'd be badass.
Jury entering.
Singing in the Rain? Singing in the Rain's pretty cool. I like it. I liked when David Elsewhere
State, do you recognize our jury?
did
Do you recognize our
a
jury?
reinterpretation
Thank
of
you. All
that
can be
movie
seated.
for a Volkswagen commercial.
Members of the jury, again, once you're seated and comfortable, if you
He did
could raise
popping
your
and
hands
locking,
to
singing in the
confirm that
rain.
you complied with the court's instructions.
It was pretty cool.
All right, thank you very much. Thank you for your patience. Matters with counsel took a little bit longer than we anticipated. We're going to take an earlier break today. It's 11:35. We anticipate the defense putting on a case this afternoon, and we don't want to get into it and then have to break a half an hour into it. So we're going to go ahead and take that break at this time. I'm going to give you a similar instruction as I've read to you over the last couple of days. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors, do not watch local news or read local newspapers. Jurors must not have any discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, I thank you for your time and your service and your attentiveness, and we'll see you at 1 o'clock this afternoon. Thank you.
Jury exiting.
1 o'clock is going to be the grand moment for Sarah Boone. 1 p.m. Star of the show. 1 p.m. It's going to be glorious. And since it's afternoon, I may have a drink in my hand. We'll see.
Y'all may be seated. Thank you. State and the defense, if you could please review those items and please mark every defense exhibit at this time with Madam Clerk, and I will see you all to commence promptly at 1 p.m. Court's in recess. Thank you.
Cool. Fun. Neat. Oh, we should absolutely see if Jules wants to pop on. All right, I'm going to send Jules a message, see if she can pop on. Hold on. All right, I'm gonna send her a message, see if she can pop on. Let's see. Okay, where is her thing? All right. Okay. Would love to hear from you. You should be able to call this number. Okay, great. So Jules may or may not pick up the phone. We'll see. We'll see how it goes. We'll give Jules a minute to see if she wants to join us. That'd be cool. Great. Jules. Yeah. I look forward to hearing her discussion of the last couple days from a person who was actually down there. Little Shop of Horrors? Ooh, that's a classic. Little Shop of Horrors, that's an old school kind of classic at this point, man. Rocky Horror Picture Show, I refuse to see. I absolutely refuse to see it. Yeah, based on every description I've ever had of it, based on every description I ever had of its fan base, no interest. Spam-A-Lot? Spam-A-Lot could be cool. Jules had tea yesterday. Ooh, maybe she can share some of the tea with us. That'd be good. Theoretically, if she calls me, it should pick up on my computer. We'll see. Feed me, Seymour, feed me. You know it. You better believe it. Newsies? Did I ever see Newsies? I might have seen... Was there a movie version of Newsies? Or something? Is it possible I saw it on TV? If so, I might have seen it. Rocky is not me? Yeah, that's what I've been saying. It is not my cup of tea. She says that she has other people to call first, so we might have to wait a hot minute. So we'll vamp for a while. We can talk theater. There was a movie, Newsies. I might have seen it. If not, then maybe I need to see it again. Pippin? Never saw Pippin. Not familiar with it. Never saw West Side Story. No. Sounds fun. Grease? I've seen Grease. Yes. You're the one that I want. One that I want. Hoo, hoo, hoo. I'd like to be in a theatrical production. I definitely, I think would like to do some sort of community theater. I think that would be fun. I would definitely like to do some sort of theater. And maybe I can go to Broadway and maybe I can be a star. I don't want lunch. I'm gonna wait for Jules. See if Jules calls. Did I see Book of Mormon? I did see Book of Mormon. It was great. Yeah, I saw it in Baltimore. It was fantastic. I very much enjoyed it. They should make a musical called Jury Selection. Sarah Boone, the musical. I don't know if my my songwriting talents are good enough for that. Maybe I'll stage my own theatrical production. Sarah Boone, the musical. We could write some, we could write some numbers together. The chat and I could write some numbers together. It could become a thing. Or LawTube, the musical. Oh, Lord. Nutcracker. I've definitely seen Nutcracker. Don't really care for it personally, to be honest. Hedwig, I've never seen. 12 Angry Men musical could be fun. I'd like to see Legally Blonde, the musical. Blood in the water. Do, 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 do. Do, 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 do. Do, 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 do. We got Blood in the water. Da, 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 da. Chorus line. Law tube the drama. That's right. Would Rakita be in Law Tube the musical? I mean, he'd have to be, right? I mean, he'd have to be. He's a pretty key part of Law Tube, for better or worse. For better or worse. Rakita the musical. I don't know that I have much of a songwriting talent. We could do some tap. Be good. Yeah. Right now you're working on a country music parody about the clunker of a car. Every light on the dash is on. Neat. Sounds great. Harry Potter and the Cursed Child. Yeah, I don't know much about that as a musical. There's a ballet of Alice in Wonderland? That sounds promising. That sounds promising. Snort, the Rakita musical? Yeah. What's the status with Rakita? No particular status right now. There's a settlement conference that was scheduled by the court. I believe it's the day before Thanksgiving. So I believe there's a settlement conference and or a hearing in the court on the day before Thanksgiving, wherein he'll be given some opportunity to plead guilty, or I assume at that point it'll be calendared for trial. So I think that's the day before Thanksgiving. So I don't think there's any information beyond that at this time. We shall see how it all pans out. Moulin Rouge. I did love the movie. Moulin Rouge. It was an interesting movie, for sure. Different, but I liked it. Improv was great. Thank you for asking. Improv is great. We've unfortunately had a lot of attrition in my class. So for the next level, we're going to have to merge with a new class because our class is now too small. But, we've had a lot of attrition. So, which is unusual for improv. I've never really been in a class where there's been this much attrition before. But, it happens, I guess. So we're going to have to merge in with a new class. But we had a great time. Yesterday, we learned about doing walk-ons or walk-ins, whichever way it's rephrased. So, you have a 2-character scene and then someone comes on to the scene, to add something and then leaves. So we learned about walk-ons yesterday. And the time before we learned about the straight versus absurd dichotomy. How to play the straight role, how to play the absurd role in a straight or absurd world, as the case may be. And the overall theme we're supposed to be learning is game. And I still don't really completely understand what it is. The game, as far as I can find, is the funny. So it's a riff off of the funny, as far as I can understand it. So it's like having a variation on a theme, being the funny. But I don't really completely understand it yet. I don't really completely internalize it yet. So I'm not quite sure exactly what it is, but that's my current working assumption of what it is. The charges against Rakita are the same they've always been, as far as I'm aware. Second-degree possession, child endangerment by the fact that children were present at a place where drugs were present, and illegal possession of a firearm by a person of a controlled substance. So it's the same charges they've always been, as far as I'm aware. Isn't there an improv rule about not saying no? Yes and is one of the classic rules of improv. You say yes and you build it on. You accept the premise and you build it. Is a classic rule of improv. So yeah, not denying what your scene partner has said is a pretty common rule. It's like, yeah, we're a bad example. Like, we're out at a beach. No, we're not. We're at a club. It's like, no, it's like we're at a beach. Now we can be at a club at the beach, but you don't like deny my premise, right? And that could be the funny, actually. It could be the funny, right? It's like, oh, we're on the beach. Yeah, who would have ever thought they would set out a nightclub in the middle of the beach, right in the middle of the open? It's a strange place to put a club. That could be the funny. You know? It's like, yeah, man. I mean, the DJ was spinning their songs and they kept getting interrupted because the waves kept crashing down on them, kept messing with the records. You know, that could be the funny. But you don't deny what your scene premise gives. Okay. She says she's calling me. All right, hold on. So we may have to stop riffing. Let's see if it actually rings. Please ring. Okay. Please ring, or I'll have to call you back. Come on. Come on. Ring. Ring. Oh, shit, she tried calling me. I'll call her back. You aren't set up to get calls on the web. Oh. Oh, okay. I need to change the microphone. Why am I not answering? I'm not answering because I'm having problems, Jules. I'm having issues. Hold on, I'm working on it. Hey, what's up?
Kurt.
Hold on, Jules. I'm working on it.
Hello.
Jules, it's Kurt. Jules, it's Kurt. How's it going? Hey, Jules.
Okay, I got you.
All right, great. That worked. Yay. How are you doing, Jules?
Oh my God, Kurt, you missed it.
Did I?
Yes, you missed it. Okay, I got to stay in the courtroom after the judge left the bench. All right, ladies, hear this. So Sarah puts on the gloves. Mr. Owens puts on the gloves. They all pull the suitcase out of the box. I thought this was all being filmed, okay? I did not know that the cameras were off because since we were still in there, I thought Court TV was still filming, but no, apparently not. In any case, Mr. Owens started asking Mr. James, where is all the paperwork and the evidence that was in this suitcase? And Mr. J, this is really personal with this guy. He does not like Mr. Owens whatsoever, and he showed his true colors today. He picked up the box, turned it upside down, and shook it, and then threw it on the floor and said, "There's your evidence."
Love it. Love it.
And then we all were like, and after we did that, Mr. J turned around and told the deputies he wanted everybody to be escorted out of the courtroom, that nobody was allowed in there. And I have a legal question for you.
Sure.
Was he allowed? Aren't we allowed to watch them view the evidence?
I don't know the answer to that question, strictly speaking. I mean, I don't know the answer to that question. Because it's not, I don't know that necessarily that would have to be being done in open court in the first place. Because production of evidence and discovery, which I imagine this would fall into, would normally be done in a private setting or a secluded setting. I mean, the prosecution talked about the opportunity to view evidence, and they didn't do a second viewing. So there was an opportunity to view evidence. So I don't know if there's any particular right for people to view it, even if it's happening in the courtroom. That might just be the location. So I don't know.
Oh, boy. Okay, so what questions do you have for me?
I have so many questions. First of all, everyone wants to know about what happened yesterday.
With the lady, the lady that got thrown out?
Yeah.
Okay. She came in the courtroom. This was before we were on the record. And she sat down in the last row on the defense side. And all of a sudden, she starts yelling, "Where are my readers? I need readers. I can't read without my readers." I mean, she's yelling this in the courtroom. So one of the deputies told her that she had to be quiet. And in the meantime, people literally are looking to see where these readers are. And I don't really think that they ever existed. So she was quiet. Then they brought in Sarah. And as they brought in Sarah, she belted out, "Oh, this is Sarah Boone's child." And again, this was before the judge took the bench. So, she was spoken to again, and then the judge took the bench, and they immediately called for a sidebar, and it was to discuss this woman's presence in the courtroom. And then you heard what the judge said, and he was directing, the Judge Kranick is so cool. He's so nice. So he was talking to basically he was making it sound like he was talking to everybody in the gallery, but he clearly had his eyes on her. And then he said, "And if you're wearing sunglasses, you must remove them." That was her. She had sunglasses on. So she took off the sunglasses, and she was like, "Oh, sorry," So she started saying other stuff. Then the next thing you know, they're back at sidebar. And then after that, the judge went to go have her removed. And instead of leaving out, and she was right next to the courtroom door, but instead of going out the door, she starts to walk up the aisle preaching about Jesus.
What? No. I'm sorry. You just laid that on me. You gotta take a step back, and you gotta describe this in a little bit more detail. What is happening now?
Okay. After the second sidebar over her, the judge told her she had to leave. He asked her to leave the room, and she come out the aisle. And when she come out the aisle, the door to exit is right there. But instead of turning and leaving the courtroom, she started to walk up the aisle towards the judge, she was walking up the aisle, and she started preaching about Jesus and how we're all going to be saved, and how we all have to stick together, and then, she gave everybody a blessing, and the deputies walked her out.
Wow.
Yeah.
Wow. I guess I missed that. I guess I didn't quite hear what was happening in the courtroom, because I heard her saying stuff, but I couldn't quite hear what she was saying. I guess I missed that it was a blessing from Jesus. Holy shit.
Yeah.
Wow.
Yeah.
That's a lot.
It was wild.
And what was the jury's reaction to the suitcase evidence when they saw the video of the suitcase and the Shim saying, how was the jury reacting to that?
A male juror and a female juror that sit in the front row, the one on the end that sits closest to Sarah, and then 4 jurors down is the male. They visibly were affected. I saw the grimace on their faces, and the male was shaking its head, not vigorously, but back and forth, wow. Everyone was taking notes during that, and Sarah did not look at the jury, and she didn't look at the video either. She just stared straight ahead.
Yeah. I mean, it had been a long time since I'd seen that video. It's probably been, I don't even know, 2 years since I seen that video. And so for me, it was almost like watching it for the first time. And I think actually, I don't know if it was during that video. It might have been. I might have actually laughed because of how comically evil it was. It's like, it's so over the top that it's hard to believe it's real.
Yeah, I know, but it's very real. And when you see the suitcase in person,
that's so small. Even on camera, it looks small as hell.
And in person, it looks small. Now, I was only 10 feet at the most from this suitcase, okay? I was right there. Because once I got the heads up from Mr. Owens yesterday, and I just want everybody to know, I did not approach anyone. I was approached by them. They sought me out. So in any case, he gave me the heads up yesterday morning that Sarah was going to be testifying today. So normally I sit on the prosecution side because it gives me the view of a good view of Sarah and what she's doing and the entire jury. But because I knew she was going to be testifying today, I sat on the defense side and I was directly behind Sarah. So this way I can still see the jury, but I will be able to see Sarah full face while she's on the stand. So I'm at the ball, you know the railing? I'm there. I'm like right at the railing. And so when they were doing this thing with the suitcase, I literally was at the most 10 feet from this suitcase. I still am befuddled how he fit into that suitcase. I can't figure it out.
I mean, apparently he was a really small guy. I mean, 100 something, like 100, like 5 or something.
He was 103 pounds, 5 foot tall.
That's really small for a guy. 103 pounds for a guy is incredibly small.
Yeah, it is. But still.
Yeah.
Yeah, it's crazy. It's crazy.
What was it like when that suitcase first came out of the box?
They were craning their necks, like looking, like, yeah. Well, we all were, but the jurors were very intent on looking at it, and they were taking notes.
Is anyone from his family in the gallery? Or where are they sitting, and what are they reacting to?
There is a family advocate in there, and some of the younger members of his family, I think they're like nieces and nephews and stuff, but his parents have not been in there. Now, I don't know if they're going to be in there this afternoon or not. I will definitely tweet that out if they are, but no, his parents have not been in, and his brother Juan has not been in since he testified either. But the ones that are in there, it's only 2 or 3 at a time, and I would say their age range could be anywhere from 18 to maybe mid-20s. So I think that these might be nieces and nephews, or it could be his kids. I don't know. I was going to ask the victim advocate, and then I thought better of it that, yeah, I didn't want to do that.
Yeah, that makes sense. Yeah, there was a brief shot of the gallery, so I was wondering if it would be anyone that I would have recognized based on what they were wearing.
I can't remember, but they're young. They're probably the youngest ones you'll see in the gallery on the prosecution side. Second row, the second row in.
Okay. So what do you think has been the overall affect of the jury during this trial? Because it's been incredibly, for my money, it's been just incredibly efficient prosecution. There's been basically no wasted time, no extra fat, which I kind of like, to be honest. But I'm curious, what do you think the jury's reaction overall has been to the state's presentation?
Early on, there was no reaction, like very little note-taking. I've heard people complaining on Twitter and on other channels about Why wasn't the prosecution? Why didn't the prosecution bring on like the medical examiner and like why didn't they start there? And here's the thing. I don't know if you agree with me. I feel like the prosecution has put on a very tight case and a very tight timeline. Yeah, and they started with 24 hours prior to the actual.
Yeah. My only real criticism was I thought they started a little slow, because you want to ideally have some sort of thing that gets the jury really emotionally invested right from the start. And their first couple witnesses were kind of just background characters that didn't really do anything. But I was having a difficult time trying to figure out like what I would have moved like earlier in order to try to try to have a little bit more punch right from the start. I was having a real difficult time trying to figure out what they could do different, because I was like, well, maybe they could have opened the suitcase right away. But the fact that they didn't, and the fact that that box is sitting there the whole time, and like what's in the box becoming like a point is like, well, that's something I'd be losing. So I'm not sure I want to do that. And I was like, I don't know what I can move. So the state's presentation might have been optimal. So I don't know.
Well, I liked it because I felt like they were showing a definite timeline on what led up to with what happened, and the fact that they asked specific questions and did not leave any room for a door to be open, which gave Mr. Henderson no room really for an effective cross. Excuse me. And
no, the cross has not really gone anywhere, and I imagine the jury hasn't been, super reactive to anything the defense has been trying to put out, have they?
No, because of the fact, in my opinion, and you could correct me if I'm wrong, no doors were opened up where they could explore. Like they couldn't talk to Brian Boone about Sarah and his relationship, because there was Brian said that she was physical with him, but the prosecution didn't open that door, so the defense couldn't cross him on that. So it was very tight, but we're going to see what happens now with the defense. I mean, and I did ask, I know because people are saying, because Mr. J brought it up in the beginning of trial, that Sarah has changed her story so many times that there's no way that she could be questioned, that she's going to have to, if she decides to take the stand, that she's going to have to do it in a narrative form, because no attorney would knowingly allow her to commit perjury.
Yeah.
Which, of course, we all know that's true. However, I don't know what this means, but this is the question I asked this morning. I went to Mr. Henderson, and I said, Mr. Henderson, can you please tell me, when Sarah takes the stand, will it be you or Mr. Owens doing direct? His answer was, Mr. Owens. That suggests to me she's not doing a narrative, and he will be asking her questions.
It's possible. The rules of ethics on this, in terms of like what an attorney can do, differ a lot on state to state, and it depends a lot on like what the attorney like actually knows. And so in some states it's actually quite narrow in terms of what the defense lawyer can't do. Like in some states they'd have to like have actual, like basically personal knowledge that they're lying. Otherwise it doesn't count. So, but that's not necessarily every state. So it may well be the case in Florida that he can do this without it being an ethical violation. It would depend on exactly how they interpret the rule. So if he chooses to do it, and it's like, I mean, obviously he has a problem because some version of it's a lie and he doesn't know which one, but as long as he doesn't know this to be a lie, and the only way he would know it to be a lie would be because she told him, right? And it's like, I'm planning on lying on the stand, or otherwise something like that. So if it winds up not being narrative, then I wouldn't be surprised. I was I gave a slow clap 10 out of 10 for his motion for judgment of acquittal, because I was like, I can't believe he's doing this with a straight face. But hey, that's why you're a professional, man.
Yeah, and but that's standard procedure. We all know that.
Yeah, fair enough. People are asking about the pink blazer in court, so they won't let me go unless I ask about the pink blazer.
The pink blazer.
There was a woman on the front row with a pink blazer in the gallery.
Oh, I have no idea.
Okay, never. They were just curious if you happen to know who that was, because they kind of stood out. So yeah, I figured I'd ask.
No.
Never mind, it's fine.
No. Okay. Yeah, I don't know. But if they have any other questions, tell them to shoot it to you.
Does Sarah have any family or support in the gallery?
Not a one.
Yeah.
No one.
Yeah. It's not going great, is it? Yeah. So no. I this is going to be popcorn fuel, I think, this afternoon is what's happening. This, because I don't know. I may drink during it. I don't know. This might be the best testimony of our time, because I don't know how she, and I think there's also a pretty decent chance that she's not going to be able to make the overt act. She can't do it because it doesn't make any sense. So I think there's a very decent chance. I think there's a very decent chance she testifies, and the judge is like, okay, you can't offer self-defense. You can't offer battered spouse. That defense is excluded to you. And then it's like, well, I don't know what else you're doing with your time because you have no other defenses. So good luck, I guess.
I know, but Mr. Owens, in opening statement, and obviously we know opening statement is not evidence, but when you say something, you're kind of expecting that they're going to come through with it. He said that the overt action happened in the 11 minutes between the two videos. So I don't know how he's going to show that with her, how he's going to bring that out, or if he actually can. I don't know, but that's where he's claiming that the overt action happened, was in that 11-minute difference between the two Suitcase videos. So I don't know. Maybe Sarah's going to say, well, during that time when I wasn't videoing, he was cursing me out, saying, when I get out of here, I'm going to kill you. I guess.
I mean, if that's what she's going to do, then I guess. But I don't know how that works. He obviously has the right to try to leave the suitcase. So it can't be him trying to leave the suitcase. How can that possibly be the overt act? It doesn't make any sense. And so, yeah. So it'll be interesting and comical if the judge has basically told the defense they're going to do this. So it's not like a surprise. The judge has said, you need to present the overt act, and it's essential. It's what I would refer to as the burden of production, although none of the lawyers have used that phrasing. It's the burden of production versus burden of proof. It's the bare minimum scintilla of evidence necessary to establish the affirmative defense, which the defense does have to do. They have to establish the bare minimum evidentiary picture, and they can't do it. So, so if the phrase burden of production comes up at any time, that's what they're talking about. So yeah, I don't know. Do you have any other thoughts or comments? I don't want to keep you overly long. I'm sure you have to eat and stuff, so I don't want to be too much about it.
I ate a piece of banana bread while I was on the phone with you, but I want to get back. I do want to get back up there and be like one of the first ones in court, because I've decided I'm still going to sit in the same row on the defense side, but I want to be a few more seats over, so I will be cutting off part of the jury, but I will be seeing Sarah like full face on. I don't know, but in any case, this has been crazy. The gallery, since the start of the trial, has been mostly empty until today. Today is a full gallery because people knew she was taking the.
Everyone knows it's a train wreck. Everyone likes to watch the train wreck.
I suppose so, but yeah, it's been crazy here in Orlando, and but this judge. Oh, and also too, may I please make this statement because I'm getting people are two things. People are like, well, if you're live tweeting from the courthouse, why aren't you telling us everything that's being said? Well, here's the thing. I'm not a stenographer. I don't take dictation. I am just trying to give people a general idea of what's going on. You know, there's plenty of people that are streaming it, so if you want to know word for word what's being said, then watch it.
Yeah, really, right?
I'm just trying to give the experience of what I'm experiencing inside the courtroom. I'm doing jury reactions. I'm doing Sarah reactions, okay? I'm not there to transcribe what everybody is saying. So I want to get that out there. I apologize. If that's what you're looking for, then that's not me, okay?
No, that doesn't make any sense. I don't need you for that. I can just watch the trial. Why would I want you to just tell me what I'm already seeing anyway? That does me no good. What I would want from you is what I can't see. I want you to tell me about, and also your perceptions of the thing, how you feel it's reacting, how the room is reacting to things, how people's faces are reacting. What does it feel like to be in the room? That's what I can't tell. So that's what I need you for. So this is a really dumb criticism of you, Jules.
Well, thank you for that, Kurt. And the other thing that I also want to say is people are criticizing the defense team. I feel it's not appropriate. This team, I have spoken with each and every one of them, and they are it's a great team. They answer your questions. They are approachable, and they've got a hard job. They volunteered for this job. They are doing the best they can, no matter how you feel about Sarah Boone. Okay, she is entitled to the best defense she can get. And so they are doing the best they can because that is their job.
Correct.
And we should not be saying, you know, nobody should be saying, you know, anything negative about them other than their performance. Don't be criticizing them because they are defending her. You could criticize their performance if you think that they're not performing the way they should. They have a hard case to put in even reasonable doubt. I mean, let's face it, it is difficult. But they're doing their job, and despite how we may feel about Sarah Boone, she's still entitled to the best defense possible, and that's what she's got.
Yeah, I mean, I couldn't agree more. I mean, obviously, she's entitled to the best defense. You know, I can obviously say, well, this doesn't work. This doesn't go anywhere. Right. Why are we asking these questions? You know, they don't seem to be leading anywhere. Why do I care about the information you're soliciting? Like, for example, when they were asking the detective this morning, they were asking her certain questions about certain things she did or certain people they talked to. And I'm like, why do I care? Why does it matter? You know, what's the importance of this information? So I can say like it doesn't work, but you know, they're certainly trying their best with a very difficult client, I'm sure. So I'm ever grateful that it's not me. Did I tell you that her private investigator reached out to me at one point and asked me if I wanted to represent Sarah Boone?
No, you did not, but it does not surprise me that someone reached out to you. It does not surprise me at all.
Yeah. I decided not to respond to that solicitation, and I think I'm happy for it. The thing is, like, the time frame is just so condensed, and I don't have any real criminal experience. I'd be getting my teeth handed to me in every possible dimension. So
Well, no,
Although, to be
not
fair,
that.
it wouldn't be much worse than that she's getting now because she has nothing to work with. So there's that.
There is that. But I will say this. She has, as difficult as she was running through 8 attorneys over the past 4 years, she does have a very good relationship with this team. And I love the fact that Judge Cranick, every time she comes back in the courtroom before the jury comes in, he asks her, are you happy with, your defense? Are you
just try to get past that ineffective assistance of counsel defense. I also thought the colloquy today where they were asking about whether or not she wanted to testify, I thought it went on perhaps just a little bit longer than it might otherwise would. I'm like, he really wants to get this on the record. He really wants to get this on the record. They're like, yeah.
Oh, and there's one other thing, too, that you might find interesting. I would love to hear your take on this. Now, obviously when court is in session, it can get testy and tensions rise and you may hear snipping back and forth. But once breaks come about or, lunchtime, whatever, in other trials, I have always seen where, both sides start laughing and joking with each other and, oh, what do you have for lunch? Or, we're going to do this, or we're going to do that, or whatever, okay?
Sure.
And that's not happening here, okay? Mr. J has a very strong dislike for Mr. Owens. He won't even look. When Mr. Owens approaches him, he won't even look up. Like this morning, he went over to Mr. J to show him photos to say, these are the photos we'd like to, he didn't even look at him. He was like, put them on the desk. And he was staring down. He has such a disdain for Mr. Owens. It's unbelievable.
That can happen. I mean, there's no like hard and fast rule, and that can happen, and it happens in civil cases. It actually happens less in criminal cases, which is funny. People tend to, all things being considered, attorneys tend to be more cordial to each other in criminal cases than civil cases on the whole, which is kind of funny. But that kind of thing can happen, either way. It's like we can, either, our work is our work and we'll go out and be drinking buddies and then we'll go back in and we'll fight it out, or, we just don't get along. So either that's due to the personalities of the people involved more than any other factor, which I guess is just true of friendships in general.
Yeah. Well, this is, this is how it is. So, but that's, if you got any other questions, give it to me. If not,
no, I think I'm going to let you go for now because I think we've got enough, and you're entitled to a break and a lunch, and you've got about 30 minutes before court resumes. So I don't want to deprive you of getting your good seat in the courthouse.
All right. Well, you know how to, text. If you have questions, you've got my number. Go ahead and text me, and then on a break, if whatever. But what do you call it? Scott from Recovery Addict, though, just so you know, I have to do him first because I have my media pass. Thanks to him.
Fair enough.
Yeah,
Scott's a good guy. I guess we can forgive you.
Yeah. But okay, guys, I hope I was helpful. Don't forget to follow me on Twitter. And if you want me to get you...
Where can we follow you on Twitter, Jules? Whatever handle would we look for?
Well, since there's a certain person by the name of Kurt who encouraged me to embrace the term that Ethan Shapiro gave me, Notorious Jules. I am Notorious Jules on Twitter. Yes, Kurt,
you are.
Took your advice. I took your advice, and I have embraced it. So thank you, Kurt, for that.
No problem.
I
Happy
tell
to help.
Everybody asked, and I told them. I said, Kurt is actually the one who talked to me about it and said I should embrace it.
This is awesome. Yeah, I think it's great.
Yeah, so there you have it.
Yeah.
All right, Kurt, I will talk to you later. Have fun.
Bye-bye. All right, that was our good friend Jules calling from the courthouse in Florida. We love Jules. Jules is the greatest. Yeah, branded the notorious Jules, and she absolutely 100% should lean into that moniker, and I'm very happy that she is. It's like, yeah, it's like, fine, I'm notorious, whatever. It's fine. You can't buy that branding, man. It's great. So that's good. All right, so we've got about a half hour left. I think I might just put on the banner and turn off the microphone for a half hour because I'd like to eat something. I'd like some sort of food product. We got jury back in 30 minutes. So is there anything pressing before I just turn off the microphone and leave you to stare at Sarah Boone's cold, dead eyes? Get some food? I will in just a second. Yeah, the speed of this has probably contributed to some of the testiness, if I had to guess. Right? Again, it's like you're trying to run onto a moving train, and you kind of knew what you were doing, but still, it's not like fun and easy. So I wouldn't know for sure, but I would imagine some of the testiness is due to the speed at which the defense had to get up to speed. And so things are not necessarily gelling the way they're supposed to because we're having to do everything very condensed. So if I had to bet what that would be the factor, but it could be long running animosity due to other cases. It could be due to a lot of things. Who knows? All right. I'm going to have you stare at Sarah Boone for a while. I will see you guys back in just a minute. Talk to you soon.
Next up, I got some sounds from
Oh, yeah, baby. We're coming back, baby. It's going to be glorious. Joining the uncivil law revolution as we join ourselves for some Sarah Boone frivolities. Sarah Boone is taking the stand at last. We are all super excited for the bullshit. It should be amazing. It should be epic. We're all thrilled. They've actually got music on their channel. They stole my idea, bastards. Anyways, we are turning our attention to the Sarah Boone trial, where Miss Sarah Boone herself will take the stand and tell us how we have all tragically misunderstood this. And, you know, all she has to do is tell us with sincerity and credibility how we've misunderstood this, and a not guilty verdict will follow. Great. So we'll see how that works out. Tell your friends about the stream, indeed, Tony. Yes, absolutely tell your friends about the stream. We're the best stream. We are the best stream. We have snacks. We have snacks. Such as me. I'm a snack. And also, we have trial commentary and other things that makes the trial fun and exciting. Strap in, strap on. Either way, cowpoke. Either way, I think it would be about appropriate. Yeah. This is going to be interesting. This is going to be interesting. How will my own sanity do as a result of this? Will be a question that's open to potential interesting revelations. Vicky says she has graham crackers. I've got some Doritos. I got your sister hooked during Karen Reed. She said, I need this man in my life. There you go. What are the chances of a hung jury or full acquittal? Not great. Not great. Did the jury recently have a catastrophic turnip truck accident? Has the jury fallen off a cliff? You know, so, you know, have they all been poisoned with a hallucinogenic of some kind? So no, I don't really, yeah. So 5%? 5% is the base chance to convict. I'm not sure what the base chance to acquit is. There may not be a base chance to acquit. I've said there's a 5% base chance to convict, no matter what happens, just because the defendant is sitting at the defense table. I'm not sure there's a base chance to acquit. So, 0. Yeah, it's not 5%. I don't think it's that high. If there is a base chance to acquit, I'm not sure it's 5%. I don't think it's that high. I haven't really thought about it. I haven't really said a number. 1% maybe. Maybe there's a 1% base chance to acquit. I don't know. You think it goes both ways? I don't know about that one. I don't know about that. You see, the thing is that no matter how much we tell people innocent till proven guilty and beyond a reasonable doubt, the problem is that your average person, what they really think is, well, if they're sitting at the defense table, they must have done something. So, yeah, this is, you know, yeah. The snowball's chance in Florida sounds about right. Yeah, It's not great. It is not great. Massachusetts has legalizing psychedelic mushrooms on the ballot. Ooh, exciting. That didn't really necessarily work out that well in Oregon, though. So I don't know. Although, to be fair, Oregon legalized everything. So maybe that's an unfair comparison. I think that there's some very interesting, I don't know a lot about it, but I think there's some interesting potential, medically at least, for some of the hallucinogenics. So I wouldn't necessarily be opposed to further study relating to that. Was it, what was it, ecstasy, I think, that was very recently under consideration for treatment for PTSD, but got denied very recently. But it got like some serious consideration for ecstasy, I think it was, being legalized for post-traumatic stress disorder for veterans. So at least some people are thinking about it. It was in the news relatively recently. It happened like, I don't know, 2 months ago or something like that. MDMA? Is MDMA the same thing as ecstasy? Or are those different things? And is it the same thing as Molly? Because I think those are all the same. Newsom vetoed it. Was it Newsom? I thought it was something on the federal level. I thought it wasn't just a California specific thing. I thought it was like a federal thing. I might have been mistaken. X is the cut. Okay, fair enough. All the same? Okay, fair enough. So my drug knowledge, I know some things about drugs. Yay. Combined with talk therapy, I'm sure.
We are on the record. 20. We'll wait for it. That's fine. Just hang out for me.
Sarah Boone's not here yet. Sarah Boone's not here. MDMA is purest form? Yeah, I guess so. You think she's fled the jurisdiction? You think she's in a convertible right now heading towards a cliff? Yeah. Thelma and Louise. Is Sarah Boone more Thelma or more Louise? Discuss. And who would be the second person in a remake of Thelma and Louise with Sarah Boone? Who would be the second person in the car? Discuss. So one, is she more Thelma or more Louise? Second, who is the second person in the car? I would like your contributions now. You don't have cliffs. That's true. Florida's peak height is something like 30 feet, I think, or like 25 feet. Florida doesn't have cliffs of any description. They're very, very flat. So if she's going to try to head for a cliff, she's going to have to drive through a couple states first. This is true. Fair point. Amber Heard? Good call. Good call. Amber Heard? I like that. Good call. Shabusiness? Taylor Shabusiness? That could work too. Casey Anthony? What's her name? From South Carolina is about to be eligible for parole. What's her name? Is that no, it's not Casey Anthony. What was her name? Damn it. Brain's failing. I'm not as sharp as I used to be. I think my brain is getting old. We're back. I know we're back. We're fine. Karen, no, that wasn't Karen Reed. Susan Smith. There you go. That was the one I was looking for. Thank you. Yeah, Susan Smith is eligible for parole. So it could be Susan Smith. Maybe Sarah Boone gets off and maybe Susan Smith gets parole. Although driving with Susan Smith in a car is perhaps not the safest course of action. Letitia Sosh. Susan Wright of Texas.
We're back
Lori
on the record,
Daybell.
Case number 2020 CF 2603.
Lori Daybell is a very
State
interesting
versus
choice.
Sarah Boone. Let me get appearances for the state.
David Ketchstraw on behalf of the state. William J. for the state.
Defense.
James Owens for Ms. Boone.
Connie Henderson for Ms. Boone.
Ms. Boone is seated at counsel's table.
Lori
We're
Daybell.
mixing black jacket and blue blouse from
Lori
this
Daybell
morning.
is a very interesting choice.
We will be standing when our jury enters. She is in custody but out of any restraints. As she is testifying first, once we bring in our jury, she will walk to the jury box and be sworn in front of the jury. State, are we ready to bring in our panel?
Yes, Your Honor. I was able to get the redactions done. I put a disc on Mr. Owens' notebook there, has the case number on it and 3 black dots in Sharpie, just so that a random way of saying what it is.
Excellent. Appreciate it. Thank you for getting that done over the lunch hour. Defense, are we ready to bring in our jury?
I've got a couple of issues.
Yes.
I bet you do.
Number one,
I bet you do have a
Kevin
couple
Beck
issues.
is, working on
Let the record reflect that Mr. Beck has appeared.
Look, I have been teased enough. Okay? I need to move on.
our acts, prior bad acts, prior to the overt act. And there's 2 reasons that I believe I should be allowed to do so.
Oh my God, you're making this motion again?
One is, Judge,
Holy shit.
in that 2-minute video, Sarah Boone
You can't
makes a statement.
bootstrap this.
That's how I feel when you choke me. And then some moments later, that's how I feel when you cheat on me. And she's angry at him, and she's talking to him.
But not malicious.
She's
Not
talking
malicious.
to him in an intoxicated state, and she's expressing her anger and why she is angry. And I ought to be able to elaborate on what that is that she's angry about as it relates to.
You can't bootstrap this. You're trying to use your client's own self-serving statements.
The second one is, Judge.
No.
Proceed with the second. Is the second intertwined with the first?
No, I mean, it's a similar argument, but related to something else.
Okay, response.
Judge, I don't disagree that they should be able to bring that in once they've established an overt act that is imminently dangerous to an objectively reasonable person. I believe that's the law.
Yep.
Any other further arguments, sir?
Shove that
No,
case
that
right
issue.
up your ass.
Motion's denied. Court again is going to rely on the Supreme Court's guidance in these situations based on Holland 916 7 750.
Right up your ass.
760 through 761.
My second argument ties into what he just said about what a reasonable person would do under the circumstances facing an imminent threat, whether a reasonable person would perceive
You have to establish it
the overt act
objectively.
on the part of Jorge Torres that was witnessed by Sarah Boone. Would that be perceived by someone as a
You still need the objective.
imminent threat?
You need the objective,
And
sir. This
To
is
some
exactly
degree, you have
why
to
you need the
understand
objective,
history
sir.
of Jorge Torres and Sarah Boone. They were together 3.5 years. They were engaged, but there had been a history of violence.
Yeah, we might have to read Holland. We might read
Yeah.
Holland.
From
'Cause-
the evidence that's been
yeah.
presented,
Right up your ass.
facing the circumstances in total, if you take what she said at various times, you would understand that
He
she became
really wants to
concerned
get it in.
when he
I mean,
came
I
back
appreciate
from
what he's
Publix
trying to
with that
do.
second
I
bottle
understand what he's
of
trying to do.
wine
He's
because she
looking for
knew
any door to get it in.
when George Torres,
You know, any port in a storm.
gets to a certain level of
But
intoxication,
it's not
he
happening.
gets
Stop trying to make fetch
sad,
happen.
he gets moody, and eventually he gets belligerent. And
Ooh, he might get
sometimes
moody,
he can be
people.
violent.
He might get moody.
So
That's an
she
overt
knew
act.
when he brought home that second bottle of wine that it was not going to be a good night, and she tried to keep him occupied.
It was a good
tried
night.
to keep
It was
his
a good
mind
night. She
off
said
of
it
his
was a good
troubles
night,
because
repeatedly.
she knew
I heard her
that
say
if
it.
he reaches a certain level and is dwelling on
It was a
his
great night.
hardships, that he will react to her in a violent way. So she had that state of mind with that understanding of her history and his history in his
Motion's
overt
denied.
act, which she's going to testify to, coupled with the fact of her state of mind based on
as a judge right about now, I'd be like,
past experiences with
motion
him,
denied.
that
Did I
intoxicated
stutter?
state and the fact that he is violent. So
that'd be what I'd be
she was
doing right about now.
hypersensitive
So if I ever become a judge,
to
there might be
danger
some sarcasm
and fear. And
from
I
the
think
bench.
that ought to be allowed in
It could happen.
as part of her collectively an overt act. So it was culminated by his state of intoxication coupled with his overt act created the well-founded fear for her to block the attack, to self-restrain or physically restrain George Torres in the suitcase, to
Maybe I'll
actually
have a
use the
sign.
bat to
Just have a
prevent him
sign.
from getting out
Did
of
I
the
stutter?
suitcase because she knew she was going to get attacked.
And the basis of the opinion of about to be attacked is predicated on the prior incidences of violence, correct? Based on
Well, there's an overt
knowledge.
act committed by George Torres, but she was heightened because she knows when he gets to that level of intoxication in that scenario, and that's an issue.
So I need clarification. What is it that you're asking me to do?
For me to be able to elicit from Sarah Boone that she was concerned once that second bottle was brought, and that's why she tried to placate him over the course of the evening, and that's why she had a heightened sense that he was capable.
Heightened sense.
Judge, due to that.
Someone's been reading the domestic violence
He may act
pamphlets.
violently towards her, and the problem is, a lot of the problem is, Judge, he doesn't remember
Heightened
battering
sense.
her the next day. That's part of the reason that she videotapes him and photographs him. She starts to document what happens so that she can show him. She loves the man. She adores the man. She wants to marry him. She wants a life with him, but
If she
she's
wants a
trying to
life
be
with him,
on.
she's
So
going about it
that
very
all
much
ties
the wrong
into
way.
Her behavior, her sense of nervousness at that point. The reason she
Mission
was so
failed.
confident during that 2-minute video is because she knew, okay, this is my chance. He can't get to me. I can tell him exactly what he does that bothers me, that hurts me, and how I feel. And so that's all tied together with then he starts to try to get out of the suitcase, and she reacts the way she does.
Response.
Can I respond with everything that guy just said is bullshit?
Already, the court
Can I
has
do that?
ruled there are no new arguments being made. The court understands exactly what Sarah Boone, the defendant, said to Dr. Werner on October 2nd. The court knows exactly what the defendant said to Dr. Harper over the period of a number of months and years, and there was no overt act. The overt act
overt
has
act.
to be something that is objectively reasonable to cause a reasonable person
Right.
to
Objectively
believe
reasonable.
in the
Objectively
fear of
reasonable.
harm or death.
The
But
normal,
testimony
prudent, ordinary
is-
person.
Is not, that's
The
what
man
has
on the
occurred,
bus,
that
that guy.
her
Or
new
more to the
testimony
point,
is
the
generalized
jurors.
fear, but you've already
Those
read that.
people.
You've already ruled on that.
Yeah.
And I'll just remind the court that her previous testimony is, it's all fun and games, we're laughing, I zipped the suitcase shut, we're still both laughing, it's funny, and then the decedent says, I can't breathe.
Motion denied.
Then she flips a switch, gets angry because it reminds her of all the times before where she is asserting that the decedent made her feel like she couldn't breathe. And then that's when she starts beating and shuffling the suitcase so much that it flips over and hitting him with the bat. We've covered this ground. Aggravated assault, aggravated battery, 2 independent forcible felonies. She's committing false imprisonment. She is the initial aggressor after there being no overt
She sure
act.
is.
She can't start it and then say, well, I'm in fear of retaliation, because that's what her testimony was, is once I started doing these things, once I wouldn't let him out of the suitcase, I was afraid he would come out and harm me or kill me. Well, Judge, if I pull a gun on you, and I say, give me everything you own on you right now, and then you, in turn, pull a gun on me and say, bam, 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 and shoot and kill me, and I shoot, let me strike that, you pull a gun on me to defend yourself, and then I shoot and kill you, I can't assert self-defense. I can't say, well, Judge Kranick pulled a gun on me and I was in fear of death, because I was the initial aggressor. I was committing a forcible felony. That's the facts of this case here, according to her previous testimony. And the state concedes if she wants to change her testimony again, that's one thing, and then we'll cross that bridge when we get there. But if she testifies as she previously has, the court has already ruled there's no overt act, and you've read the transcripts. You know what she has said.
Judge, she hasn't testified. She hasn't testified. Dr. Harper's testified. Dr. Warner's testified.
Like the state just explaining self-defense law 101 right now. It's like you can't use the fear of retaliation as the overt act. That makes no sense. You can't use the fear of retaliation as the overt act. Oh my God, he was so angry. He was going to kill me. Well, why was he so angry, Sarah? Why was he so angry?
Characterization of that assessment. But it's up to Sarah to tell the truth here today. She's under oath. She's under oath today. She's got an obligation to tell the truth. If he thinks she's made prior inconsistent statements, it's up to him to impeach her with those.
That shouldn't be very hard. Impeaching her.
To the extent that you are requesting permission to go into presumably and seemingly prior bad acts, vis-a-vis, he got the wine, and I know what happens when he gets it, and everything that follows from that. Those are bad acts. That is character. And the Florida Supreme Court has provided guidance in circumstances, specifically in Holland,
easy to understand words.
Done. You're attempting to provide information that the defendant was apprehensive of the victim at the time of the homicide by virtue of the wine, etc., as you've proffered. That's bad character evidence that you're going to be bringing in. Historic bad character evidence. This is what happens when he drinks. This is what happens when I don't placate him. This is the situation that I find myself in, which inevitably may dovetail into prior incidents of abuse. That's all prohibited character under 404, 9404. And the carve out for that is if a overt act is established. It's not a subjective standard, it's an objective standard. The jury instruction, 3.6F, identifies it being an objective standard, and the Akendo case specifically tells us that it's an objective standard. And Akendo, the second DCA in 2023 stated, the conduct of a person acting in self-defense is measured by an objective standard, but the standard must be applied to the facts and circumstances as they appeared at the time of the altercation to the one acting in self-defense. I'm going to rely on Holland. Holland is the law of the land. It is what the Supreme Court has told us to utilize. That's what I will be relying on. The overt act has to be established.
Ms. Boone, do you understand that?
I do.
Okay. Anything else?
We cannot talk about any prior bad acts.
That's right. What part of this is confusing to you? No bad acts. Give me the overt thing first, baby.
You understand?
Do you understand that?
I do.
Okay. Anything else, State?
Nothing.
Defense, anything else, sir?
No, sir.
All right, let's go ahead and stand and bring our jury.
Let's stand for the jury, everyone. Everyone rise. Everyone rise for the jury. Gonna stand up for this one. The jury deserves the respect for this one, because the jury has to listen to some bullshit. So I'm gonna honor the jury by standing.
Jury entering.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? All right, thank you. Y'all can be seated. Members of the jury, after seated and comfortable, if you could raise your hands to confirm that you complied with the court's instructions during the break. Record reflect all hands have been raised. With that, the state has rested. The defense is going to put on a case. Defense, Mr. Owens, you can call your first witness.
The defense would call Sarah Boone.
Here we go, kids. Here we go. Exciting. It's happening. Woo! Oh, Lord.
Please do swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, ma'am, you could take a seat. And if you
We
could,
need a
state and
lies
spell your
counter.
name for the record.
We
for
need a
us.
button I can push that just increments lies.
Sarah Boone, 101077.
And could you spell your name?
SARAHBOONE.
All right, thank you very much. Sir, you may inquire.
Ms. Boone, would you please tell the jury where you were born and raised?
Atlanta, Georgia.
You were born in Atlanta?
I was born in Atlanta.
And how long did you stay in Atlanta before you moved here to Florida?
I was 3 years old, 3 or 4.
Okay. And from that time, y'all moved, you and your family, your mother and father, moved to Orlando?
And my grandparents.
Okay. Y'all all moved down from Atlanta down to Orlando?
Yes, and my 2 brothers.
Okay. And were you raised here essentially from that time on?
Yes.
And you resided here in Orange County, Florida that entire time?
Yes.
Okay. And where did you go to high school here locally?
I did.
Where did you go to high school?
Edgewater.
Okay. And tell the jury, how old were you when you graduated?
I was 18 years old.
Now, I know you lost your mother and father.
Overruled.
It's basic
I know you
background.
lost your mother and father in your teens and in your 20s. Is that true?
I lost my grandfather when I was a sophomore in high school, and I lost my father when I was a senior. And then my mother passed away a few years after that, and then my grandmother passed away after my mother died.
All right, so you were in your 20s when all that was going on?
Yes.
Okay. And then at some point in your 20s, you met Brian Boone?
I did, yes.
All right. And how long did y'all date before you married?
A good handful of years. I helped my family with paying mortgage and bills for the house since my father had passed away and my grandfather, so.
So you worked outside the home?
I did.
Okay. Can you tell the jury when you said you and Brian Boone dated for a while? Do you remember when y'all married?
I do.
Could you tell the jury when y'all were married?
The year?
Yeah. You remember the date?
It happened to be, yes, that after my mother passed away, that he had waited to ask me to marry him because he knew it would be,
Objection, non-responsive.
Sustained.
Just answer the question if you can, Ms. Boone. Are you a little bit nervous?
a little bit.
Okay. Well, just tell the jury if you remember the date that you and Brian Boone married.
August 21st, 2004.
Okay. And had y'all lived with each other for a short time before that?
Short time.
Yes. Okay, after you married, how long was it before y'all had any children?
Gosh, 6 years?
Okay. And y'all have one son.
Yes.
What's his name?
Lucas.
And how old is Lucas now?
Lucas will be 14 years old on the 28th.
28th of this month?
Yes.
Happy birthday, Lucas.
So you and Brian were married, and y'all lived in Orange County. How long were y'all married?
For 13 years.
Right,
I
and
don't
y'all
think your mom will
divorced?
be making you a cake, Lucas. Sorry to say.
And as part of the divorce, were y'all to share custody of your son?
Yes.
So y'all would split days, would that be fair to say?
Yes.
Okay. At some time after you and Brian split up, did you meet Jorge Torres?
Yes.
All right, could you tell the jury how you met Jorge Torres?
I met George when I decided to buck up, I guess, and was tired of trying to patch things up with my ex-husband. And I decided to go one day for a walk across the street and go have a beer by myself and sit and people watch just to get out of my house and a change of scenery.
All right, now is this your apartment?
No, this is the marital home.
Okay. Where is that marital home?
Winter Park?
You're no longer living in that marital home?
No.
Who lives in the marital home?
No one. It has been sold.
Okay. So you met George Torres before you got the apartment?
Yes.
Okay. And you met him at a bar across the street from the marital home?
Yes, we had a mutual friend there.
Were you introduced?
Yes.
All right. How did you and George get along when y'all first met?
Very well. It was strange how quickly we hit things off and had so much in common, and I never thought that he would be interested in someone like me, and I just couldn't believe that he was actually interested in me and said a lot of nice things, and 1 hour ended up being 4 hours from when we had first met, and then we would always have something to talk about.
Why couldn't you believe that he would be interested in you?
Because I'm a horrible, horrible monster of a person.
He was very handsome. He was very funny. He was smart, and I would show up in workout clothes and disheveled hair, and I guess I kind of felt broken from being in the process of the divorce that he knew about. But then one of the things that we could relate also was the fact that he was here in Florida because he had just been divorced from his second wife. So that was another topic that he and I could compare notes on.
So eventually the divorce was settled. Did you get your own place?
Yes.
Is it fair to say that after at first you lived in your parents' home, correct?
Yes, until I was married.
And then you moved directly in with Brian?
Yes.
And then y'all lived in the marital home, correct?
Yes.
And then you got this apartment?
Yes.
So that was the first time in your life that you actually had your own place?
Yes.
And what was the address?
4748 France Court, apartment number 3.
And what city is that in?
It's in Winter Park.
How far is that from here?
20 minutes.
Okay. So you got that apartment, and initially were you by yourself?
No.
All right, tell the jury.
In the almost year, about 10 months of separation from Brian, my ex-husband, that is the time when I met George. And my ex-husband was trying to buy me out or force me out of our marital home, and I needed to find somewhere to live. And
So did you and George agree to rent the apartment?
yes, I needed extra income. We could not afford it, just on my own.
You were receiving some income from the marriage settlement, were you not?
Yes.
So you did have a consistent monthly income coming in from the marriage settlement?
For the most part, yes.
But you needed more to live?
Yes, to pay the bills and for rent.
So did you and George have some agreement?
We did.
All right, what was the agreement?
The agreement was that if I decided for he and I to live with one another, because it would be under my name, that he would help with the monthly bills and on a regular basis where it wouldn't be something that I would have to argue with him about. It would just be an automatic, make sure that everything's paid first, and then from there, hopefully have some fun with it.
Okay. And so I understand from that point on, would it be fair to say that y'all saw each other on and off for about the next 3.5 years?
No, I would consider us a couple. At some point, he asked me to marry him.
Okay. But y'all did have times where he left and went to live with his parents?
Yes.
Is that fair?
Yes.
And there were times where there was an understanding that y'all were going to break up?
Multiple times.
Okay. All right.
Okay.
So, again, on again, off again.
Yes, this was actually before we had our apartment. That was, I guess, our dating phase.
Okay. So y'all were together for 3.5 years, is that fair?
Yes.
And y'all had actually agreed to marry?
He had asked me yes a couple of times to marry him, and one time I agreed to yes.
Okay. Now, I want to get directly to the date of this event so that the jury can hear your testimony. All right? So tell us, I believe the date is February the 23rd of 2020. Explain to the jury that whole day, from the time y'all got up, the whole thing.
It is narrative.
Approach.
It does call for a narrative. Explain to us what happened the entire day. It does call for a narrative. But, yeah. We'll see. I'm sure the defense lawyer knows it calls for a narrative. He might right about now be saying, yeah, it does. But, you know, the prosecutions themselves suggested a narrative, and I'd really like to take them up on that offer right about now. Would be good. So we'll see how this ruling comes down. If it's overruled, it's because the judge knows it's about to be lies. So we'll see which way. The objection, strictly speaking, should be sustained. But if it's being done because he doesn't want to solicit perjured testimony, then it will be overruled. So if it's overruled, it's because the judge knows it's lies.
Objection's overruled for now.
Yeah, there you go. So it's lies. There you go. Yep, there you go. It's lies.
Now, Ms.
Yep.
Boone, let's just, instead of one long speech, let me break you up over the course of the day. So, do you remember the date of February 23rd, 2020?
Yes.
Do you remember getting up?
Yes.
All right, just tell the jury about that morning, what y'all did that morning, what you and George spent the night together at the apartment.
Yes, at that point, he was living there.
Yes. So y'all slept in the bed together upstairs, February. So y'all would have gotten up that morning, February 23rd of 2020.
Yes.
All right, tell the jury what happened when y'all got up.
He was already downstairs, and I went downstairs, and he wanted to start the day off by drinking because it was a day off from his job. And I talked him into cleaning and tidying up the house for a sense of accomplishment. So that is what we did for however long that it took. So we did tidy up the house and got everything in order, and it was kind of a reward, I guess, to be able
Jordan
to sit
Peterson
and
does tell you to
enjoy
clean your
ourselves
room, so
and,
I mean, you got that going for you.
sit on the back porch.
All right, what do you mean by cleaning up the house? What did y'all do?
We swept and mopped. We folded some of the laundry. I know that we did the dishes, emptied the dishwasher, just general run-of-the-mill tidying up.
And did you have your son coming the next day?
Yes, that was one of the reasons why we were able to do that.
What was the arrangement you had in terms of the next day would have been your day to pick up your son from school?
Yes.
What time would you pick Lucas up from school the next day?
I believe his school ended at 3 o'clock.
Okay. So you would have been responsible to pick him up, and he would be spending the night with you that night?
Yes.
So you wanted to have the house nice and clean?
Yes.
How many bedrooms are in the home?
2.
And you and George had one bedroom?
Yes.
And who had the other?
Lucas.
All right. Is that exclusively his bedroom?
Yes.
All right. So how long would it have taken y'all that morning to clean?
I don't really remember what time we woke up, but maybe a good 2, maybe 3 hours.
Okay. And would it be fair to say that you and George both smoked cigarettes?
Yes.
And would it be fair to say that you and George both drink alcohol?
Yes.
All right. So at some point, y'all finished your chores,
Yes.
right? And then y'all were going to enjoy the day.
Yes.
All right. What was the plan?
It was just kind of, we've got the day to ourselves. Let's just kind of relax and go with the flow.
All right. did y'all make a decision that y'all were going to start drinking?
Yes, we had a half of a bottle that was already in the refrigerator, and I did not want to go out afterwards. I, again, had Lucas coming the next day, so we went over to Publix to purchase another bottle of wine so we could not have to go out later on that evening.
Now, you were here in court when the state...
Slackers.
The state played
Slackers,
the
they should be
video of
buying
you
by the
two
case, man.
and the Publix purchasing the bottle of wine?
Shaking my
Is that
head.
what you're referring to here with the jury right now?
Yes,
Okay. And that was around noonish?
I believe so, yes.
Okay. Had y'all started drinking the leftover bottle before going to the Publix?
No,
Okay. So, y'all bought a bottle of wine?
yes,
All right. And how did y'all get to Publix?
my car,
How far is Publix from your apartment?
5 minutes.
How would you get there from your apartment?
What do you mean?
Did you have to go across any major highways, or is it right there?
You just come out of our apartment complex and you do a little U-turn and then you come up and it's right in that complex.
Okay. But it's easier to drive than to walk?
Yes,
Okay. Now, I know at sometimes y'all would simply need cigarettes and it was in walking distance. Can you tell the jury about that?
yes. There was a Lotto Zone convenience store with, in
That's a
the
good-
same,
that's a good
I guess,
dating spot.
parking lot of our townhome, our complex, and it was just a straight shot from our apartment to a back gate, and you could get right into the convenience store from right there.
Okay. But y'all went over to get that bottle of wine around noonish, and how did you took your car?
Yes,
Did George have a vehicle?
he did not,
Okay. And how did you pay for the wine?
with my debit card.
And then y'all came back and started drinking?
I paid for
Yes.
it with
Okay. Tell us
blood.
what you did when you got back from the Publix.
Just went on the back porch where we usually spend our time because we're able to smoke cigarettes outside as opposed to inside. And
Is cigarette smoking not allowed indoors?
it is not.
Okay. Do you have pets?
Yes, I do.
Or did you have pets?
I did, yes.
Okay. Were they with y'all?
Thank you,
there?
Carolina Moon, for the gift memberships.
my
Always
dogs were with
appreciated.
me all the
Appreciate your
time when I was
support.
there.
How many
Always
dogs do you
appreciate
have?
all your support. Thank
two.
you.
And just, what are their names?
Penny and Tess.
And what is the breed?
They are red Boston Terriers.
And are they both disabled?
Yes, Penny is blind.
She cares
and
for
Tess
disabled
is
dogs,
deaf.
guys. Aw, how
So when
nice.
y'all went out to smoke on the back porch and drink, I assume, as well, correct?
Yes.
Did y'all take the dogs out?
Oh, yes.
Is there a place for them to do their business out there?
Yes, I extended our back porch for them to have a little bit of area as opposed to going from a large backyard from my marital home to our little townhome. And they would come out there and do their business, and I could sometimes I would open the gate and then walk them in the back part of our apartment.
So you and George were just going to enjoy the day together?
Correct.
Is it fair to say y'all don't have a lot of money?
Yes.
And so y'all were going to do something there in the home? Y'all weren't going out for dinner or?
Yes, we primarily, I would consider us homebodies as opposed to going out and partying and doing this and that.
Okay. And how long do you think y'all were out that afternoon outside?
A few hours.
All right. Could you tell the jury what y'all did during that time?
We have a dartboard that's out there, and we just had drinks, and we're just really enjoying each other's company and talking about, things that are coming. We both were looking for a job and just kind of, I guess, encouraging and supporting and planning. And
Well, now you said he had a job. Was he looking for a job, a second job?
no, the job that he had was very unstable, and at that,
So he was looking for something new?
yes, at that time, yes.
Okay. And so during that 2 or 3 hours, would it be fair to say that y'all drank the bottle?
Yes.
Okay. So would it be fair to say that y'all were feeling the effects of the alcohol?
Yes,
Okay. At some point, who made the decision to come in?
I did.
Okay. Why did you want to come in?
I felt that George needed a change of scenery.
Okay. So y'all came in, and then did y'all do anything else before he left again? Were y'all doing anything? I know y'all did some arts and crafts. What did y'all do? At some point, he went to get another bottle at Publix.
Yes, after, I believe it was after we had, it was right before, I believe, that we had gone inside, because he called his daughters. I was trying to encourage him to call his family.
Okay, now where are his daughters?
His two daughters are located in Pennsylvania,
And what are their names?
Anna and Destiny.
And how old are they?
I believe that Anna is in her 30s, and Destiny may be in her early 20s.
All right, does he have any more
Is
children?
Destiny her
Yes,
real
he has
name?
a son.
And where does his son?
He is in Pennsylvania also.
Okay. So part of that afternoon is y'all came in to call relatives, call family.
No, I had him call outside, just trying to, I guess, boost the mood. The first daughter didn't answer, and I don't remember the reason I didn't speak to the second one. I believe if he did, it was just for a moment.
All right, now whose phone we are using?
My phone.
All right. And is that common for y'all to use that, for y'all to share that phone?
It was because George said that he didn't have a phone, so it would either be lost or given to him by his mother, so I didn't know he had a cell phone, so we would use my phone.
So it was primarily your phone?
Yes,
Okay. And you took a lot of photographs that were on that phone?
yes,
Videotapes?
yes,
Text messages?
yes,
Phone call?
yes, he and I both on the phone calls,
So he would use it as well?
yes,
And that phone, is that the one that was seized in this case?
yes,
All right, so y'all called his daughters, and then during that phone call period, did you also call his brother?
yes,
Okay, and which brother was that?
John.
All right, now, how many brothers and sisters does George have?
I'm gonna list them if that's okay.
Okay.
It's John, Pharrell, Isaac, Mo, and his sister.
Okay. And do they all live here in Florida?
Yes,
Are they close by?
as far as I know, yes.
What about his parents?
Yes,
They live here as well?
yes,
Okay. But his ex-wives and his children live up in Philadelphia?
yes,
Okay. So you called the girls, then you called, or George called his brother.
yes.
Was that conversation that long?
No, it was not.
Okay. And then after that phone call, were y'all inside by this time?
Yes, at this point, I believe that it was a good time to get a change of scenery. So I thought George would be better off inside, and frankly, I didn't want to be outside any longer either.
Okay. So just to get an idea, about this time is when he went to get the second bottle, or did y'all stay inside for a while before he left?
No, from what I recall, I thought the day was over, and it was going to be, get ready for the evening, for the day, what do you want for dinner, do you have an extra load of laundry that you need to throw in, kind of thing, and that was my understanding, and he said,
This was about 5-ish or something?
I don't remember the time.
Okay. At some point during that time period, did George go to Publix again?
Yes, I thought he was going to be walking to the convenience store, but apparently, when he returned, he had gone across the street with my car and my debit card to buy another bottle of wine.
What was your understanding of where he was going?
To the convenience store, walking,
For what?
cigarettes.
Okay. And you learned obviously that he came back and you learned that he'd used your vehicle
Yes,
and he'd used your debit card
yes,
and he'd brought back a bottle of wine from Publix.
correct.
And you saw the Publix video of that.
Yes,
So he comes back with the other bottle of wine, and did he want you to drink with him?
it was expected, yes.
Yes. And you agreed to consume the wine, the second bottle with him?
Yes.
Okay. So over the course of that evening, drinking the wine, what did y'all do for time-wise? Watch a movie, music, just kind of tell the jury what you remember. I know it's obviously been a while, but...
It was kind of a regular thing where I would always try to come up with entertaining activities for George, and I bought a puzzle. We started off at one point doing a smaller puzzle, and then we did that very quickly, so then I purchased a larger puzzle, and I believe it was 1,000 pieces. So I thought to get his mind off of things and to focus on something, it would be smart for us to do the puzzle. So for however long that took, we finished the puzzle. So that was one.
Did you every piece was finished, or was it?
Every piece was finished. It was strange that we couldn't find one piece, and we thought it was funny that it was like in like the perfect place on there. But yes, every one but one piece.
All right, after the puzzle, what did y'all do?
I decided to continue to maintain and focus him, and I have a bunch of paints that I used of my son's that his grandmother bought him. It's a very big art wooden box, and it's got pastels, pencils, paint, any kind of whatever. And he and I were very much into art, and with this resource, it got him very interested in being more creative.
How long have you been into art?
Ever since I can remember. As a child,
You like to draw?
I like to do anything artistic.
And I know, we saw some of the pictures of your apartment, but it looks like there was pictures and artwork up. Is that all your work and George's work?
The majority of it, yes, are belongings from my home, and then also some of George's, yes, on the wall.
Was he pretty good at art as well?
Yes,
All right, so you both enjoyed doing that.
very much.
So y'all got out Lucas's art set. What did y'all do with that?
We were just, I guess, doodling, whatever. I would always tell him that everything that you make is a masterpiece. So just let loose and just let it go. And we would just paint and
drink.
Paint and drink, yes, and listen to music sometimes, and yes.
Okay. Now, with the dogs, did y'all get the dogs involved?
Oh, yes, my dogs follow me everywhere, yes.
Was there some dancing going on with the dogs?
Yes,
What now?
after we had completed the puzzle and
What are we doing now?
I guess we're painted out, I thought that it might be a good point for us to maybe listen to some music. And the music that George listens to is it's very fractious to me, and it was definitely not going to lighten the mood. So we ended up finding some channel on the radio, and he was feeling it. And then we ended up, my one dog gets very active and was dancing with us, and we were just having a good time listening to music.
Okay.
And I guess it's getting pretty late in the evening.
Yes,
Anything else I've missed?
I don't believe so.
All right. So tell us where y'all ended up before you started the game of hide and seek.
We were there. I couldn't think of anything else possibly that I had to continue entertainment. But I remember sitting at the end of the couch and him sitting in one of my son's chairs that was in the living room, and just kind of doing this. Like, what are we going to do now? Like, I very much would like to go to sleep.
Had y'all finished off that bottle that he had bought?
I don't remember, to be honest with you.
Bless you.
Would it be fair to say that as the day wore on, the more y'all consumed?
I mean, logically.
Yes.
All right. And would it be fair to say that as the day wore on, the more you consumed, the more effects you felt from the alcohol?
Of course, yes.
Oh, both of you?
Yes.
Okay. So you would agree, would you not, that at the time y'all were trying to figure out something to do and you put your head down on the couch, that y'all, would it be fair to say that y'all were intoxicated?
Yes.
Tell the jury what happened.
At one point, I guess he knew that I couldn't come up with anything else, tapped me on my knee and said, "You're it." So from there, I ran up the stairs and hid into our shower, just waiting for him to find me so we could hopefully go to sleep soon at some point. And
Now, your shower, is it a tub or just a walk-in?
it's a tub, but it's in the master bedroom, and you have to go all the way upstairs, you have to go in the bedroom, and then you have to go into the bathroom part, and then there's the shower part.
So did you lay down in the tub?
At one point, yes, I was.
Okay. So you were hiding?
I was trying,
Okay. And did you believe that he was going to come try to find you?
yes,
Did you wait?
yes, for quite some time.
All right, then what did you decide to do?
That I decided that I need to go to sleep. I'm picking my son up the next day, and we need to start wrapping up the evening. And I went downstairs to find where he was.
And what, I think the jury has seen pictures of your, would you call it an apartment or
It's considered a townhome.
a townhome? So you walk down the stairs, right? And at the bottom of the stairs is a bookshelf here?
Yes, at the very end of it, yes.
Okay. So you walk down the stairs and you turn and look in the living room. What did you see?
I don't even think I made it all the way down the stairwell because I was just looking for him as soon as I could to hopefully go upstairs as soon as we could. And I looked over and I saw him settling himself in the suitcase.
All right, tell us about the suitcase. How long, is it an older suitcase?
Yes,
Whose suitcase was it?
this is George's suitcase.
All right, and did he use it for traveling back and forth to Philly?
Yes, I had recently taken him on a trip to go see his children in Pennsylvania, who he hasn't seen in years, and we took that with us. And because of how dilapidated it was, how broken it was, in the end, after that trip, we decided that we would donate it.
All right, and I understand y'all kept the suitcase upstairs.
Yes,
How long did y'all keep it upstairs?
since we had moved in.
All right. Is there a closet up there you kept it in?
Yes, it was in the master closet, the master bedroom closet, all the way in the back because of the size of it, and there was nowhere to put it, so it's all the way in the back.
So when did y'all decide to move it down from upstairs to downstairs? Was it that day or sometime earlier?
No, it was maybe a week or so prior.
Okay. And so what, y'all were going to donate that to Goodwill, or?
Yes, we were going to do, I guess, a spring cleaning. Anyone who has children understands that they grow quickly, and there was a lot of clothes that I needed to go through of my sons, and then also from George and I moving in and just kind of putting everything in there, at one point where we just needed to actually go through it and organize it and get things more in order.
So is that the reason it was downstairs? You were going to donate it and a bunch of things that you were going to put inside of it?
Correct, yes.
Okay. So it had been down there a week, so it was already down there?
Yes, George brought it down.
Okay. So you said that you got down there, you're looking for him, you see him settling into the suitcase.
Yes.
What did you do?
In my head, I said, oh man, we're obviously not going to be going to sleep anytime soon. And I walked over and he was trying to get himself flat, so I couldn't tell that he was in there. And then
Now, let me stop you there. The suitcase, is it the suitcase over here in the
yes,
box? You've seen it, you saw it.
yes,
It's a pretty big suitcase.
yes.
How big is
No,
George?
it's not.
George was my height. And
How tall are you?
I'm 5'3".
Okay. And how much did George weigh?
I thought it was 100 pounds.
Okay, and how much did you weigh?
I was 98 pounds.
All right, do you agree you put on some weight?
Since I've been incarcerated, yes.
Well, at the time, though, y'all were pretty skinny.
Yes.
Damn, son, your lawyer just called you fat.
From the pictures, it
Yeah.
looks like y'all were both pretty thin.
Yes.
All right, so because of his thinness, is that how, and he's a small man.
Yes.
Okay, so he was able to get in the suitcase on his own.
Yes.
Did he willingly get in the suitcase?
He was already in there.
Okay, when you got to him, did he see you?
Yes.
All right, tell us what happened.
I mean, I zipped him up. We thought it was funny, and we're joking about how he was, I guess, small enough to fit inside of the suitcase.
All right, so what happened then?
From there, it was just, we were laughing about it, and it was just strange that he was small enough to fit in there. And
That is a
then,
good question. How do you gain weight on
kinda
jail
moved it
food?
around
That
a
is
little
actually a
bit.
pretty good question.
With him in the suitcase still, it was still funny that he was still in the
That's
suitcase.
a pretty good question.
I think he and I were just kind of, couldn't believe that he could fit in the suitcase.
Did you eventually close the top?
Yes, in order for, well, the top was already closed. As he was settling himself in there, that's how I knew he was in there, was because the top was kind of flopping a little bit.
So he had got in there to hide, and he pulled the top
Yes,
on top of it, but you could tell he was in there.
yes,
You saw him right away.
yes,
All right. So at some point, did you zip him up?
yes.
And what was he saying or doing when you were zipping him up?
We just thought it was funny.
Were you both laughing?
Yes,
It's high carb.
And
Okay, fair enough.
so you zipped him up. Were y'all still laughing once you zipped him up?
yes.
Okay. Tell the jury what happened then.
From there, I moved the suitcase around a couple of times, just kind of on the wheels, and moved it around, and at that point, it was funny. We were joking and laughing about it.
All right, now eventually, did you go sit down on the couch and get your phone?
Yes,
I missed something?
well, the suitcase had, from me moving it around, was flopped over. So while it was like that, I thought at that point I had a moment to, I guess, take the time to talk to him while I guess he was not able to get out for a moment.
So you flipped it. You got it on the top, right?
Yeah.
It gets in, but at some point you flip it over so the zipper is on the bottom.
Well, it was just kind of how I was moving it around, and it ended up kind of flopping, so,
But it was upside down.
yes.
So after you did that, what did you do?
That's when I went over and decided to videotape to just see the, I guess, the gist in it, for him to understand that right now I feel safe, and right now I have the ability to actually speak to you in a manner that normally I would not have the ability to do.
And you were intoxicated,
Yes.
and you would agree that you said some things you should not have.
Yes.
Right? But you realized he could not get out and get at you. Is that fair?
At that moment, yes.
So it goes on for about 10 minutes.
Yes.
You heard it here today, did you not?
Yes.
You heard his voice as he was speaking from the suitcase.
Yes.
That was his voice on the video and audio.
Yes.
And you heard your voice on the video and audio.
Yes.
That was your voice.
Yes.
All those things said by the man were said by George in that 2-minute video.
Correct.
All the words said by the female were said by you in that 2-minute video.
What are you trying to prove right now?
Were you intending on showing him the video the next day?
Why are you asking these questions?
Yes.
At the time or the next day, is it fair to say you don't even remember a videotape?
I do not.
So, from what you can tell from watching it, did that refresh your memory about that event?
It did.
And how do you feel now about it, Sarah? Well, okay. Good. Okay, that smile's creeping me out. I don't like it. I don't like it. If she can't remember the video, how could she remember why she made it? It's a good point too. Don't ask questions like that. It's too logical. Don't ask questions. It's just don't ask questions. Just basically at all. Just there's no point in asking questions. Let's just not ask questions. Let's not do that. She looks like Mickey Rourke. Thank you, Liam, for the €2. She looks like the specter that haunts my nightmares. She looks like death incarnate. I'm going to open the door and see her. And then just appear in the afterlife. She looks like she's coming to claim my soul. Shit. She is a cold woman. Cold. Whatever I've done in my life to avoid being with a woman like her, I guess I've done something right in my life. So there are worse fates than being single. The Sarah Boone story. So I may be single, but
Mr. Owens, you may proceed.
It's okay. It could be worse.
All right, I'm talking about just the 2-minute video part that was recorded. Could you just tell the jury what you were feeling, what your feelings were at the time, and then explain that to the jury? You mentioned, you talked about it before. You said he was in that confined space and it was my chance, but do you want to elaborate on that, or?
Sure. I want you all to know that the majority of the time, am always afraid and always scared.
All right. Well, I understand that. Okay, I understand that. But would it be fair to say that you had some anger at that point?
I did.
Would it be fair to say that you wanted to tell him off to some degree?
I just wanted, yes, for him to have a better understanding, which was the whole point of the videos and documentation prior.
And you could tell that he was uncomfortable.
I'm guessing.
And did you want him to feel some uncomfort?
Wow. I'm guessing.
Okay.
Holy shit.
Now, at some point,
holy shit,
you turned off the video.
She's a psychopath.
Yes. And then we saw a second video, which was approximately 11 minutes later. And you've seen that video. It was played to the jury. It was 22 seconds long.
Yes.
Holy shit.
And I don't think you speak in that video. You hear George say Sarah one time.
Yes.
Is that fair to say?
Yes.
So between the 2-minute video and the 22-second video is an 11-minute period. Would you tell the jury what happened?
We continued to, I guess, speak to one another, and his tone changed, and I knew the tone, and we ended up, I guess, arguing back and forth with one another, and was the things that he was saying very much frightened me, and
What did he say?
Cursing at me and threatening me. And
What were the threats?
Did he want you to let him out of the suitcase?
I'm sure so.
Okay, go ahead, tell me your...
And it got very heated very quickly, and he continued to push on the suitcase. And
She's being so
my fear was
abstract.
that he was going to break out
What do
of
you
the
mean it got
suitcase, knowing
heated?
that it was
What do you
a
mean
broken
he made
suitcase.
threats? What did he say?
And,
What do you mean his tone? It's too
His
abstract.
hand started to come through. His hand started to come through.
Use
this
your
way.
words, Sarah.
And so I shook the suitcase. Trying to get his hand to go back in, shaking it, and telling him that, please stop doing this. Please stop doing this to me. Please stop doing this to me.
So his hand actually got out of the suitcase,
Yes,
and you went to the suitcase
yes,
and shook it.
yes,
Did that force his hand to go back in?
no.
So you're shaking it. Were you shaking it to try to get the suitcase, his hand back in?
Yes,
How long did you shake it?
I don't know.
But his hand was still out.
Yes,
Was he trying to get out?
forcefully, yes,
Was he angry at you?
yes.
What did he say?
Were
What
you
did
in
he
fear?
say?
Always.
If he would have gotten
Oh, my
out of the
God.
suitcase, what would he have done to you?
Objection,
Like he used to
speculation.
tell me he probably would have made me unrecognizable,
Oh.
or I would have lost my life.
He said that? What is it? You're saying he said that?
He have done to you?
Like he used to tell me he probably would have
Like
made me
he used to tell me.
unrecognizable,
Like
or
he used to tell me. Did he tell you on this occasion? Holy shit.
I would have lost my life.
Did you lose the grip on the suitcase?
Yes.
Where was the bat in relation to the suitcase?
It was leaning up against the dining room table, right there.
How far was the bat from the suitcase?
3 feet, 2 feet.
Was his hand still out of the suitcase?
Yes.
And was he getting out of the suitcase?
He very much was trying, yes.
And so what did you do?
For the split-second reaction that I had, I happened to see that, and I grabbed the baseball bat and was trying to poke his hand to go back in to please don't break through, please. So I hit his hand.
Oh my God.
Did you hit the outside part of his hand?
Yes,
We've seen the photographs of his left hand. Did you cause the bruising there?
I'm guessing yes.
You're guessing. Fantastic.
Now, you've seen the bat.
My disdain for this woman continues to grow.
A youth bat?
Yes, I bought it for my son.
You bought the baseball bat for your
Is this
son.
bat you used?
I'm not sure he's going to be
Yes.
using it anymore. Not sure he's going to be using it for some t-ball.
You said you poked him with it?
Yes, I kind of pushed, like I held it with the skinny part here and then
So the grip here,
prodded at it, yes.
you grabbed it with both hands here,
Yes,
and then the barrel of the bat, the big part of the bat is here.
correct.
And you thrusted it into the different areas of the suitcase?
I started
Why
with-
don't you just have her get her off the stand? Why don't you just ask her to step into the well and she can demonstrate for us how she used the bat? Why don't you put the murder weapon into her hand, defense lawyer? That'd be really good.
his hand, he was still trying to get out. He was still trying to do that. So I started to push on the suitcase around it, hoping to have his hand retract and go back inside.
You made those injuries.
I did,
We've seen the photographs.
yes,
We see the bruising. Is that from that bat?
yes.
Eventually, did his hand go back inside from you doing?
Yes, finally, he had subsided and retracted his hand.
So in your mind, did you prevent him from attacking you?
Absolutely. Split-second decision.
Now, once he retracted his hand, do you remember zipping it up some, or what did you do in relation? Because he was upside down, was he not, at that point?
Yes,
At some point, you flipped him back up.
I did.
Tell how that happened.
He wasn't cursing, he wasn't threatening, his hand was inside foremost. There was no more of him trying to break through the suitcase. So I felt safe enough to turn it back over. It wasn't happening anymore.
You went back to the video and the couch,
I did, yes.
and we saw the second video,
Yes,
the 22-second, and he's right side up again,
yes,
and you hear him say, "Sarah?"
yes.
Had you left enough room for him to get out? Zipper to zipper.
Yes, that's how his hand was trying.
That suitcase has 2 zippers, doesn't it? And they meet at various places along the line?
Correct.
How much room, when you flipped it over, how much room was between zipper to zipper?
I don't know specifically. I mean, it was enough to where his hand was coming out.
After you had hit him with the bat, was he not trying to get out anymore?
No,
Did you believe that he could breathe in there?
yes,
Did you ever believe he could die in there?
no, at all.
Say
Are
it.
you trying to
Say
kill
the
him?
line, Sarah. Say the
Never.
line. Say the
Did you
line.
want to kill
Say
him?
it.
I did not.
Say the line. Damn it.
Did you walk upstairs?
I did, yes.
Why didn't you let him out before you walked upstairs? Were you afraid?
Terrified is more of the word.
As long as he was in the suitcase, he couldn't harm you.
Correct.
Dude.
When he's,
Dude. Serious.
did you want him to calm down?
What the fuck?
Yes, I wanted him to stop being angry because I know what it is for him to be angry.
You went upstairs. Where were the dogs?
The dogs ran upstairs with me.
And where did they go?
On the bed.
Did you have the phone with you?
As the state, I'd be losing
Yes.
my shit.
I know at some point you called your husband Brian, did you not?
I did.
Do you recall how long that conversation was?
Not very long.
Can you recall what was said?
I don't remember exactly. No, I don't.
Would you like to ask for permission to bring in the battered spouse stuff now? Don't think that's necessarily going to work out for you.
Sarah, you said that when he was in the suitcase, he was threatening her, threatening you. Can you tell the jury what he was saying?
Yes, thank you.
I don't know. Am I allowed to curse?
Yeah. Yes. Yes. If you're quoting it.
But he was going to fucking end me. And that's what made me ask him please to stop doing what he's doing to me. That he was going to, I'm guessing, try his best that night.
You're guessing?
To probably take my life.
You're guessing?
What the threat you heard was
He's going to
Say the
Fucking
word.
and me.
Excuse me?
Fucking and me.
And you?
Yes.
Okay. I'm still not sure it works legally, but at least it's closer. I'm gonna fucking end you.
Judge, can we approach the bench?
Yes.
Yep, now is the time you want to ask for permission to do the stuff. As the state, I'd be having a conniption. I'd be having a conniption on this issue. He said, I'm gonna fucking end you. And I thought, I guessed he was going to hurt me. I thought he said this in the past. It's also vague. He was angry. It's also vague. He was threatening. He was angry. He was this. It's like, it's also vague. The only concrete statement we have is, I'm going to fucking end you. And now that's the overt threat. That's the overt act. I don't know which way, man. I don't know which way to go on that one. I don't know what the judge is going to do. I mean, it is the burden of production. It is the barest minimum thing. It is the least thing. So I might have to allow the defense.
All right, members of the jury, it is 2:14. I have a matter that I have to discuss with counsel at this point in time outside of your presence.
Yeah,
So
we're
I'm
going to have an
asking
argument
retire to
over
the
it.
deliberation room.
We're going to have an
We'll bring you
argument
back
over
in
it.
as promptly as possible. Again, similar instruction that I've given you. Please do not conduct any independent investigation or research as the person, places, things, or charge involved, and do not have any discussions
The
amongst yourselves
only
or anyone else
evidence
about those
of an
things.
overt act
We'll
is,
bring you
I'm
back
going to
in as
fucking
promptly
kill
as
you.
possible. Thank you.
Which incidentally, I'm not even sure qualifies as an overt act in this situation anyway. And the timing is also wrong, and a whole bunch of other things. And so, like, I don't know, ma'am. I don't know. We're gonna have an argument over it. We'll see which way it lands. This should be an interesting legal argument. The defense is going to pin everything they have onto that statement.
Y'all may be seated. Thank you. State, you can proceed with any argument at this point in time.
Judge, I believe that's pretty close to what we already knew from the deposition testimony, from the doctors relaying what she said for the proffer. What we have here is testimony from the defendant. Her timeline is she comes downstairs after having gone up to the shower and hiding, laying down, after being declared to be it. She comes back downstairs, and before she gets back to the bottom of the stairwell, she can see that the victim is in the suitcase trying to get flat because the lid is flopping and he's not hidden just yet. And so she comes over, and I believe she testified she was moving it around before actually zipping the lid shut, but moving it around, everybody's laughing, it's all fun and games still. And then she zips it, and it's still fun and games, and everybody's laughing. And then at this point, she testifies that this is now her opportunity to get on her pulpit to express her true feelings about everything. And that's when she sits down on the couch and opens up her phone device and begins recording what later turns out to be IMG _1062.movie at 11:12:45 for 2 minutes and 3 seconds. During this period of time, the decedent is expressing meekly that he can't breathe. The only time he ever curses at her is, Sarah, I can't fucking breathe, babe, I can't fucking breathe. He is demonstrating under the law that he is in fear of losing his life. She has committed an aggravated assault. She has committed false imprisonment. She was the initial aggressor.
Yep.
There was no overt act
Yep.
to justify these actions that she took
Yep.
against her boyfriend. She then goes on to say that during this period of time between the end of the movie at 11:14:48 seconds and before the next one starts at 11:23, that it's now at this time, while he's still constrained and clearly unable to get out under his own power despite having his hand out, she begins beating him with a bat, poking his hands, poking the suitcase with a deadly weapon. A bat is used for baseball, but it can also be used to harm another person. And according to the medical examiner's testimony, there was great harm caused to him, deep ecchymosis bruises. She can't start to do this out of fear, like the analogy I gave earlier. If I pull a gun to rob you, Judge, and you pull a gun, I can't shoot you in self-defense. She started this. She started this. There is no overt act, and therefore, we're asking for you to prevent, under the case law, any prior instances of violence, any reputation evidence, and any battered spouse syndrome evidence, because that's simply just what the case ended up being. Thank you.
Response.
It's a pretty good argument. It's a pretty good argument.
Judge, this was a game by two intoxicated people. When people are drunk and intoxicated, they do silly and stupid things. The evidence is uncontroverted that Jorge Torres willingly, by his own choice, elected to hide in the suitcase. By their interaction between the two of them, giggling and laughing at each other, he consented to her zipping up the suitcase.
Okay.
And the playful nature of what was going on during those few minutes prior to the video.
Okay.
When the video is turned on, there's a 2-minute period where they're talking. He's saying, I need to get out, I can't breathe. She's not taking him seriously. As you've seen from the videos, I thought it was the boy crying wolf. She did not appreciate the fact that he could be actually having trouble breathing. And this was a chance for him to be heard by her about how she felt about some things involving their relationship.
He had it coming. He had it coming.
Short time later, the
he
video
had
was
only
turned
himself
off,
to
and then
blame.
that period
If you
has
had been there,
testified to by my
if you
client.
had seen it,
And that
I
period
bet
is
you'd done
uncontroverted.
the
That's a
same.
second period of time. We've got that time for the video. We got the 11 minutes. We got the 22 seconds. And there's no video, there's no audio, there's no eyewitness, there's nothing but Sarah Boone's testimony. And she's testified here today that they had words, there were threats. He got his hand out of the suitcase. She knew by the threats and him getting his hand out of the suitcase that he was about to get out of the suitcase and he was going to hurt her. A reasonable person under that scenario would believe she was about to be harmed. She was an imminent threat of harm.
Do it. Oh, Judge. Do it. Oh, this is such a big balls move by the judge if he rules against her. This is such big balls. Okay, Judge, just how big are your balls? How big are your balls, sir? If you rule against her, you've got massive huevos.
She blocked that attack by grabbing the bat, hitting his hand. When that didn't work, she started poking him with the bat and the suitcase. Eventually, she poked him several times. He put his hand inside the suitcase. She put the bat up. When she realized he was not going to do that any further, she flipped him over right side up. She still had a fear, knowing that if he got out, she would be harmed. He would beat her up. She went upstairs. That is an overt act based on the discussions, coupled with the fact that he threatened her, using the word, I'm fucking end it for you, or some words to that effect. I don't remember her exact words, just before she went upstairs while he was still in the suitcase. If she would have let him out, and this is a crime, now this is an event involving an omission, failure to act, failure to unzip him at that point.
No, it's a little bit more than that.
Before she went upstairs. The
little bit
failure
more
to
than
act,
that.
the failure to unzip, which would have let him out, which would have...
A little bit more than failure to act, sir. First of all, failure to act might be sufficient. Second of all, it's a little bit more than that.
created a situation that she believed was imminent bodily harm to herself.
Yeah, but it has to be.
And I guess I'll get a couple of examples. Let's say that a police officer is called to a scene and the only thing he hears is there is a suspect and the suspect may be armed. So of course the officer pulls out his revolver and he's walking around. Well, then eventually he finds the suspect and the suspect reaches for his waist. The officer doesn't see the gun, but the officer sees the movement to the waist. The officer fires and shoots the suspect. The officer is justified because there's an immediate threat of harm. The officer has to react instinctively. There's no time to think. Similar to the actions that Sarah Boone had to take.
I'm sorry. I'm sorry. Did you just compare Sarah Boone to an officer on the beat? Wow.
Another example, you're in a bar with your buddies and you've had something to drink and another group has had something to drink and one of your buddies gets into an argument with one of the buddies on the other party. And one of your friends, seeing that it's being escalated and the guy that's arguing with your buddy is aggressive, more aggressive than your buddy is. Your buddy's trying to settle the thing, but this other individual, maybe he's had too much to drink and he's more aggressive. So you go around behind this individual, and before he's able to strike your buddy, you grab him.
Okay, that would be assault. That would be assault. You've just done a bar fight. You're going to jail. He's using this as a positive example. This guy was being escalating towards my friend. He was being loud and belligerent. So I got from behind him and I grabbed him from behind. It was self-defense, Your Honor. What?
You lock him up. That's physical restraint to block an attack. Or you grab him by the neck.
What?
And you choke him.
This
physical restraint to block an attack.
This isn't legal, sir. You're not allowed to do that, sir.
That's what she was doing with the suitcase.
What are you talking
if she
about?
let him out of the suitcase, she was going to be harmed based on him trying to get out.
That's not legal.
Hand, based
you can't
on the
do
threats
that.
he made while he had his hand out, and based on the threats he made while he had his hand inside just before she went upstairs. Thank you.
Thank you. Court's going to review all the case law that it's obtained in its research in this matter and come back with an oral ruling momentarily. Thank you.
Big balls. Big balls. He's thinking about it. He's thinking about it. If the judge rules against Sarah Boone, it will be the biggest balls I've seen of a judge maybe we've ever seen. This is a big boy ruling. This is a big boy ruling. Because he's potentially about to deny her a defense. He's about to deny her a defense. And if he's wrong, it's reversal every day of the week, right? So it's a big boy balls decision. He is basically throwing his balls right down on the Court of Appeals table and saying, what do you think of this? It's a big boy ruling. And if he does it, massive huevos. Massive huevos. Whew. He's thinking about it. Holy shit. Yeah. 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 He probably won't do it. He probably won't. Because that is such a big boy decision. That is some massive huevos. You are just writing the defendant's appeal for them. You are writing their appeal for them. You got to be right. You got to be right. Big balls. Big balls. And right, she wouldn't have any defense then. Correct. She wouldn't have any defense then. Correct. The only thing the defense could do at that point is try to transition to accident. But they have no other witnesses. They can't call any of their experts. They can't call any of their experts. They can't call any of their witnesses. They can't recall any other witnesses. They have no defense. You basically denied them any defense. So I mean, that's a big boy. That's a big boy decision. That's big ball. That's a big ball decision. Big ballin'. See, in my Air Force One, big ballin'. That means the defense case is over. It means the jury gets the case. It means we get a conviction. It means we get sentenced to 40 years. And then we're off to the Court of Appeals about it. We'll see. That is a tough decision as a judge. That is a tough decision. I'll tell you what. I don't know if I would have balls to do that. I don't know if I'd have balls to do that because I know I'm putting my balls right on the line. I don't know if I'd have the balls to do it. It is such a big boy decision. But I think it would be correct. I think it would be correct being the operative words. I think it would be correct. But am I willing to go toe-to-toe with the Court of Appeals on this? Tough decision. Tough decision. We'll see. Will this attorney do the appeal? Probably not. Usually it's someone different. It could be, but usually not. Usually it's an appellate specialist. Usually people prefer one or the other. So it could be the same attorney, obviously, but usually not. Usually it's an appellate specialist. Not for the least of reasons that, you might want to bring in an effective assistance counsel defense, and you really can't do that if you're the guy who brought it to trial, right? Because then you're arguing against yourself, and that's always problematic at best. Yeah. This is like, what do I think the right decision is? I think the right decision is to deny the defense. I think the right decision is to deny the defense because Sarah Boone is the first bad actor. That's what it comes down to, right? Sarah Boone is the one that flipped it over. Sarah Boone's the one that used a baseball bat. Sarah Boone's the one who committed the forcible felonies. And the prosecution's right? You can't antagonize the action to give self-defense. You can't invite the action that gives you the right of self-defense. You can't instigate it. Incidentally, like we've seen this in other contexts, there was a case, I think it was in Chicago once, I don't think we saw it, but there was a case once where there was a guy in like a bar fight kind of situation. And he was not the initial antagonist. But he left the bar to grab a shotgun and then went back into the bar. And so having fled, he has now re-entered the scene. And so you can't do that, right? They didn't follow him out. If they had followed him out, different story. But he re-entered the fight. He re-engaged. So even though in the first instance, he was the innocent in the first instance, once he left and came back in, right, then he's no longer the innocent. Now he's the one engaging. You can't do that. So, we've definitely seen situations like that before. But But yeah, you can't. And take your swing. Take your swing was a great example. Take your swing, right at the mattress with the guy with the father. Take your swing, and then he took his swing, and then the guy shot him. You can't do that. You can't invite the conflict that then gives you the right for self-defense. You can't be the initial antagonist. That would be really dumb if you could, right? If you could bootstrap yourself into a self-defense case, that'd be really, really dumb. Now you've just legalized murder, right? That'd be really, really dumb. You've just legalized murder if you could bootstrap it. So obviously you can't do that. So I think the right ruling is to deny it based on the fact that she's the initial antagonist, and therefore she can't claim self-defense. I think is the right call. But would I do it? Would I do it? I don't know, man. I don't know. It's a tough call. It's a lot, it's a lot to do. It's a lot. It's a big boy call. Because the defense is entitled to any defense that's cognizable at law. They're entitled to any defense cognizable at law. You know that if they have even a chinchilla of evidence, they're allowed to present the defense. And so you're saying they don't even have a chinchilla's worth. Woof. Tough decision. Kirk Grossum, just telling you, man, it's tough. It's tough, man. You want to get the law right, and you don't really want to be reversed on something like that. I don't necessarily want to have this trial again. I don't want to be embarrassed by the Court of Appeals. The safer thing is to let her offer the defense. If she's convicted anyway, then, fine. That's the safer thing to do. Judges have to worry about, and they have to worry about how it looks on their record. They have to worry about what it might mean for their next job. They have to worry about a lot of things. If they're elected, they even have to worry about how it looks to the public. So there's a lot of considerations, man. It's tough. It's a tough position to be in. It's as tough as being locked in a suitcase. But you're writing the defense's appeal for them. You're writing the defense's appeal for them. So you better be right. You better be right. It's obvious if it's wrong. It's clear. It's obvious abuse. It's an obvious abuse of discretion, obvious clear error argument. You're just begging to be clear error, abuse of discretion. You're begging. You're doing, arms wide. Come at me, bro. Come at me. Yeah. We'll see which way he wants to go. If he says no, I wouldn't be surprised. If he rules against it, I wouldn't be surprised. It's safer. But if he rules against Sarah, massive huevos. And it's the end of the defense, because there's no other defense. There's no defense. So, yeah. And the judge did warn them. The judge warned them multiple times, by the way. The judge let them know that this was going to happen. So they've been warned. They've been warned. So we shall see. The best we could do was one statement of, I'm going to kill you while he's already in the suitcase. That's the best we could do. Yeah. Yeah, the chinchilla of evidence indeed. This is. All right, here we go. Which way you want to go, sir?
All right, we're back on the record. State of Florida versus Sarah Boone, case number 2020 CF 2603. Appearances for the state.
Chief Judge Shore on behalf of the state. William K. the state.
Defense.
James Owens for Miss Boone.
Connie Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
Ms. Boone is currently seated at counsel's table, wearing the same clothing from this morning. The court has had the opportunity to review the case law, review the arguments provided by both the state and the defense. The court finds that a overt act has been established. The case law is clear that a scintilla of the providing of an overt act is sufficient to provide the self-defense jury instruction. An overt act is not something that's specifically defined in Florida case law. It's something that's from the totality of the circumstances, seemingly under the authorities that the court has reviewed. As such, the court is going to find that under Holland, a overt act has been established and will allow the defense to proceed with evidence of reputation and specific instances of conduct and battered spouse evidence, so long as the necessary predicates are established for those items. Any questions or clarifications with regard to the court's order, state?
Yes.
Defense.
I think it would help if we went through my exhibits involving the blow-up photographs and these other photographs, because I think some of it was contingent on the court's ruling. So I don't
I'm
know if
not
you
surprised.
try to deal
I'm
with
not
all
surprised.
of them one time in front of the jury, or whether we want to just talk about them ahead of time.
That
so
is,
we know.
yeah, I'm not
Are there any
surprised.
objections to those items?
It was far, far safer
And
to
the
say.
items, I've shown a lot
It was
of
far,
different
far
things,
safer to say.
including like a rap sheet.
Disappointed.
The victim and the defendant stuff.
I've taken that.
We need to, I'm happy to take care of some of this stuff in advance.
I'd rather do it now.
Yes.
So that it's not up, down, in and out with the jury.
So,
All right, go ahead, Mr. Owens. What do we got?
Well, I had the clerk go ahead and mark everything. Some of it is a composite. Is this it here? This first is identification, defense identification K. It's 4 pictures involving injuries to the leg.
Mr. Owens left what?
The leg.
assuming a predicate for fair and accurate conviction, etc. is laid, we don't have any specific objections to K.
Okay.
Beta. Judge Beta.
Defense identification composite L, 2 photographs of a burn to her leg.
You said that was L, correct?
Yes.
Again, assuming proper testimony that the decedent was responsible for that in a criminal manner and fair and accurate conviction, we have no specific objection at this time.
Okay.
Defense exhibit M, for identification. 2 photographs. The first one is a photograph of the back porch. Sarah's on the back porch with her 2 dogs.
Does this have precedent? No.
Next photograph is a picture of one of her dogs on one of the outdoor couches. Judge, relevance is that he would threaten the dogs.
No new law. No new law being created today.
She didn't comply with his directives, and he actually harmed the dogs, kicked the dogs as a threat to her. So to get her to do what he wanted, he used the dogs.
Hey, for the 600 of you currently watching, thank you very much for joining me for a while. Really appreciate you choosing Uncivil Law. You have your choice of legal commentary channels, and I'm happy that you chose mine. You're the best. We love you. Thank you for joining. Just a friendly reminder, by the way, it is only 99 cents a month to join. We have the lowest memberships on YouTube. Period. No one is cheaper than us. 99 cents a month to join. If you hit that beautiful, beautiful join button. For your join button, you get access to some cool, you get your name in green. You get some cool scales by your name. You get access to behind the scenes content, such as recording and editing streams. Also, you get some off-brand content, such as gaming streams, stuff like that. You also You also gain access to some nice emojis. Plus, you help feed an uncivil for another day. So please hit that beautiful, beautiful join button today. And if you've already hit the beautiful, beautiful join button, I'd remind you that there are higher membership tiers available. You could join at the $5.99 tier or beyond.
Thank you.
And it's all appreciated. Thank you very much.
There's a short video on
It's on the State's Exhibit 2, we're not going to object to that, as long as it's foundation.
No objection so long as foundation is established.
P, identification, defense identification P, is 2 photographs of an incident in which...
No objection, as long as foundation is laid, etc.
All right, no objection so long as appropriate predicate is established.
Now, these next ones are individual photographs. not
Thank you,
pop-
Snackless Sarah, for the 5 gift memberships. Always
Identification
appreciate
is
it.
1 photograph.
Is that part of the right stuff that we already done?
I was told this was separate from the burn. So this was, I think, a slap or something, or a hand to the leg, not for the burn.
Okay. No objection, foundation is laid.
With regard to Q, no objection so long as the appropriate foundation is laid.
Identification R,
No objection, as long as foundation laid.
No objection to R so long as foundation is laid.
S,
Same for S.
for identification.
With regard to S, no objection so long as foundation is laid.
Same for T.
T,
No objection by the state so long as appropriate foundation is laid.
Same for U.
No objection from the state so long as appropriate foundation is laid for U. Same for V.
Same for W.
W.
Same for X.
X.
Same for Y.
Y.
that's all.
It's one of the other, oh, go ahead and say
A, identification for A.
Were these the ones that we addressed pre-trial?
Yes.
Okay, thank you.
No problem with that being a demonstrative aid.
Okay.
In terms of introducing this as an exhibit into evidence,
Duplicative, competitive.
Is it contained in K through Y?
Yes.
Then, is that accurate?
I believe so. I mean, I know the clerk probably doesn't want the blow up, but
If it's contained,
it's going to be easier to handle, the clerk to handle the 8.5 by 11.
if it's, I'll allow you to use it for demonstrative purposes, but I'm not going to accept it into evidence as it is duplicative of what's already in evidence as X, defense pre-marked X.
And then identification C.
Same thing, same photographs.
That was either, it was one of the earlier ones we addressed. M or N was the staircase.
And
Okay, for the same reasons, you can utilize it for demonstrative purposes, but it's duplicative as the exhibit itself will be entered into evidence, presumably.
D, identification.
same thing, it's one of the photographs and it's on the state's digital exhibit.
Any disagreement that it's included in your pre-marked?
I agree.
Okay, then same ruling. It is duplicative. You can utilize it for demonstrative purposes.
Identification E.
Same thing.
Is it included, sir, in K through Y?
Yes.
Then for the same reasons, it's duplicative. You can utilize it for demonstrative purposes only.
F for identification.
Same thing.
It's included in your submittals?
Yes.
All right, same ruling. It's duplicative. You can utilize it for demonstrative purposes, but it will not be accepted into evidence.
Identification G.
Big ass photographs, man.
Is it included in your submittals, sir?
Yes.
All right, for the same reasons, I find it's duplicative. You can utilize it for demonstrative purposes, but not seeking it into evidence.
H.
Same thing?
Yes.
Same ruling. You can use it for demonstrative purposes, but it will not be received into evidence by virtue of it being duplicative.
Identification I.
Same as T.
Any disagreement with that, sir?
No, sir.
Same ruling. If my court finds it's duplicative, you can utilize it for demonstrative purposes.
Identification. Madam Clerk.
Hang on, is that the house?
It's either Delta or B.
I think that's Bravo. It's at the defendant on the porch with the 2 dogs?
Yes.
That was pre-marked before trial as Bravo.
That a B?
That's a B.
Same.
Same.
It was as defense M. Relevancy objection is overruled, but I'm not going to allow the enlargement as it's duplicative, as the native photo is in evidence. But you can use it for demonstrative
Yeah, I
purposes.
probably want to use these in closing and just use this, use that for the...
However you see fit, sir.
Okay, this is not working today?
I can't speak to that. I don't know that anybody today has utilized it.
I know
But that's not connected to the overhead. That's separate and apart from the overhead.
Okay, okay. Judge, what other evidence do we have? Body cams? Excuse me? Nothing else? Nothing else through Sarah. There may be some body cam footage to refresh memories. We've got 2 deputies out there.
Okay. All right. Any other exhibits with regard to Ms. Boone at this point in time, Mr. Owens?
No, sir.
State any reason why we cannot ask Ms. Owens or Mr. Owens to continue his inquiry of Ms. Boone and have her return to the witness stand.
Yes, sir.
All right. Mr. Owens, anything else we need to discuss, sir?
One moment.
Sure.
I have pictures blown up. Stylistic reasons. I think personally it's probably more effective having a physical exhibit than it blown up on the projector, personally. It's worth it. It's more effective. Really critical evidence to have as a blown up physical
Okay.
thing.
If we can bring Ms. Boone back up to the witness stand, once she is seated, we can bring back in our panel. Let's go ahead and stand and bring back in our panel.
Now, I feel like we're muddying the waters now. You know, I think her odds of getting acquitted go up, to be honest. Because it's like, if we can show her she's a victim of domestic violence, it's like, you know, I don't really think that has much to do with the price of tea in China, but, you know, it is what it is. You know, whether or not she was a victim of domestic violence in the past is really much not to do with the moment in question, really. So, it's frustrating.
State, you recognize our jury?
Yes, sir.
Defense, you recognize our jury?
Yes.
All right, thank you. All can be seated. Members of the jury, again, you could, once seated, raise your hands to confirm that you complied with the court's instructions during our last break. Record reflect all hands have been raised. Mr. Owens, you may continue with your inquiry, sir.
Thank you, Judge.
On the plus side, it means more trial for us to cover, so that's nice. More content for us, so that's nice, I guess.
Ms. Boone, so I think we left off. You had called your ex-husband?
Yes.
All right. After you called your ex-husband, what happened after that?
I ended up falling asleep.
Okay. Do you remember waking up the next morning?
Yes.
Did you sleep in?
Not intentionally.
Okay. But you didn't get up at 8 o'clock, did you?
No.
Have you ever gone up
Did
at
you
8
wake
o'clock?
up closer to noon?
I believe so, yes.
Did you check the time?
No.
Now, did you hear your phone ringing?
Yes, my phone was ringing.
And did you answer it right away?
No.
Do you know approximately how many times it rang before you answered it?
I believe the call was about 3 times.
Did you know who was calling?
I figured it was my ex-husband.
And why would he be calling?
To make sure that I was still on schedule to pick up our son.
At 3 that afternoon?
Correct.
And he goes to school there close by?
Yes.
All right. When you woke up, did you stay in bed for a while?
For a little while, yes.
All right, tell the jury what happened when you got up.
I knew it was my ex-husband calling repeatedly. I didn't answer right away because one of our problems is that he doesn't understand that I'm doing things around the apartment and looking for jobs and so on and so forth. So I inevitably just let it ring, and I laid in the bed, and I figured that George was downstairs either drinking or looking for jobs, or may have just left. And so eventually I decided to get out of the bed and start moving to go downstairs. I was motivated enough to go downstairs, and when I went downstairs, it was very quiet. So I had the understanding, I believed that he had left. And
Did you check to see if he was, where would he be looking for a job at?
Usually on the couch. He would have my son's laptop, and he and I, which we would share.
Y'all only have the son's laptop?
Correct.
And the TV was not working at this time?
The TV was not there.
Okay. So you thought he would be in the living room on the laptop?
Yes.
He was not there?
No.
Where else did you look for him?
I looked on the back porch. I went through the front door to see if my car was there, thinking maybe he had taken my car. I checked the bathroom, and when I was checking the bathroom, I saw the suitcase, and I remembered about the night prior, and I unzipped the suitcase and...
Let me stop you there. You said you were in the bathroom when you saw the suitcase, or coming out of the bathroom?
No, where our bathroom is, I would have to go to the bathroom here, and then when I turned around, I noticed the suitcase, and I remembered.
How did you feel when you saw the suitcase?
I don't think I've ever experienced anything like that before.
Describe it for the jury.
I guess it was... I was aghast, and I just can't describe the feeling.
Bless you.
It was terror to
Bless you.
a certain degree.
I'm sorry, say that again now.
It was terror to a certain degree. I just can't describe it in words, the feeling. of remembering. And then he was still in there.
So what did you do?
I immediately unzipped the suitcase, and I was screaming, "George, George, George," and I was shaking him, and I pulled him out, and I stretched him out flat, and then I began instantly trying to do CPR, and then was trying to look for a pulse or a breath or just anything, and was just screaming his name over and over and over again, and come on, George, and I continued CPR, and I continued CPR, and he was gurgling, and...
What color was he?
What color was he?
Yes.
He was purple.
At some
Purple
point,
mean
did you
dead.
call your ex-husband?
Yes, when he started to gurgle, and I knew that my ex-husband is notorious for bringing my son over in very inopportune times when George is possibly drunk or doing things not appropriate for my son to see. And I just didn't know what to do. It was just a quick knee-jerk reaction. Ryan was kind of my go-to person because of my family being deceased, and I don't have anyone else that I can call. And I just wanted to ensure that he would not bring my son over in the process of all of this at some point.
So you called him?
I called him.
Did you ask him what to do? Or did you just tell him to come over?
I just told him to come over.
Did you tell him that you felt like George was dead?
Yes, I did.
And how far? You said it's 5 minutes from house to house?
Yes.
Did you call him back?
Yes, because he was taking so long. It felt the seconds were hours. Yes. I'm still doing CPR at the same time in the process of it. I'm doing CPR I don't know how many times.
Did he get there?
Yes.
Did he walk in?
Yes.
Did he walk out?
Yes.
What did he tell you to do?
Call 911.
What did you do?
I called 911.
Is that the recording we've heard here in this trial?
Yes.
Did you love George?
To this day.
Oh, nice.
Why did you love him?
George was very passionate. George was a very real person. George was nice to me
You know,
on the good days.
normally when someone says
George
someone's a real
complimented me.
person, I don't think it means much, but on this occasion, I feel like it does.
George and I were two bodies with one soul, he and I would always say. I don't believe that I've ever had a connection with anyone like I have with George.
Did you have that connection with your ex-husband?
I did not.
Was it even close?
No.
George has some good traits, doesn't he?
Very much.
Did George have some bad traits?
He did.
Did you drink too much?
I did.
Did George drink too much?
Yes.
Tell the jury about George's drinking.
If George was able to, he would drink from sunup to sundown. And me having my son and trying to work and maintain the home and just have a life, a normal life as best as I could, somehow that upset George. And because I had a certain dollar amount from my divorce settlement, at one point it was from wine we could afford vodka, so a lot of the times he would take my card, my debit card, and go buy the large, we call them handles, of vodka, which is the big bottle. And sometimes he would finish that all off on his own throughout an entire period of a day into an evening. That's honestly where I thought that he was going to be that morning when I came downstairs, because he's notorious for just automatically already being outside from drinking all the time.
All right. And you said you have an alcohol problem. George has an alcohol problem.
Yes.
How did George's drinking adversely affect you?
It would debilitate my ability to help him the way that I was always trying to help him, because it would be one good day, a day of survival, and then it would be another day where I'm having to peel him off of me and call 911.
Why would he get that way? Tell us his pattern as it relates to drinking and then...
Judge, object.
Approach.
Well, we're now going to spend our time slandering the dead, I guess. Although, strictly speaking, you can't slander the dead, but I digress. This is very disturbing. This is pretty messed up. I'm not a happy camper. Yeah, she's read a DV handbook or two. She knows the cliche things to say. She's read a book or two. She knows the words. Yep. Women can lie about being victims. I know. Apparently this is a shock to some people, but women can in fact lie and exaggerate and be the devil incarnate. You know, on a personal level, I don't know what separates this case from, like, in terms of, what would I say? In terms of people's reaction to me, for example. What separates this case from, like, that ballerina case that we were covering, where the ballerina killed her husband, I believe it was, by shooting him in the bedroom. And I'm like, I don't believe this bullshit. And some people in another creator's chat got really, really mad at me. They got really, really mad at me for, like, mocking her and insulting her and degrading her, because I don't believe her. I don't believe she's a victim. I don't believe her. I don't believe Sarah Boone's either, so I mock the shit out of her too. So I'm not sure what the difference is, other than, you know, some people believe that woman and don't believe her. So I guess it's based on your own perceptions about whether or not you believe she's a victim, whether or not my commentary is okay or not. You know, my commentary mocking her is okay if you agree with me that she's not a victim, but not if you disagree with me, I guess. I don't know. There's something in there that's annoying. Yeah, and I stand by my opinion. I stand by my opinion. I think that woman was lying. I don't think that she was in threat. I think she's guilty. I stand by my opinion. So
Objection's overruled for now.
Really.
Y'all were together 3.5 years?
Yes.
Is there times when he would get to a state of intoxication where he would get violent against you?
Quite often.
Judge, can I approach the witness?
And
Yes.
there probably is some
As long as you
modicum
show it
of
to the
truth
state
in
first,
there.
please.
There probably is some modicum of truth in it, but it's just exaggerated. And even if it's true, I don't think she was justified in the moment. I don't think she was justifying the memo. So it's like, you know, and I think she's the devil.
I'm going to show you defense exhibit for identification P.
But maybe my mind will change. Maybe the defense will put on some really compelling evidence. I'll be like, wow, I didn't know the half of it. Maybe I'll wind up apologizing to Sarah Boone. Who knows? We'll see.
Those two pictures of your body,
Yes,
did they show injuries to your body?
yes,
Were those injuries caused by Jorge Torres?
yes,
Are those photographs a fair and accurate depiction of the injuries you sustained at the hands of Jorge Torres?
on this occurrence, yes.
Do you remember this occurrence?
I don't, it was so often.
You don't remember a specific date,
I don't,
but you're sure that that's you?
yes.
Is that the injuries that he... What's the injury to the rib cage?
I don't remember specifically. These may be the pictures. So, when we used to go over to his brother's house, one of his brothers and his...
Objection. Non-responsive.
Sustained.
You don't have to answer the question. Ms. Boone. Do you know what happened to... Did George cause these injuries?
Yes,
All right. Were y'all both drinking at that time?
I don't remember on this instance.
Okay. Judge, I'd like to move this exhibit into evidence.
Okay.
All right, what was pre-marked as P will be received into evidence without objection as Defense Exhibit 2.
I'm not sure I know how I heard this.
Mr. Owens, may I give Mr. Tackett just a number, please? Thank you.
Mr. J, would you be so kind? Thank you.
And I need to ask permission to publish it.
Yes, sir.
Mr. Henderson.
You may do so.
And, this is magnified, Judge. So
Looks like I think there's a wheel on the top where you can use to, there you go.
Ms. Boone, is that you?
Yes,
Are those injuries to your arm?
yes,
Were they caused by Jorge Torres?
yes,
And during the same incident, is this you?
yes,
Is that an injury or bruise to your ribcage area
yes,
and your arm?
yes.
And also, she still wants it both ways. She both wants it to be an accident and self-defense, which is a very odd thing to try to do.
I'll show
Is she
you
trying to argue in the alternative?
defense identification.
Is she trying to argue
You
both? I
recognize
guess.
that photograph?
I don't know.
Yes,
Is that your thigh?
yes,
Okay, do you remember this incident?
yes.
Can you tell the jury what happened?
I wanted to take my dogs for a walk and get off of the back porch.
Were y'all drinking?
Yes. And he was upset that I would rather go walk my dogs than sit there and continue to drink. So he slapped my thigh as hard as he possibly could and said that you're not going anywhere. And it was a good smack on my thigh.
Is that a fair and accurate depiction of the wound that you suffered?
I'd like to
as
give
a
her a
result
good smack
of
upside
Jorge
her
Torres
head. I don't
slapping
know
you
if
on
that
the
means
thigh?
on
Yes.
anything, but
Judge, I'd like to offer Q in evidence.
No objection.
What was pre-marked as Q will be received into evidence without objection as Defense 3.
Judge, can I publish?
You may, sir.
yeah, it'd be pretty hard to be both self-defense and accident at the same time. That doesn't really make sense. I don't know if she's trying to argue it in the alternative. I don't know if she's trying to have it both ways. I don't know what's going on.
I'm going to show you identification, defense identification S. See if you recognize that photograph.
I do.
Is that your hand?
Yes.
Is that your blood on your hand?
Yes, it is.
Is that you standing, looks like in a room with flip-flops?
This is in the kitchen at Brian's house.
Okay, what happened there?
So George was very drunk, and I wanted to leave, and he's notorious for taking my car keys and putting them around his neck and my phone in his crotch area and telling me to come get them. And I really wanted to leave because of how drunk, and I knew the escalation of his anger. I didn't want to be there when it was at its peak. So I tried to take my keys from around him because he kept taunting me to take my keys, come get your keys. And so I attempted to go and get my keys. And so he ended up getting a butcher knife. And I had an opportunity to call Brian to come and help me, to please come pick me up, to come get me. And of course, he brings my son with him. And so I'm in the parking lot asking Brian to please help me get my car keys away from him, and there's neighbors, and it's a scene at this point. And George comes to the doorway of my townhome wielding the butcher knife, saying that, do I curse?
Yeah.
That no one's going to take her fucking keys, no one's gonna fucking come into this house, and he's waving the butcher knife. And I walked up to him, and I just wanted to leave, and my little son, who was, I believe, 7 or 8 at the time, just is screaming, give mommy her keys, give mommy her keys, let her leave. Brian was even trying to negotiate with him, saying, please, you know she'll come back, just let her leave. So I went up to try and take the keys from him, and he was pulling on them, and I ended up pulling harder, and he pulled them back again to try to pull me in the house, and I pulled them even harder, and it ripped my finger. And at one point, I had lost the fingernail, and the tip of my pinky was severely gashed.
Yeah, the state called the ex-husband. We heard from him.
Okay.
What was it pre-marked as, Counselor?
Looks like S, but not a quarter man.
What was pre-marked
He was a
as
very nice
defense
guy.
S will be received into evidence without objection as
Very
defense
nice
4.
guy.
Ms. Boone, for the jury's sake, is this the picture you're referring to? Is that the nail?
Will state be able to recall her ex-husband?
I believe so, yes.
I think so. They want to. I'm not sure what the state intends for rebuttal.
Composite identification L, 2 photographs. Can you look at those photographs?
Taking her keys might have not been abuse. It might be because she was drunk. That's fair, too. Yeah, that's a fair point.
I wanted to eat, and while he was drinking, went and made myself, as quickly as I possibly could, a microwave bowl of, I believe it was broccoli and cheddar soup. And I
Good call.
didn't
I like
get
broccoli
it
and cheddar
out
soup.
enough time, and he came up behind me and he slapped it out of my hand. And it was a 2nd-degree burn. I went to the hospital for it.
Are those fair and accurate depictions of the injury, the burn to your thigh?
Yes.
We'd like to offer identification L in evidence.
No objection.
What was pre-marked as L will be received into evidence without objection as defense 5.
Permission.
Yes, sir.
You had to go to the hospital as a result of these injuries to your thigh?
Yes. It was
Okay.
extremely painful.
Is that a depiction of the burn?
Yes.
Is that your thigh?
Oh my God, yes.
And your knee?
Yes.
It's all right, I'm showing you.
The ex-husband was not asked about the beating stories because the predicate hadn't been established yet.
Did you look at those all four before?
The
commenting?
defense might wind up calling the ex-husband. We'll see. They kept him on.
This is a longer story,
they
isn't
kept
it?
him on.
Go ahead and tell.
How do you know George did
So-
this? If you believe her, that's how you know.
George stabbed me in my leg. I almost bled to death.
All right, well, let's go back.
She is providing testimony. She is providing evidence in the form of testimony.
I
So
thought it would be nice
You-
to cook a nice
you
steak
can-
dinner.
you can
We
decide
don't
whether or not to
have two
believe her
nipples
or
put
not.
Together, so I thought it would be special to make a steak dinner and baked potato and go above the normal whatever's left over in the refrigerator. And so I spent a lot of time doing that, and George is drinking the entire time and on the back porch.
You were drinking as well, were you not?
I was drinking. He was on the back porch while I was in the house and I was cooking. And it was one of those where maybe if I start making dinner now, it will be over at a particular time and we can go to bed at a reasonable time. And I even put it in the bedroom and had a movie set up for us to watch. So it would
What
just
movie?
kind of be dinner in bed. And then he came upstairs and saw that I had made the steak dinner, and I don't know how to describe how drunk he was, but it definitely was not George. And had him come lay on the bed, sit on the bed, and, you know, put the, I got the dogs out, and I presented him with the steak dinner and sat down and was getting ready to start playing the movie. And he starts being very rude and cursing the steak and finding fault with it. And then, you know, I'm having to encourage him to eat. You know, if you want me to cut it up for you, I will cut it up for you. Did you want some more sour cream for your potato? What can I do to make you happier? And then he started to pull on me and kept saying that, excuse me, that I just want to fuck you on the steak and fuck you on the potatoes. And I took offense to that, and I kept trying to
Okay.
encourage him to eat. I started to
Was
eat.
this just him really drunk and saying,
I mean, you really should not mix those things. I mean, those are both very enjoyable experiences, but I wouldn't necessarily recommend trying to do it both at the same time. That seems a little much to me, but you know, okay, I shouldn't yuck someone else's yum, I guess.
nonsense?
Don't play with your food, my mom said. That's all I'm
I don't know why
saying.
he was so angry that day. I don't know if it's because I got steak. I don't know. Most of the time, I don't know the reason why. I couldn't take it anymore. Obviously, I was not going to be able to eat, so I started to crawl off of the bed to leave, just the bedroom. And he told me again that I'm not going anywhere, and he stabbed me in my leg, and it crunched. You could hear a noise that it made, and blood just started to come out of my leg just like a fountain. So I got off of the bed. He's starting to freak out and grabbed me a towel. I got a wet towel, and I'm sitting here holding the towel, and it's increasingly becoming even more and more saturated by the minute. It's just minutes. So I'm going through towels and towels, and I said, George, I think I need to go to the hospital. This is not stopping to bleed. This is serious. And he got on his knees and begged me, please don't call the police. Please don't call the police. Please don't call the police. And inevitably, he went and got my car keys and put them around his neck again, and my cell phone. So I was not able to call anyone, and I wasn't able to leave in my car. So I figured I would just go downstairs, and I'm just going to go downstairs. And I had propped my foot up on the glass table that we had, and blood is just everywhere. Blood is everywhere. I can't keep up with the amount of blood, and I'm starting to feel very weak and really weird. And he comes downstairs and he's still begging me, please don't call 911, please don't call 911. I kept telling him, there's something, this is serious, this is something. Because he knew that he would probably get arrested or something bad would happen to him. So I couldn't take him anymore. He was just all over me and just, I'm bleeding. I'm bleeding very badly, and he's having me try to console him. And I kept telling him, please, I need to call 911, please. And I said, okay, just give me a moment. And I crawled upstairs to my son's bathroom, which is the furthest bathroom away from everything. And I remember holding onto the sink. And I looked into the mirror and my lips were blue. And I knew I needed help. I needed help. And he came upstairs looking frantic for me, calling my name. And then I turned to him and I said, please, I'm going to die. I've lost a lot of blood. There's something wrong. My lips are blue. Please. Please, we don't have to call an ambulance. If you could just take me, I'll drive whatever I can do, please, to go to the hospital for this. And he said that before anything happens, I had to concoct a story in order for him to not be arrested or be in trouble when we did inevitably get to the hospital. So I'm sitting there with this blood-soaked towel with blue lips, trying to come up with a story of what I can tell them when I go down there so he's not in trouble, and telling him that it's okay. And I came up with the story of that we were sword fighting silly after drinking with our steak knives, and he accidentally punctured my leg. And from there...
How did you get to the hospital?
That was the story you came up with, sword fighting?
He told me to drive, and because of the amount of alcohol that he drank, and I couldn't. So he got into the driver's seat and drove me, and the entire time he's barking at me to make sure that I get the story straight. We're sword fighting, okay? We were drunk, you know.
Did you go
being
to
silly? Yes.
All right, and did you get treated there?
Yes. I was bloody, and
All right, let me show you the photograph. Can I show you these?
yes.
All right, is this a fair and accurate depiction of the injury to your leg?
Yes. I had to go to 2 different hospitals for it.
And you lied to medical personnel about how this happened?
Yes, they brought in sheriffs and everything.
Was it consistent with, they brought in sheriffs? Did you have to answer to the law enforcement officers?
Yes,
Did you stick with the story that you and George had agreed?
I did.
Judge, I'd like to offer this deposit exhibit.
Okay. What was pre-marked as K will be received into evidence without objection as Defendant 6. You may publish, sir.
Thank you. And is this you at the hospital?
Yes.
You want to reorient that photo at all?
Is this the stab wound to your leg?
Yes. My foot.
Is this a close-up of the stab wound?
Yes.
And was that, did you hurt your foot?
No, due to the injury, I had other problems with the surgery.
Okay. But you eventually recovered?
Eventually, yes.
Do you have a scar to that effect?
I do.
Judge, can you step down and show me the...
Mr. J? Okay. You may. There's a lock, sir. Out.
All right, I don't know how best to do this, Judge, because we've got this bar.
They can probably see it in there.
Is this the injury here? Looks like there's an indentation.
I don't know, man. I mean,
Identification T.
I think, unfortunately, this defense is playing better than I anticipated, unfortunately. Because, you know, she has what a lot of victims don't have. She has documentation of injury from various photographs, including hospital visits, that she's able to document. Now, what caused those things, we don't know. And she lied about what caused those things at the time, but she's here to tell us what caused those things and tell us that this is all domestic violence. And so her actions on the evening in question become more understandable because we're providing a reason for her actions, because her actions seem so incredibly evil that it's hard to understand. And now she's providing a basis for some sort of subjective fear that could be understandable to a jury. So I don't know. Maybe I'm just trying to like overly compensate for my own biases here or something, but I think it's playing better than I would have anticipated. So if the defense continues to do this, and they're going to bring in other witnesses, other people who can testify about the violence and all the rest of it, they're going to bring in those other witnesses to testify about police reports and police interactions and other things, and the ex-husband or whatever, they're going to bring in. So they've got, you know, they've got their evidence of domestic violence. And there seem to be some women out there who are of the opinion that if a man commits domestic violence against you, that inherently means he should die. Not because he's a threat to you in that moment, just because he's a victim, just because he does domestic violence. And so, and there are what? Is it 5 women on this jury, I think? So this could be going over better, this could be going over better for the defense than we anticipated. So, yeah.
You recognize that photograph?
I do. Yes.
All right. Looks like you've got an injury to your lip and to your face. Do you recall this event?
And she's such a psychopath and has so little remorse that she comes off as more credible than I expected. Because she has so little remorse and so little compassion. She has no problem making these statements in a way that seems sincere, which is also notable. So, yeah.
I was trying to sleep, and
Had y'all been drinking?
I'm not sure. I know that he had been drinking. This was one of the instances where I would go upstairs to try to go to sleep. And
But y'all drank together a lot, did you not?
sometimes, yes.
But there were times where he wanted to stay up and continue to drink, and you wanted to go
She
to
may
bed.
walk yet. She may walk
Many
yet.
times, yes.
She
You were
may
done?
walk yet.
He was not.
Correct.
Maybe Sarah Boone will get the
Is that
last
what
laugh,
he's
in fact.
Yes.
Maybe she will get the last laugh.
Tell us what happened.
I'm sleeping in the bed, sound asleep, and he comes into the room and grabs me by my hair a lot of the times, and from here he scratched me from trying to grab me, and then grabbed my hair and pulled me off of the bed, and then raked my face across the carpet. These are carpet burns.
To your lips?
Yes.
What about to the, looks like the eyebrow area?
That's from where from grabbing me, scratched me, and got a hold of me by my hair.
Why was he mad at you?
Because I wasn't downstairs with him
He wanted you to be drinking with him?
all the time.
All right, I'd like to introduce identification T in evidence.
What was pre-marked as T will be received into evidence without objection as Defense Exhibit 7.
Yeah, first thing you do is
You may, sir.
buy a new set of luggage. She's going to become an influencer, have a luggage company as a sponsor.
You see the injury between the eyes and the injury to
Oh
the
my
lip,
God.
Yes.
as you described.
What a dark future.
Blood going down my eye, yes.
Showing you what has been marked state's exhibit for identification, or defense exhibit, you for identification?
Yes,
Can you describe that photograph?
I can.
Go ahead.
This was the first time that I ever called 911. George and I had gone to a bar across the street within walking distance, and at some point, I asked a guy, or he asked me, somehow or another, it was over a cigarette. And he left, and I didn't know where he went, and the bartender said, oh, he left. He took your car and he left. So,
Why would he do that?
You're waiting for her OnlyFans?
well, I found out when I got home, it was because I spoke to another man. And so I paid the tab and I walked home, and he's sitting on the back porch with the handle of vodka, and I was walking on eggshells and terrified and kind of treaded lightly when I came in, and he acted all natural and fine. So I didn't know the reason why that he had just gotten up and left with my car. So then he calls me a whore, and then he calls me a slut, and then he calls me a cunt, and gets up and pushes me. And he pushed me with both of his hands so hard that we have this little area where our washer and dryer is, and there are metal doors that are on it. And he pushed me into the metal door. And then I fell back, and he got his knees on top of me, on my arms here, so I was pinned down, and was starting to strangle me and hit my head up against the metal closet over and over and over and over and over it again, and calling me a fucking whore, and you're such a slut, and fuck you, and everything. And my tongue was flopping out of my mouth, and I thought I was going to bite my tongue off, and because of the amount of noise I guess my head was making on the metal door, he slid me down and got back on me, and then started to strangle me again. And it was on, we have carpet, but it's like concrete, and I was able to get my arms out from underneath and grab his throat and get him off of me. So I got him off of me, and I pushed him off, and he came up and he goes, you fucking bitch, and he stomped my face. And the next thing I know, I woke up. I obviously blacked out.
Did you get knocked out?
I'm obviously, I guess, yes. And he was passed out on the floor, and I woke up frantic, looking for my phone, and I immediately called 911.
Okay. The police arrived on that incident?
Yes, they did.
Is this a fair and accurate depiction of the injury you sustained as a result of him kicking you?
Stomping, yes.
It was a stomp?
Stomp.
With his
All I
heel?
saw was his heel.
We'd ask that this be identification you be admitted today.
Okay.
What was pre-marked as you will be received without objection is defense 8.
Was that the next day, or is that a few days later?
That's a couple of days later.
And that's the bruising from the kicking of his eye?
Yes.
Now, the police were called, and we're going to talk about that in a minute, but let me go through these things. Showing you identification V, defense. Could you recognize that? You have to speak up.
Yes.
Can you identify that picture?
Yes.
Is that your leg?
Yes.
And is that was like the injury to your knee?
Yes.
Is that a fair and accurate depiction of the injury you sustained to your knee?
Yes.
Do you remember how that happened?
Yes.
Did you tell the jury?
I was trying to get off of the back porch, and he grabbed me and pushed me, and it was a rock or a really sharp piece of mold from him grabbing me and pushing me onto the ground, and I guess I just happened to hit my knee just right on whatever it was.
Were y'all drinking?
Yes.
Why did he push you?
Because I wanted to get off of the back porch.
He wanted to stay out there?
Yes.
He wanted you to be with him? What's the deal with him wanting to be with you all the time?
Insecurity, I guess. I don't know. I don't know.
Maybe he just loves you. Maybe he just wants to be with you all the time because he loves you. I mean, I know that's a hard concept for you to understand, but like in principle, sometimes people want to be with somebody all the time because they love that person. You know, saying. Okay.
And then some, yes.
All right, I'd like to introduce in evidence identification.
What was pre-marked as V will be received into evidence without objection as defense 9.
Now, Ms. Boone, were you treated for this, or did you self-treat? Show the jury now.
No, that was just, I got the first aid kit that I have for my son, and I just cleaned it up.
You what?
I said I got the first aid kit that I had for my son, and I just cleaned it up and put a Band-Aid on it.
All right, I'm showing you identification W. Defense identification. You recognize that photograph?
Yes.
What is that a photograph of?
This is a photograph of my arm.
And is that a fair and accurate depiction of the arm with some type of injury?
Yes.
Do you remember this event?
Multiple times, yes.
Well, I'm talking about this isolated event where this photograph was taken, the injury you sustained.
Yep.
Who injured your arm?
Jorge Torres.
You remember this event?
Yes.
Did you tell the jury about it?
This was one of the instances where I would try to pull away from him.
She does lie better
I
than
don't
Amber
know
Heard.
how
That's
my
true.
arm
I will
started to
agree.
do this, but from him pulling from this way, how hard he would pull, with me trying to struggle to get away from him, it would leave these bloody under the skin splotches.
So he wouldn't hit you sometimes, he would just grab you and pull you.
Yes, from me trying to pull away from him, that's the point of it doing this, from me pulling away from him.
Now, this is one of the many times y'all were both intoxicated?
I mean, I can't say for sure that, yes, but whenever it would happen, yes, we would be drinking.
Identification W in evidence.
What was pre-marked as W will be received into evidence without objection as defense exhibit 10. You may, sir.
All right, it doesn't look like a wound or anything.
Objection to commentary.
Sustained.
Tell me, I'm sorry, tell me, you said it's just from the grip, him losing his grip?
Yes, it would be from me pulling away from him, and whatever under the skin it was that it was disturbed from, the amount of pressure of him holding and then pulling from me would create those on my arms.
Okay. I'm going to show you Defense Exhibit X for identification.
Yes.
And what is that a picture of?
This is a picture of my ear, side of my head.
Is that a fair and accurate depiction
Yes.
of the injury you sustained by Jorge Torres?
Yes.
Do you remember this event?
Yes.
Were you drinking?
I at the time was not drinking.
On this event, you had not consumed any alcohol.
I mean, I may have earlier. This was another, I was in the bed trying to sleep.
Where was George?
Downstairs drinking.
All right, and so you were wanting to go to bed, and he wanted you to stay down there with him?
Yes, I was in the bed.
All right, tell the jury what happened on this event.
I believe this was the instant where I was in the bed and I used to barricade the door with our dresser.
Why didn't you just lock it?
All of the locks were broken in my home.
Why?
They were from George taking them in, including my son's. At one point, I could seek refuge in my son's room, but he broke that one as well.
Well, tell me, explain how that happens. Tell the jury. We can't read your mind.
George wants me, which he has told me numerous times, that I am to be with him at all times and doesn't like to be apart from me or away from me. So whenever it was even just to go to the bathroom sometimes, he would go with me. And you have to understand, I have a 2-story, 900 square foot townhome, so there's not many places to go. So it just happened to be that it would be upstairs or downstairs, or I'd be in a particular room or not. So inevitably.
Did you want some time away?
Yes, I did. Even if it were just him upstairs or me downstairs or vice versa. So I rarely got to sleep. This was one of the instances because I had barricaded the door with our, 200-pound dresser that we had, and then
I'm
I
amazed
had
by how
my
well the
nightstand
defense is
barricaded
doing.
up against the bed, to where
I'm
it
amazed
was
by
even
how
more
well the
difficult
defense
from the
is doing.
prior times of him breaking in. And he would, I don't know how he would ever do it, but he would get himself in through the crack of the door that he would be able to wedge the dresser in the nightstand. And he pulled me out of the bed and told me I was going to die. And I believe it's this incident, and punched me and...
Punched you in the side of the head?
Yes, in
Was
my
it-
temple and everything.
Was it an open fist or a closed fist, or do you know?
It was fully closed.
Like identification X introduced into evidence?
What was pre-marked as X will be received without objection as Defense Exhibit 11.
Identification R?
Yes.
All right, and what does that do?
I believe it's from holding the baseball bat, and
Is that an injury to your hand?
it's a bruise.
I don't
Was that
believe her.
taken,
I just think it's going over better than I predicted.
Was it February 23rd, 2020?
I think it's playing better than I predicted.
February 24th.
I still don't
February
believe her.
24th? Okay. I'd like to introduce identification R to evidence.
What was pre-marked as Defense R will be received into evidence without objection as Defense 13.
Judge, can I publish?
Yes, sir.
All right, this is not a great photograph, copy of the copy. But February 24th of 2020, is that what you were wearing? Is that you?
Yes.
Okay. And there's some discoloration up here of your palm. You see that?
I do.
Is that from you jabbing him with a baseball bat?
Sustained.
Do you know how you suffered that injury?
I believe it's from holding the baseball
Oh, we
bat.
found objection leading. We found objection leading. Oh, I was worried that we'd forgotten
Let's try
that
to
existed.
get back in.
Oh. Did we find our evidence book again? Oh, okay.
I'm showing you defense identification N. Just like 5 photographs. Can you look at those? See if you recognize them. it's in now, so.
Yes.
And are those fair and accurate depictions
Yes.
as a composite of the events that occurred in relation to George Torres and your TV?
Yes. Yes.
All right, are those stills of a videotape that you took?
Yes.
And is that videotape, was it on your phone?
Yes.
So when law enforcement seized the phone, they would have had access to this video?
I believe so, yes.
And tell me about it.
Lucas liked to watch cartoons and play video games on the big screen, this is the big screen, and I would have to call Brian to come over sometimes to help me figure out the Fire Stick and whatever platform or whatever it was that Lucas was trying to view his shows and video games on. And I don't remember how George found out that Brian had come over. I believe because it was actually fixed and he knew that I didn't know how to do it. Found out that Brian had come over to fix it, and
Was he jealous of Brian?
I don't know if he was jealous of Brian. I think that he had a fear that I somehow would go back to Brian. So I think by Brian helping me with things for Lucas, he just didn't want him to be interacting with me at all.
So Lucas wasn't over here this day, was he?
No.
Brian wasn't over here this day.
He may have been, I can't remember when he actually fixed the television for Lucas.
But y'all were drinking this day.
I know he was for a fact, yes.
Chances are you were.
Probably so, yes.
Okay.
I would agree.
So how did it end up badly?
He accused me of sucking Brian's dick and told me that he was going to break my face with the bat, and that he was going to make me unrecognizable to my son with the bat. And then told me that he's going to destroy my fucking television, and then I was going to remove it from the apartment. And if I didn't, I was going to be, again, unrecognizable to my son.
So did he grab the bat?
Absolutely, he already had that in his hand, and he told me that I had to videotape it.
Did you videotape it voluntarily?
No.
All right, but there is a video, but I'm going to go ahead and ask Judge if I can...
There's video of this?
Identification of these 5 photographs into evidence.
Objection. Is it O or N?
I have O being a composite with 5 photos, and I have a single photo.
We're moving in O, okay. All right, what was pre-marked as O will be received into evidence without objection as defense 14.
All right, so these are some stills from the video. This was George, that particular day, holding the bat.
You guys telling me that I'm going to take the television out once he destroys it.
He wanted you to take the television out?
That or I was going to help him, but either way, I was taking it apart and removing it.
And what is this picture of?
In the process of him destroying my television.
While you're videotaping?
Correct.
Is that the result?
No. After that, he ripped it off of the TV stand.
Did you later pass out?
Yep, like he usually does.
Yeah, if there's video, I would want to see the video.
I don't know. God could have something, I'm sure.
I'm showing you identification N. See if you recognize that.
It's my living room and a stairwell.
All right, were those, was that a photograph taken by a crime scene?
Correct.
Is that a fair and accurate depiction of your living room and stairwell?
Yes.
And
I wonder what Melanie's chat thinks of all this. I wonder how they're reacting to all this incidentally. I asked Melanie if she wanted to stream this with me. She hasn't gotten back to me,
correct?
which is perfectly fine.
And
She's
I
more than
apologize.
free to stream it
Was
herself,
pre-marked
of
as
course.
N will be received into
But I'm
evidence
very
without
interested to see
objections,
how she and her
defense
chat are
15.
reacting to this. Be interesting how they are parsing it. Shout out to Melanie Little, by the way. Hope she's doing well today on her stream.
Can you tell us a little bit about this room?
This is my living room. This wall that we have over here with the hearts, that's where we would display all of our artwork. We were in the process of taking it down to add more, so he could continue to be entertained. The bookshelf over here is my son's bookshelf with all of his toys and little guns and musical instruments. He's got his little karaoke machine down here, his guitar. The stand right here with the red bucket on it, that was the television stand. And then my back porch area and the dog bed here.
And then it looks like in front of the bookshelf at the foot of the stairs is that a doggy?
It's a baby gate, but my dogs would wander upstairs sometimes and go to the bathroom sometimes when we couldn't get them out. So I would, at nighttime, or whenever we weren't home, make sure that they didn't go upstairs. And plus Penny was blind.
There's an allegation that you pushed George down the stairs?
Apparently.
Or got him in the suitcase upstairs and pushed him down the stairs?
Supposedly.
Did that occur?
Absolutely not.
Is that bookshelf disturbed in any way?
No, nor the plant next to it.
I'm showing you composite, 2 photographs, identification M. Did you look at those 2 and see if you recognize them?
Yes, this is me sitting on the back porch with my dogs. And as you can see that we are both drinking.
All right, who's taking the picture?
I'm guessing George's, or maybe it's one that Lucas, no, Lucas wasn't over here, so it had to be George.
How can you tell y'all are drinking?
Because there's a cup here and then he has a beer.
All right. And there's 2 dogs, there's one sitting next to you. Who's that?
That's Penny, she's the blind dog. I used to have to pick her up to put her somewhere so she would stay there because she was unfamiliar with the area, especially since we moved from my marital home to the townhome. So most of the time Penny would be close or next to me.
Who's next to the film?
This is little guard dog Tess. She was the deaf dog. And this is the fence here.
Well, I'll show them that.
Okay, but this is Tess, and then this is deaf, blind. Penny and Tess.
All right, and the second one.
This is Tess on the back porch, taking a nap. She was never far from me.
All right, when George was sober, how did he treat the dogs?
Nice. I don't know if he was a pet person, but I mean, he was nice. If I needed him to feed them, he would feed them.
Were there times when George was drinking where he would threaten to harm the dogs?
All the time.
All right, you're going to have to tell the jury specifically.
One of the worst threats was Penny being blind. He would actually leave the gate open in the back. He wouldn't threaten me to do it. He would actually do it on nights that I had to go up to sleep or I fled the night before or something. and would tell me that he hoped that I would come back and find her bloated body dead in the pond across the way from our townhome. And Tess was notorious if I wasn't there to go look for me, and would say that he would hope that I would have to scrape up her dead body from the street that was out in front of our apartment complex.
Why was George upset with you? Why would he threaten to harm the dog?
Anything that he could get to try to have some type of hold over me.
Control?
And he knew I loved my dogs very much, especially that they were handicapped.
Were they afraid of him?
Yes. Penny would hear his voice and instantly go underneath the dining room table that we had. Tess was always fractious and very, very quick with his movements, but she was never far away. They never showed their teeth, they never growled. Tess would occasionally bark, but it was very rare. And he used to kick them and just...
For what reason would he kick them?
Penny would try to find me because she's blind.
Speculating in the mind of a dog.
Sustained.
I'd like to move identification M in the evidence.
Any objection? Was pre-marked as M will be received into evidence without objection as defense 16.
All right. Can you describe this for the jury?
This is again is our back porch, and this is the fence that I made for the dogs to have a little bit extra space. Penny is next to me. She's the blind dog, and then Tess is down here at guarding the gate.
Are these fake rabbits? Is that
Yes.
in here?
I used to call my son when he was a baby. He was my bunny rabbit.
Overruled.
He was my bunny rabbit, so I used to collect bunny rabbits, and so I have rabbits here and there throughout my house and in my little garden area.
All right, this is the alcohol you are consuming,
Yes.
and this is a close-up of which one?
This is Tess. She's the deaf dog.
How old were these dogs at that time, 2020?
Gosh, maybe 9, maybe 10.
We approach.
Yes.
Interesting. Very interesting. I'm still not sure what the legal basis for concluding there's an overt act is, though. The judge did not specify. He just said there was one without clarifying what it was. Oh, okay. Yeah. I don't know, man. Oh, man. What are we thinking, chat? How do you think it's playing? She's got a lot of videos and a lot of photos that are showing some behavior that could be attributed to
All right, members of the jury, it's 4:03. By show of hands, would you like to take an afternoon break at this point in time?
I would.
Okay, court sees no hands. We may have to work also a little bit past 5 o'clock, maybe going between 5:45 and 6 this evening. I know juror third from the right, you may have to make a phone call as to that. Does anyone have any concerns about working a little bit later today till 6 o'clock? If you have those concerns, please raise your hand at this time. All right, court sees no hands. Ma'am, are you in a position to step out to see if you can get assistance with childcare, or is that not an option for today?
I'm actually all set for today. She's already taken them off.
You are? Okay, all right, excellent, very good. Thank you very much. I appreciate you all. With that, Mr. Owens, you may continue.
Judge?
Yes, sir.
I think one of the jurors raised their hand.
Oh, I'm sorry. Yes, juror fifth from the right.
Are we going to get a break before the 5:45 mark? Because if not, then yes, I would like a break now.
Then I tell you what, let's go ahead and take it at this time. We'll give you all a 15-minute recess. It's 4:04. Hang on, don't leave yet. I got to tell you a couple things. It's 4:04. We'll see you back here at 4:20. Same instruction as before. Please don't conduct any independent investigation or research as the person, places, things, or charge involved, and don't have any discussions amongst yourselves or anyone else. We'll see you in a couple minutes. Thank you very much.
Jury's trying to run away. Jury's trying to run away. We're out. We're done. Can we deliberate now? Oh, man. It's interesting for sure. There's a lot. There's a lot.
Y'all can be seated. Thank you. If Ms. Boone needs to use the facilities, we might as well take advantage of that at this time. All right, court will be in recess till 4:20. Thank you.
If the jurors believe the photos, yeah, I think her defense is playing better than we anticipated. Which, that's why you got to watch these things happen, man. I like this judge. I like this judge too. I think this judge is good. Sarah thinks she looks like this with an angel emoji. Very cute. Now they're putting Sarah Boone in the shackles, I guess, to take her to the bathroom. Seems like a little excessive, but okay. Protocol. No discussion of prior bad acts. No discussion of prior bad acts until they provided the basis for the defense, which the judge found that they did. So now we're into prior bad acts because the judge found the basis. The judge found the scintilla of evidence necessary. I'm not sure where, but apparently he did. Or quite possibly, more accurately, he was just not willing to make the call because it's a big boy call. So either one, he actually found it, or two, he was just like, this is like I'm just begging for error, and he wasn't willing to do it. Scintilla is very, very small. Scintilla is any amount at all. The least amount. Anything at all. Scintilla is anything. It is micro. So just anything at all is a scintilla. Yeah. He did cover his ass. The judge covered his ass. He'd be putting his balls really on the line, going the other way on that one. You're just begging for an appeal. The Court of Appeals rules against you, man. It's rough. It's tough. Yeah. A peppercorn will be enough to go to our contracts law, right? How much consideration do you need? A peppercorn will do. So how much evidence do you need? A peppercorn will be fine. Yeah, just the barest amount will be fine. I'm not inclined to believe her personally, but I kind of discount the documentation. Yeah, fair enough. Defending the straw man. So it makes her actions more reasonable, somewhat. And I think the jury could very well hang. So maybe Sarah Boone was smarter than us all after all. Maybe Sarah Boone was smarter than us all after all. Maybe she was smarter than her other 9 lawyers. Maybe she was smarter than all the commentary. Maybe Sarah Boone will prove to be the smartest of us all. God damn it. How bad is that? How bad is that if I get humbled by Sarah Boone? That's a rough day for my ego, man. Will the state have the opportunity to re-examine anything since they didn't provide anything to combat self-defense? Yes, they will. They didn't want to. They didn't want to provide it because it would have opened the door unto itself. So they very deliberately didn't do that by very deliberate design. So yes, they will have the opportunity in rebuttal to bring any evidence to the contrary that they wish to bring. Absolutely, 100%. 100%. So the defense is going to recall a whole bunch of people that we previously saw, previous neighbors, previous police officers, previous whatever, that they can document any of this domestic violence. And then the state has the opportunity for rebuttal as well, 100%. If she gets off, will the state compensate her for her time in jail? No. Not unless Florida law specifically provides for it. Not as far as I'm aware, no. Where's the imminent threat? I don't know. I continue to wonder that too. I have no clue. I can't find the overt act. I can't find the basis in law. I can't find it either. But the judge says it's there, so I guess I must be wrong. The judge says it's there. I guess I must be wrong. I don't know. I have no clue what it is. Don't ask me. Did they charge manslaughter? Unclear. They could charge manslaughter. I assume it's lesser included, so they could. Of course, they're giving the jury the compromise position, which the state may or may not want to do. And the defense may or may not be able to force it. I'm not sure how that works exactly in Florida law. Five women, one man, she's toast. He said some things to her while in the suitcase. Said he'd kill her. Yeah, the timeline doesn't work, though. At the time he said it, I think she had already flipped the suitcase, and I don't think the timeline works. So I don't think the statements work because I don't think the timeline works. If I understood the timeline correct. So doesn't the jury have to go by law? In principle. But the judge has already said, right, that this is something the jury could potentially find because they find that there is something there. So there's apparently a scintilla for the jury to find. If the judge can find it, certainly a jury can, right? I mean, how could it possibly be error for the jury to find it? If the judge can find it, which I can't find it, but how could it be error? So I don't know. Sarah will sue Florida. I'm not sure she has any basis in law to sue Florida. I'm not sure she has any basis for that. There's enough to convict on manslaughter? I tend to think so. But I think what part of the equation that you might be forgetting is that jurors are human beings. And if they buy her story and they think that George needed killing, if they think George needed killing, then, jury's gonna jury, man. Juries are human beings. Yeah, she lied to the police. She lied to a lot of people. But she can try to wrap it all up in battered women syndrome. I was too afraid to tell the police. I was too afraid to tell, whomever. She's read her domestic violence pamphlets. She's probably read a couple books by domestic violence survivors. Wouldn't be the first time. Wouldn't be the first time. That kind of shit was going on in the 80s, at least in the 80s. With people reading domestic violence handbooks and domestic violence stories to fabricate domestic violence. That kind of stuff has been going on for a long time, man. Why'd she get a protective order? I don't know. Why don't victims get protective orders, right? She's going to hashtag this Me Too thing, man. She's going to try to hashtag Me Too this, man. She's well prepared. She's had 4 years to study and practice her testimony. Yeah, very much so. And she's coming off more credible than I expected. It might be because she's a raging psychopath, but she doesn't come off. She comes off as believable because she has no conscience. She has nothing to get in the way. So. There's body cam of her choking him. Yeah, fair enough. She read the Amber Heard How to Get Away with Domestic Abuse handbook. Yeah, I mean, if you want to fake being a domestic violence victim, go get yourself 5 books by people who have written about their survival from domestic violence, and then amalgamate them. You'll do fine. Get yourself 5 books by domestic violence survivors. Get yourself some domestic violence literature and pamphlets. Get yourself the Wheel of Power or whatever it's called. Study it, amalgamate it, make it your own. No problem. You've now successfully faked domestic violence. No problem. It's easy. It's easy with a little bit of study and practice. This information has caused a shift in perspective on Melanie's channel. I bet it has. I bet it has. And Melanie's channel might be very much emblematic of the jury, right? She does seem to have a bit of a domestic violence crowd in her channel, which, fair enough. And so I bet you there's some people on her channel who are resonating with this. I bet you there are. And they're getting on the he needed killing defense, right? They're getting on the he needed killing defense. There's some people who are victims of domestic violence who are like, oh, he was violent. He was domestic violence. He needed killing. I bet you there are some people over there like that. 100%. I bet. Yep. Yep. Was I just as annoyed as you about her repeating 1 million times the dogs are blind and deaf? She's got to make herself look like the angel she is, man. She helps the blind and deaf puppies. They're eating the dogs. They're eating the cats. What's the fixation with Melanie's channel and chat? No particular fixation. Just commenting that, I guess the only reason I mentioned it is because she has a channel that's very different in perspective from mine. And I find that interesting. I like Melanie Little, but her chat and her her chat and her audience are very different than mine. And I find that interesting. I find that inherently interesting. So I guess I'm just mentioning it because I find it interesting. You know, I like her personally. I hope she likes me personally. You know, I'm not sure what she thinks of me personally, to be honest. But, you know, I guess I mentioned her just because she's the most disparate from me that is covering it. I think Emily D. Baker might be covering it, but I don't really have a good sense of Emily D. Baker's channel these days because I haven't watched it in a long time. So Melanie would be the channel that I'm most aware of that has the most disparate view from mine. So that's why I mentioned it, just by contrast. Her chat does tend to get upset if you disagree. Yeah. Her chat is very mad at me at the moment. Her chat is very mad at me at the moment. Because I disagreed with them on the ballerina case. Her chat seemed to skew in believing the ballerina, and I very strongly disbelieved it. And they're mad at me. As best as I can determine, they're mad at me. Ballerina was a self-defense case. Victim of domestic violence, shot her boyfriend, husband, whatever, in the bedroom with a gun. I disbelieved her story. I thought she was guilty. The jury convicted her of manslaughter, I think. I think she's facing something like 40 years. I think she might have been sentenced yesterday, actually. I don't think we know how many Supreme Court cases will be argued this year yet. They're not done accepting cases for the term. So I don't know. In terms of how many have been accepted for oral argument, I don't know. You could look it up. But Melanie, in your channel, in your chat, I hope we can be cool. I hope we can be cool. I know we disagreed about the ballerina case. You, as a general proposition, believed her collectively. I, as a general proposition, did not believe her. I hope we can be friends again. I hope it takes more than that to not be friends. I really do. Is this we disagreed on whether or not she was a victim or not.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State.
Nick Ketchner on behalf of the state. William J. for the state.
Defense.
James Owens for the school.
Tommy Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
All right. Ms. Boone, let's go ahead and bring you back up to the witness stand, please.
Judge, we're going to try to go with 6 today.
Yes, sir, that's the plan.
As much as it takes, I mean, it's just nothing how it goes when we get back in. You said about 20s.
I mean, it all came down to the ballerina's testimony.
Our jury.
Much like Sarah Boone, it all came down to the ballerina's testimony, because the ballerina was the only one there in the moment of truth, right? She's the only one there during the incident. So ultimately, in the ballerina case, it really comes down to whether or not you believe the defendant or not, right? That's sort of the end of the game. Like, you can simplify this all the way down. It's like at the end of the game, it depends whether or not you believe that defendant or not. Because she's the only one there. She's the only one, other than the deceased, obviously. She's the only one there in the house. She's the only one there who can testify about what did happen or didn't happen. So it all comes down to, do you believe her or do you not believe her, right? Do you find her credible or do you not find her credible? I did not find her credible. I did not believe her. So that's the end of the game. But that's basically what it boils. In the end, it boils down to be a one witness case, you know, because unlike Sarah Boone, arguably, she had nothing that was external that could really validate what she was saying about what happened in that moment. So Sarah Boone has external things that are arguably buttressing her, which is more interesting, but I digress. Let's press back.
Yes?
All right, let's do it.
Oh, Judge, hold on. Oh, she's up there. I'm sorry. I thought we lost.
Okay. Can the parties approach for a moment?
Yeah. So it all came down, do you believe this girl or do you not believe this girl? About what happened in that house. You know, and I didn't believe her. So that's kind of the end of the game. Credibility is everything before the jury, as anyone will tell you. Credibility is everything. So, yep.
All right, members of the jury, again, if you could just raise your hands to confirm that you complied with the court's instructions during the last break. All right, record reflect all hands have been raised. All right, with that, Mr. Owens, you may continue your inquiry, sir.
Just based on the court statements, identification A, I'd like to, this is one of the photographs that we introduced. Is this injury to your ear?
Yes.
And then this is your living room. This is identification C, the blow up.
Yes.
Identification D. TV.
Yes.
Funny teller. Funny, funny, funny. They say women don't have sense of humor.
Is that your arm?
Yes.
Identification F. Is that your knife wound?
I can't believe that YSL trial is still going on.
Identification G.
What a shit show that
Is this
thing
the
is,
current
man. What a shit show. How is a jury in YSL even supposed to be able to process all that evidence? Even in principle, how are they supposed to be able to do it? It's such a convoluted... How are they supposed to figure this out? It's nightmare fuel.
Identification I. See your face shot
Yes.
with the lip and the eyebrow. Identification B, and this is the back patio of the dogs.
Yes.
Camel bounce a little bit, Ms. Boone. Let me go back to the night earlier in the evening when I think y'all may have been out on the back patio, and you had suggested to George to call the children, but then I think, did he call his brother, or his brother called George? Do you remember?
George called his brother.
Okay. And you made a statement about tell him something. Explain that to the jury.
I told him to tell his brother about you choking me the other day. This is a separate choking incident. We had been drinking, and I wanted George to tell him, but he didn't tell him, so I said it in the background, so he would be aware.
What did you tell him?
Tell him why you choked me, or that you choked me.
Okay. Now, you heard the testimony of the two neighbors, the boys that live next to you,
Yes,
and you heard that they were actually questioned. I think the audio, they were audio interviewed. You heard from Detective Copsell. I think it was a couple of days later on the 25th of February, or 27th of February.
yes,
And you heard their testimony earlier this week,
yes,
where they hear a kind of a thumping sound starting at the top of the steps, ending at the bottom.
yes,
Have they got the night wrong?
yes.
To explain to the jury that.
So it was the night before. Again, I was sleeping, and in the middle of the night with the door barricaded, he came in and ripped me out of the bed. And first got me with one hand, and then got both hands and pulled me completely off of the bed. And then, like a caveman, had my hair like this and was going down the stairwell, taking me with him to come downstairs so I could sit and drink with him.
Do you believe that's the noise that the two neighbor boys heard,
I absolutely do.
and it was just the night before?
Correct.
Now, some of the time when this abuse occurred, you called the police,
Yes,
and other times the police were not called.
correct.
I want to refer to you the first time, I believe, you mentioned the 911 call. I believe that was July 25th of 2018.
Yes,
And that was the incident in which George had kicked you in the eye,
stomped me, yes.
stomped you in the eye, and you had grabbed his neck.
Yes, I was able to get my arms out from him pinning me down with his knees and grab his neck.
So law enforcement came and investigated,
Yes,
and both of you were arrested.
correct.
Do you recall asking the officer when you were arrested, why am I being arrested?
Many times, yes.
Do you recall asking the officer, why am I being arrested?
Yes,
And do you recall making any other statements to law enforcement as to why you did what you did to George?
that was the first time ever that I actually officially fought back.
Did you tell the officer that you were fighting back?
Yes, because I was complete shock that I was getting arrested because of it.
Okay, we're back. All right. Did I miss anything extremely important while I was gone? Probably not.
Now, on the 2-minute video, the suitcase video, you mentioned to him, I think you said something, I can't breathe. He said, I can't breathe, and you said, that's how I feel when you're choking me. Were you referring to an isolated incident of the night before, 2 nights before, or whatever, or were you referring to in general?
In general, the more than 2 or 3, 4 times that he had done it.
Okay. And then the part about cheating, he didn't physically cheat on you.
No, he did not.
Okay. And just, I don't want to go into a lot of detail, but what are you referring to there?
George was, I believe, addicted to pornography, and a lot of that would be found on my phone from him supposedly wanting to call up job interviews. And as a solution, I sat him down and I explained to him, to me, that's you visualizing yourself with someone else, or at least having a pleasurable moment with someone else or watching other people. And to me, I told him that I considered that cheating on me.
Okay. And so he would download that on your phone?
Yes.
How did you stay with him? You got to tell the jury.
As anyone who has ever been in love, or when you love someone, or primarily someone or something, you go above and beyond, and you tolerate and you endure and you persevere, and you try to make that person as spectacular as you possibly can, no matter the sacrifice that you may have to go through to serve someone else in a positive light so they can be better people for themselves, and to just make them a happier person. And love is very strong, and love is very deep, and love, I believe, is not fully understood in a lot of ways for how different people react to it. And I very much, deeply, and passionately love George.
Love is patient, love is kind. Love is not proud, it does not boast. Yeah? Okay. All right, fine, good. Yep, fine, yep.
Love him to this day.
Did you not want to be alone?
Beginning through my divorce, it was very nice to have him around, and he was a man to me, and I felt protected, and he's very nice, and as lame as it sounds, he used to compliment me, and it made my day. So, yes.
During that period of time when you first started seeing George, would it be fair to say that you had low self-esteem?
Yes.
Now, we talked about this previous arrest where you told the officer you were fighting back and you got arrested. Now, I want to talk about your conversations with law enforcement, but first I want to ask you, why did you go to the police station that day when you were interrogated there? We saw the 2-hour video. Tell the jury.
They tricked me.
The day
They
of
tricked me, the
incident,
Hobbitses.
the detective Copsell gave me her business card with her personal cell phone number on it and said if I happen to remember anything or anything that I would like to add to the day for me to not hesitate to give her a call. So throughout the rest of the evening, something was off. I didn't feel comfortable with what she told me and how she told it to me.
How long were you at the scene?
Gosh, all day, from the moment that they were there to the moment that the coroner's van drove off.
All right, when it ended, did you stay in your home?
No, I raced inside and collected some pajamas and a toothbrush, and I went over to where my son was at my ex-husband's house.
Did you take the dogs?
I didn't even feed them. It was so fast.
All right, and then once you got over to your...
She didn't feed the dogs?
Ex-husband's, what happened? Is it released to Detective Copsell?
Something just wasn't sitting right with me, and I had a suspicion that she just wasn't being honest with me, so I took it upon myself.
Sustained.
So you called her. Tell us about that.
I called her and I told her that I felt that she was being dishonest with me. She originally had told me that due to her being pregnant, it would just be a lot easier for her to have me come down to the station to pick up my phone. The original plan was for she and Detective Loman to return the phone to my apartment. But she said that it would be a lot easier for me to just come down and pick it up because I remember when I was pregnant. That's what she said. You remember when you were pregnant. So I said, I feel that you're tricking me, and I feel that you're being very sneaky about something, and I don't believe that you're being honest with me. And I said, regardless, I'm still going to come.
Sustained.
So you agreed to come, but you understood it was to get your phone?
Correct.
All right, you came that afternoon to the station?
I did.
And the original agreement was they were to come to you?
Correct.
All right. When you got to the station, what happened?
I thought I was just going to be picking up my phone. My car was there. I had everything in my car.
Did the
It was just
police
regular.
tell you
just
a
going to go and maybe
lie?
sign something and pick up my phone.
Did they have you calm down
And
there
there's
on
people
false
that are
pretenses?
over here at the windows,
No.
and I thought that I was supposed to go over there to get my phone. And Detective Loman
Oh
came
my
down
God,
and,
the police made a misrepresentation about what they really wanted.
Upstairs, that's
Oh
where
my
phone was.
God,
And
first
then
time I'm ever
I
hearing
was
about it. Holy
taken into
shit.
I guess it was an
Wow.
interrogation, and they told me to sit down, and that then I guess the interview or interrogation began, and I just simply was getting my phone.
Sarah, tell the jury why...
Yes.
Oh my God. I suspected they were lying to me, so I went down there anyway. I suspected they were trying to deceive me, so I did exactly what they wanted me to do.
You may proceed.
Okay.
Miss Boone? Miss Boone? Tell the jury why you lied to the police.
Because I'm a liar?
I lied to the police. Basically everyone, because I was extremely fearful of being arrested. I made the first attempt of me calling 911 by telling them what happened, and I thought they were going to help me, but instead I was arrested for calling 911.
You weren't exactly arrested for calling 911.
So you made the
that isn't
decision to
exactly
lie.
right.
I did.
Did you stay with that lie?
I did.
Are you telling the truth today?
I am.
Sure.
Now, let me take you back to the to this incident. Is it fair to say that when Jorge Torres is sober, he commits no violence against you?
No.
Is that fair to say?
Yes.
Is it fair to say that every time that he's intoxicated, or every time that you're hit by him or harmed by him, it's when he's intoxicated?
Yes.
As a result, when he's drinking, does it change your outlook?
Yes.
Could you explain that to the jury?
I'm always fearful, paranoia.
Why?
Because I try to protect and defend myself for fear something happens at the last ultimate second.
But you're always that way, fearful. Is it because of these prior incidences?
Absolutely.
Do you try to placate him?
All the time.
What do you mean?
With the puzzles and the painting and feeding the ducks across the way at the pond, listening to music, trying to go for a walk on the trail, anything that I possibly can. I told you I was running out of things to entertain him with.
Why do you think George, what bothers him?
Objection, calls for speculation.
Sustained.
Does he tell you?
Objection, calls for hearsay.
Sustained.
Those call for
As a
hearsay.
result of how he behaves towards you in that intoxicated state, how were you feeling the night of this event?
Objection, asked and answered.
Overruled.
Extremely nervous, anxiety galore, just, I can never relax.
When he's drinking?
Yes.
And
Do you want to feed her the
state
answers
of
any harder?
intoxication that he was at the time of this event, is that the state that scares you the most?
Wow. How, could you feed her the answer any harder?
Alarms and red flags that go on.
Isn't it true that when he was drinking,
Whenever it is
he was
that
an
we
abusive
are
son of a
drinking?
bitch who was a terror to you constantly? Isn't that
Tell
true?
us about
Holy shit. Could we lead any harder?
how that heightens, does that heighten your sense of safety,
At all times.
but especially when he's drinking?
Oh, yes, all the time.
And then his mood?
Yes, it depends on what mood he's in that day.
Well, do you have like a sixth sense of how he's doing?
Yes, I knew George very well.
Objection, non-responsive. Yes or no?
Sustained.
Can you tell us what you mean by that? Sixth sense, or knew him very well?
I guess you can say that I was trained by fear with him. Just,
Ooh.
it wasn't fun anymore when we would drink and we would hang out on the back porch. It wasn't fun anymore because I knew inevitably that something was going to happen to me, one way or another.
I was trained by fear. School of hard locks was my lesson.
Miss Boone, you know, those bruises that we saw of him, they look pretty deep. Tell the jury what you were thinking.
From the bat, you're
Yes.
saying? I didn't want to die that night. I can't describe it to you. It's terrifying love to a certain degree, where my plan was to show him the next day, and just, I wanted him to be better and treat me nicer and be the person that he was when I originally met him, and I knew that was in him still. I knew that it could be found, and I just couldn't figure out what it was that I was doing wrong in order for it to not be back to where that was, and
I can think of some things you were
I
doing
was tired
wrong.
of living in fear and
I can think
just sick all the time
of
of
some things you're probably doing wrong.
figuring out how I can entertain him so I don't die, and continue a relationship with my son and try to live a normal life. That wasn't a normal life for me, and just bottom line is I didn't want to die. I would have died, or I would have been disfigured or maimed, or if it weren't me with the bat, it would have been him if he were to have gotten out.
Wow. 10 out of 10. Oscar.
That's all.
Any cross-examination?
Can I have 5 minutes, please, so I can laugh first? Can I have a 5-minute break? I need to go outside and laugh a lot, and come back and ask questions.
Did George know somebody named Crystal? Did you ever mention Crystal in your text messages about being one of his bitches?
I don't know. I don't remember.
How about Christine? Did George know a Christine?
I don't know.
How about a Pamela Erickson?
These may have been people that he was communicating with on whatever the platform was.
On your phone?
I believe so, yes.
And did you find these communications?
I believe I found 1 or 2 of them from some of them.
And did you send a long letter to his family to relay to him about George and his girls that he was cheating on you with?
I believe so.
Okay, so you do know those names, right?
I don't remember them. It's been however long.
Okay. Now, on February 24th, 2020, you called 911 at about 1 p.m., correct?
Yes.
And at that point, you were still feeling a little intoxicated, were you not?
It was more shock, but yes.
So you agree that you previously stated, I was still, I believe, intoxicated to a degree?
To a degree, yes.
Okay. So 1 p.m., it's about 14 hours after 11 p.m. the night before, correct?
I'm guessing so.
Well, 12 hours prior would be 1 a.m., and then 12 a.m. is 13 hours, 11 p.m. is 14 hours, correct?
Okay.
And you were present here for the medical examiner, Dr. Zadovich, to testify, correct?
Yes.
And you heard her talk about all the effects of ethanol that has on a human body, correct?
Yes.
And she also mentioned something that it, on average, dissipates at about 0.015 an hour. Do you recall that?
I believe so.
Okay. So, would it be fair to say that if you're still feeling the effects of the alcohol at 1 p.m., so that's 14 hours, 0.015, you were at approximately about a 0.21 at 11 p.m. the night before. Do you feel like you were 2.5 times the legal limit at that time?
I don't know how you came to that number.
Judge, I'm going to object.
Roach.
Well, the way he came to that number was with math. But the proper response would be, when I said I was feeling the effects of the alcohol, I meant the after effects. I meant being hungover. That would be the proper response, just to help you out. I'm going to give Sarah Boone notes so that she can improve her testimony. Because that would be a reasonable thing to say, right? That'd be reasonable. If I said I'm still feeling the effects of the alcohol I drank last night, it would be reasonable to interpret what I meant as saying, I have a hangover. Right? That'd be a pretty reasonable interpretation of it. So that's how you fix the problem.
You may proceed.
So you testified earlier that you all had about half of one of these bottles left from the night before, correct?
Yes.
Right? I've felt the effects of alcohol 2 days later. Maybe more. There have been some episodes in the past. What is your record for the most number of days you felt the effect of alcohol? Please put it in chat. Make me feel better about myself.
February 22nd and the 2 that were purchased on February 23rd of 2020.
I'm guessing
Okay.
maybe it's like the bottle, yes.
All right, and it's 1.5 liters. Would you agree?
Are you seriously doing alcohol math still? Are you still doing this math? You can't be serious. You're going to be like, it's 1.5 liters at this ABV, and therefore you drank half, and therefore it's this ABV, and therefore this is how much you drank, and that's for how much you were, because this is your body weight. Are we still doing ABV math? Come on.
And when you say half, are we talking about to the top of the label was left from the day before?
Oh, goodness, no.
All right, a little less, halfway through the label?
It's too right about.
Are we really doing this? Is this really where we're trying to impeach her? Of all the places we could try to impeach her, this is the one we're going with? Really? I was still feeling the effects the day out later. Wasn't it true the bottle is 1.5 liter? And isn't it true you said the bottle was this tall? And isn't it true you drank half? And therefore the bottle is this much alcohol. And therefore you're this body weight. And therefore this is how much alcohol you had. So you couldn't possibly be. Isn't it true you were like, what the fuck? What are we doing? Well, of all the places to impeach her on, this is what you want to impeach her with? What are you doing, man?
So in addition to halfway through the label, which you began consuming after going to Publix at about 12:15, correct?
Jesus Lord!
So you all would have began consuming around 12:30, is it fair to say, when you got back?
I can't tell exactly.
Okay. And after finishing what you all had left over from Saturday, the two of you consumed 2 1.5 liter bottles, correct?
I'm not sure about the second bottle that he purchased, if it was empty or not at the time.
Well, you did mention that the police would find 2 empty bottles in the top of your trash.
He's not starting great, Black Beauty. That's all I'm saying. Of all the places to start, this is not great.
Two.
Empty in the garbage, yes.
All right, and you say you were about 100 pounds at the time?
Yes.
We're seriously
And we all
doing
know
the
Mr.
math.
Torres was
We are seriously doing
103
math.
pounds
I
at the
can't
time of
believe
his
it.
death, correct?
That's what they said.
All right, so that's 3 liters of wine
I can't
between
believe we're doing this.
200 pounds split between 2 people over the course of a day, correct?
Yes.
Please
And
make
you
it stop.
testified today that you were intoxicated at the time that this occurred, the videos between 11 and 11:30
No, strictly
at night,
said she
correct?
was.
Yes, at some level, yes.
All right. Now, what does that mean to you? Previously, have you indicated that that means the room is spinning? Do you ever recall saying that?
I do.
So what was your level of intoxication at this point in time when the first video was filmed at 11:12 p.m.?
Do you mean from lack of sleep or alcohol?
From the alcohol.
What was my level?
What were you feeling? Did you have trouble with your balance?
Are we really doing this?
I was more tired than anything.
Are we really doing this?
Did you have trouble with your balance?
I don't believe so.
So you were able to flip a suitcase over with a 100-pound man in it, right?
I mean, yes, it happened,
Okay. How about your speech? Do you feel like your speech was slurred?
clearly.
How about your inhibitions? Do you feel like you were doing things that you wouldn't do when you were sober?
I wasn't thinking about that.
Well, on reflection, do you feel like this is something you would have done when you were sober?
Objection? Really? Seriously? Are we doing this?
Didn't know me and George.
I'm just
Is that-
asking you, looking back on this, when he's in the suitcase and you're telling him how you feel, and then you wait 11 minutes and you film another 22 seconds, and then you go upstairs, upon reflection, is that something you would have done and left him in there had you not been drinking?
I don't know. I can't say.
He better be going somewhere
I'm
with
scared
this. This
that
better be
he'd
great.
something.
All right, now, today you testified about the time frame between the two videos, correct?
Yes.
So you came down from the shower where you were hiding, correct?
Yes.
And as you're coming down the stairs, before you even get to the bottom of the stairs, you can kind of see over your shoulder or towards your right that he's trying to hide in the suitcase, correct?
Yes.
And the lid is down, but it's not closed, and you can tell he's hiding in there. It's not a great hiding spot just yet, right?
Correct.
Isn't it true that you went to Rusty's bar last night and the bartender was Jen? Isn't Jen notorious for her light pours? Didn't she give you light pours? Let's go to the cocktail making recipe at Rusty's. Isn't it true that she was only giving you half shots at 1 p.m. as 1:37:14 exactly on the dot in the morning as they were doing last call, and she gave you a half shot at exactly that time you drank it all, and therefore 5 hours later, blah, blah. Okay.
And so you come over to him, and you're laughing, right?
Yes.
And you move the suitcase around some before zipping it shut, right?
No.
No? You immediately zip it shut?
Yes.
Okay. And you're both still laughing about it, correct?
Correct.
All right. And then it's during this course of time, how quickly is it after you zip it shut that you begin filming the first video?
This is much better. This is more promising. Thank you for moving past math.
Okay. I mean, the
Please-
video's
please
not gonna
never go
catch
back
you
to math.
zipping him up because you're like 10 feet away, right? How quickly after you zip him up is it before the video starts, is my question.
I don't know.
Okay. And then during that 9 minutes and 14 seconds is when he begins to get angry, correct?
What, 9 minutes?
Between the two videos, there's 9 minutes and 14 seconds between the end of 1061 and the beginning of 1062 and 1063.
Seconds.
You got the 2 minute, 3 second video that starts at 11:12:45, correct?
I guess.
Permission to use state 17?
You may.
If a train leaves Duluth at 2:30 in the afternoon, and a train leaves San Francisco at 5:18, how many grams of alcohol would it take for me to care?
All right, so we're looking at entry 31107. That indicates, according to the phone extraction, 2/23/2020, 11:12:45 p.m. Image _ 1062 movie begins being captured. And we have seen that that is about 2 minutes and 3 seconds. Entry 31113 indicates that image _ 1063.move.
We lost our screen. We lost our rows. It's a disaster.
I was disconnected. 31113, a second movie is captured at 11:23:03 p.m. Your testimony was that after that first video was captured by your phone and you, Mr. Torres began getting angry and trying to push his way out, correct?
Say it one more time, please.
Between these two movies, of which there's about 9 minutes and 14 seconds, Mr. Torres begins to get angry and try and push his way out and get out of the suitcase, correct?
He had been angry on and off throughout the entire day.
Okay. You didn't tell us that earlier. You said it was a wonderful, fun day all day, correct?
That's because I lived.
Wow.
But you did not tell us earlier.
Wow. That's a great answer. I like that answer a lot. That's fantastic. He was angry throughout the day, but you said it was a wonderful, fun day. That's because I lived. Wow. 10 out of 10 answer. Round of applause. Round of applause. Outstanding.
Earlier today that he had been angry throughout the day.
When would I say that?
You described your entire day of doing puzzles and arts and crafts and outside by the dartboard, and you said it was a wonderful day and everything was fun until he was in the suitcase. Did you not testify to that earlier today?
I did.
Okay. My specific question between these two movies is, this is when he begins to get angry and trying to push his way out and to get out of the suitcase, correct?
Angry again, yes.
Okay. And he was expressing his anger in what manner? How did he say this?
At which point throughout the day?
Ma'am, you know very well that I'm talking about between these movies. Please answer my question. Between these two movies, how did he express his anger with you?
Told me that I was going to fucking die.
Okay. Now this is happening after he's already told you several times he cannot breathe in the suitcase, correct?
Correct.
And he's been in there for whatever brief amount of time it took you to zip him up, and the laughter stops, and then you go over and begin to film, correct?
Yes.
And you're filming, your purpose of filming is to kind of teach him a lesson. This is your chance to say something to him when he can't say anything back to you, correct?
No.
Then correct me.
There was no lesson to be learned. It was just I wanted him to try to understand how I felt so maybe he could progress in being a better person.
That sounds suspiciously like you're trying to teach him a lesson to me.
So
Okay.
you wanted him to understand how you felt in the past, and that's not teaching a lesson?
Yeah, that's what I said.
I just wanted him to understand.
Okay.
Okay.
All right, and so immediately prior to zipping him up and putting him into the movie, you had been upstairs, correct?
I'm sorry?
Immediately before coming down and zipping him up and then filming the first of the two movies, you had been upstairs in the shower, correct?
Yes.
I'm going to publish what has been labeled as image_1061, which according to the timeline was captured at 11:03 p.m. 31 seconds with her device. All right. Does this appear to be the suitcase that's in question in the two movies that are filmed at 11:12 and 11:23 p.m.? Oh.
I mean, if him trying to get out of the suitcase is an overt act, or him saying, like even saying, I'm going to kill you is an overt act, I think we're all in a lot of trouble, to be quite honest. If that's an overt act, I think we're all in a lot of trouble. I would imagine that many of you in relationships have on occasion perhaps said something in a moment of anger that would be of similar quality. Now, hopefully not all the time, because that would be more concerning, but I would imagine that, from time to time it's possible,
This is image 1061 taken at 11:03 p.m. 31 seconds. Does this appear to be the blue suitcase that's in the two videos that were captured at 11:12 and 11:23 p.m.?
Correct.
Did you take this image at 11:03 p.m.?
I don't remember if I did or not.
And again, we had, and by we I mean you and Mr. Torres, 2 1.5 liters bottles of wine and plus whatever was left over from the day before, correct?
That's correct.
So you don't remember taking this photograph?
I don't.
Do you remember whether or not Mr. Torres was in here?
I don't remember taking the photo.
Okay. So what is your memory of what happens between 11:03 p.m. and 31 seconds when that image is captured, and then when the movie starts at 11:12:45? What do you remember?
I don't.
Okay. Do you remember anything from that night?
I do.
You told the police on February 25th, 2020, when they first showed you the video, that you didn't remember taking that. You remember that?
I do.
And your testimony is you do remember taking that video,
I do.
but you don't remember taking that photograph 9 minutes prior.
Correct.
Is there something, did you have more to drink in
Fair
those
enough,
9 minutes?
Kestrel. Fair enough.
I did not.
Was Mr. Torres in that suitcase the entire time between 11:03 when that image was taken and then when the second video was taken at 11:23 p.m.?
I believe so, yes.
So for 20 minutes? Yes?
However long the time frame is.
Did he begin telling you that he couldn't breathe before the video, or do you not remember?
I don't remember.
Fair enough defending the straw man. That's
Now, you testified moments ago that your two neighbors must have misremembered which night the loud noise was, correct?
Yes.
And now you're telling us that you don't remember taking the photograph at 11:03 p.m., correct?
Correct.
Did the police come out to your townhouse on Sunday, February 23rd, 2020?
Yes.
I'm talking about Sunday. This is the Sunday fun day when we're going to Publix twice. Were the police out of your residence?
No.
It was the day after, Monday the 24th, correct?
Yes.
And that Monday morning, you called 911, well, Monday afternoon at about 1 p.m., correct?
Yes.
And between that time frame, you were the only person in your apartment plus Mr. Torres in the suitcase, correct?
Yes.
So if anything had been disturbed in your apartment, you had all the time that you wanted to undisturb them before calling 911, correct?
If I wanted to.
Okay. And your testimony is there was no loud boom that shook the walls of your townhouse at about 11 p.m. the night of February 23rd, 2020, correct?
Correct.
To the best of your memory, correct?
Correct.
Now, that second video is 22 seconds where you just hear him say Sarah and you don't say anything, or you're familiar with that video, correct?
Yes.
It's after that you go upstairs, correct?
Yes.
How quickly is it that you go upstairs after that?
It was pretty quick.
And you grab the dogs?
No, the dogs were upstairs already.
Okay. Did you call 911 and let the police know that you had zipped somebody shut in a suitcase and they had not been able to get out for 20 minutes?
I did not.
Did you go to Brian's house and tell him, I had to zip Mr. Torres up in a suitcase shut, we need to do something about that before he passes.
I don't really like the way the state's going about this. It feels very clunky at best.
What do you remember now about the phone call with Brian?
I feel like this cross-examination is kind of a miss. I don't really like the way it's organized. At times it's overly technical. It's just not very, I don't really like the way this cross is done. It's not very satisfying. Hopefully they'll get to the end of the day and, regroup this evening and come back with new exciting cross tomorrow morning. Is all I can hope for at this point, because this is a little clunky in my estimation.
I know that I called him. I don't know specifically what it was about.
Now, your testimony, it seems like you spend day after day finding things to entertain Mr. Torres to do, correct?
Yes.
Almost like having a child. You have your own child, correct?
I do.
What you described sounded like having a small child. Would you agree?
That's your interpretation.
Okay. Well, you take him from doing arts and crafts to doing puzzles, so on and so forth, correct?
When he's been drinking, yes.
Okay. And Mr. Torres was notorious for doing some of these things, correct?
What do you mean?
Well, you described Mr. Torres as being notoriously known for doing things. You described your ex-husband, Brian Boone, notorious for doing things like nagging and calling all the time. You remember your testimony calling people notorious for doing things?
Notorious!
What would you say people would say you're notorious for?
I don't know.
What is uncivil notorious for? That's a
And
good question.
you would not answer Brian Boone, your ex-husband's phone calls, just so that you could let him know that you're busy and you have things going on, correct?
I knew that at whatever time it was that he was calling me, that he could wait for the few moments of me getting up to where Lucas gets out of school at 3 o'clock.
Okay. But you wouldn't return his call. You would let him call several times, correct?
That day, yes.
Okay. How about other days? Would he have to call to remind you to get Lucas on other days?
He wasn't reminding me, he was just making sure that Lucas was covered for a pickup or drop-off.
All right. You didn't mention to the sheriff's office either February 24th or February 25th about going to Publix with Mr. Torres at noon or 12:17, did you?
I don't recall.
King of Snark, I like that one. That's good.
So the best
Thank
evidence
you,
of that-
Lasky, for becoming an uncivilian and hitting that beautiful, beautiful join button. Do appreciate everyone who hits the join button. Thank you.
Did you not remember going to Publix with Mr. Torres that day?
At what point?
At any point?
No, I didn't.
You had indicated to the police that it was about 4 p.m. that you all had started drinking after doing chores. Do you recall that?
I do.
And your testimony today was that it was really more after you guys went to Publix at about 12:17 p.m., correct?
Yes.
Young Snark
And
life.
you did not tell the truth to the police, correct?
I'm sorry, I didn't hear the question.
You did not tell the truth to the police about that, correct?
I did not.
And when they were asking you about Mr. Torres's injuries, you told them that you had nothing to do with it, correct?
Yes.
And that was not the truth.
Correct.
Yeah. Those bottles are twice the typical size of the U.S. as well. Typical bottle is 750 ml. So yeah, those are double bottles, also known as magnums. But yeah, those are.
What did y'all have for breakfast on the 23rd?
I don't remember.
Did y'all have lunch?
I believe we had leftovers from, I think, something that we had in the fridge.
And do you recall what those were?
3 liters of wine.
Not at this point, no.
And then I believe you mentioned having a sandwich of some sort for dinner?
No, I believe it was for, I'm guessing, he and I ate at the same time.
When she walks, I can swipe on her. Great.
And at one point, Mr. Torres called his brother Juan, correct?
Yes.
And do you admit that you were yelling in the background, telling Mr. Torres to tell his brother that he had been choking you?
I don't know if I was yelling. I know that he could hear me through the phone.
Okay. So how long had that been going on that day? When did you start getting on Mr. Torres about choking you in the past?
He and I had had conversations about it because he didn't remember doing it to me. And the next day and the day of.
Is it fair to say that there are just points in time where you don't remember what you do either, correct?
Are you talking about almost 5 years ago?
I'm talking about from drinking. Is it fair to say that you don't often remember things that you did while you were drinking?
I would not say often.
Okay. In the course of your relationship with Mr. Torres, are there things you don't remember happening that happened the night before between you and him?
I can't say that at this point.
But you said that you don't remember taking that photograph at 11:03 p.m. on February 23rd, correct?
Yes.
Was there anything else that you were telling Mr. Torres that he needed to tell his brother?
Not that I can recall.
Okay. Was there anything you were telling him that he needed to tell his daughters?
Not that I can recall.
Now, you indicated that Mr. Torres would use your phone to look at pornography.
Correct.
Were there ever any points in times when it was you that was used looking at pornography?
If I was, it was to go back and look to see.
Did you ever threaten to get Mr. Torres arrested if he did not do what you wanted him to do?
I wouldn't say threaten.
Okay. Well, were there ever points in times where you would like him to call you or return a call, and if he didn't do that, you would threaten to get him arrested?
It depends on if he had my keys or something that I needed from him.
Okay. And it was your townhouse, correct?
Mine, yes. Flush hours.
Well, when did you get him off the lease?
I'm not sure what year it was, but I don't think he was actually removed from the lease.
Okay.
I think he was made a different type of tenant.
And did you change the locks so that he couldn't get back in at the points in times when you kicked him out?
I did sometimes.
And then would you leave the key in the hiding spot that he was aware of?
There were multiple hiding places.
Okay. On any of the 911 calls, did you ever mention that Mr. Torres was aware of where you kept your keys and that's how he got back into the house?
I didn't know I needed to.
Okay.
He would never break into my home.
All right, and it's your testimony that you did not push him down the stairs, correct?
Yes.
And in fact, it was him that dragged you down the stairs the night before, correct?
Yes.
Now, by dragged, did you leave your feet?
Yes.
And did you get scrapes on your knees or anywhere from the carpet?
I'm not sure. I don't.
Did you get any injuries, like bruises or abrasions or scrapes?
I was missing a lot of my hair. Yes, that was on the stairwell.
Okay. And you agree that you were photographed on February 24th when the police came out, correct?
The day of the incident?
Well, the afternoon after the incident, we're not sure when he passed.
Yes.
Some of those photographs showed ashtrays inside your house. I thought you said you guys couldn't smoke inside your house,
We couldn't.
but you did, right?
Sometimes, yes.
And you agree you would go to the hospital and tell them things that were not true, correct?
Yes.
There were times where you would go to the hospital and leave without getting treatment, correct?
Yes.
And is it fair to say that you often had alcohol in your system when you were going to the hospital, correct?
Sometimes.
All right, so just to summarize the day to make sure we understand it. You all wake up sometime in the morning, but it's an unknown time, correct? On February 23rd.
Or early afternoon. Yes, I had a problem with the detectives and them having me guesstimate times.
Okay. Are you the kind of person, like most of us, that uses your phone when you wake up?
No.
So the first activity on your phone may have nothing to do with when you woke up. Is that fair for you?
Yes, other than looking at the time possibly.
Okay. So at some point you wake up, it doesn't sound like you have breakfast, correct?
Correct.
You do some chores, correct?
Yes.
So that is true. That part of it is true. You did do chores before going to Publix at 12:17?
Yes.
All right. After chores, you go to Publix and you get that 1.5 liter Magnum bottle of Woodbridge Chardonnay, correct?
I'm not sure what Magnum is.
1.5 liters. Instead of the 750s, it's the double size. It's like 2 bottles of wine.
Okay, yes.
So you got a 1.5 liter, right?
Yes, it is the larger bottle.
And you got home, and you at 100 pounds and Mr. Torres at 103 pounds began drinking this wine, correct?
I'm guessing so. I'm not going to guess times.
Well, don't guess. I mean, you got home from Publix. When was your first drink?
I'm not sure. I mean, we could have continued to do whatever was left over from what we didn't do before we went to Publix.
Okay. So you may have started drinking even later, correct?
Then
12:30 when you get back from Publix?
I don't know.
Okay. Was it
This
1:30 or 2:30
cross
when you began
is
drinking?
not
I
working
don't know.
for me.
Was it before any of the phone calls to the brothers and his daughters?
Yes.
And so you drink what's left in the bottle of wine from the day before that's halfway labeled, correct?
At some point.
And then you drink 1.5 liters of wine, and he goes out and gets another one on his own without your permission or suggestion about 5:30, correct?
Correct.
And then you all consume that one as well, and it ends up in the trash can at the end of the night, correct?
Apparently.
Okay. At what point in the night does your memory tape stop? Because you described that it wasn't on at 11:03 p.m. when that photograph was taken. What's the last thing you actually do remember prior to these videos being made?
I don't recall it at this point. I don't remember.
Okay. All right, and so it ends in hide and seek after arts and puzzles, correct?
Yeah.
He says, tag, you're it, but you run and go upstairs and hide, right?
Yes.
So does that mean he's it and he's supposed to come find you?
No. That's
Okay.
just
So you both hide?
no.
Okay. How does this work?
I don't know how to tell you.
Okay.
I was it, and I went and hid.
I mean, my understanding of the rules of hide and seek is one person will be it, cover his or her eyes and count to like 20 and then go find the person that's hiding. Is that your familiarity with the rules too, or do you guys have house rules?
I understand how the
We are now discussing the rules of hide and seek, people.
Explain to me, what was your expectation? You go up to
Oh
the
my
shop,
God.
were you expecting him to come find you?
I was.
Okay. And after a while, he did not come find you.
Yes.
And that's when you return downstairs.
Correct.
And because of the way your townhouse is set up, you can kind of see over where the suitcase is. And that
Next time, we're
he's
going to
trying hide
discuss
in
the
there, but it's
rules
not.
of
successfully hidden just yet.
hopscotch.
I mean, yes, you have to come down a good ways in order to be able to do
Right,
that.
right. But you testified that was before you got to the bottom.
We're four square.
Yes.
All right. And then you come over there and thinking that it's funny, you zip them shut, correct?
Yes, we
I
both
miss
have.
four square. That
Okay.
was a good game. That was a good game. That was probably my favorite game in school was four square. I miss four square.
Enter into the well?
Yes.
Yes.
Can I get any hands in chat? Any fellow four square
Deputy.
lovers out there?
Could we release her
we
into the
start
well,
it?
please?
Can we start a four square league? Any hands in chat? Holla. What are we doing now? You're never invited to play? That's very sad. We're doing show and tell now, people. Please get into the bag. 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 Only the girls played Foursquare? Foursquare kicks ass. Foursquare kicks ass. We had so much fun playing Foursquare. We were very competitive about it.
Ms. Boone, can you demonstrate for the jury where Mr. Torres' head was and how his body was positioned in the suitcase, if you don't mind?
His back was this way and his head was here.
All right, and then is it fair to say his feet are kind of down here, which would be the front left corner from their perspective in the jury box?
Yes.
And then his knees are kind of tucked up towards his face.
We also had a pretty competitive shuffleboard
If I remember correctly, yes, that's the
going
position.
on for some
Okay.
reason at my middle
All right.
school. That's
Can
what we
you
did,
help me
Foursquare and
understand
shuffleboard.
how it was that your zip
What can you say?
is shut? Can you show us where you say you left an opening that his hand got out of?
Would it be easier to put it on here?
I didn't want to make you go down there. If you're happy doing that, I'll let you.
Hold up. Does she need to be wearing gloves?
Yes.
Agreed. She's going to be manipulating it.
Real. Oh, Lord. What are we doing now? Tetherball? Yeah.
What do you want her to do?
Just demonstrate how she zipped it shut.
Okay, well, where's the paper clip? And do you remember which one it was in?
Where was the paper?
This side.
She looks like Lady Di now. She's got her long white gloves on and her black suit. She's our princess. Hashtag Sarah Boone is our princess. Look at there, standing all reverent and demure. Very demure, as they might say.
Judge, the paperclip was on when this event occurred. When we pulled the suitcase out earlier, the paperclip was not attached. So now the prosecutor has attached the paperclip. We don't know if that's the way it was attached.
It's not even a paper clip.
We don't
Okay.
know if that's the proper way that it was attached. But he's asking her now to pull.
Is there an objection?
I object.
Yes?
Approach.
Is Sarah Boone just going to stand there in the well while they're approaching? This is the most awkward thing in the world. The defendant's just going to stand in the middle of the well. This is, okay. This is different. We're now arguing over a paperclip. In case you're curious what we're doing, we're literally arguing over a paperclip. That is where we're doing. Where was the paperclip? Was it positioned this way or this way? Was it on this thing or this thing? Where was the paperclip? Paperclip and you. We need to ask Clippy from Microsoft Word if he can help. He's been waiting all his life. Clippy has been waiting all his life to help us, and we finally need him. Clippy, we need you. Show us where the paperclip was. We need you. Damn you, Microsoft. Is the jury there? They sure are. Paperclip gate, you know it. Stuck on strings. Retrial because of paperclip, you know it. They left her alone with the murder weapon, 100%. Yes. Can't Sarah put this paperclip on? Maybe. Would you like to plead insanity? Yeah. 100%. You know it. Sarah Boone just standing there in the middle of the well. I'm surprised she's not turned to the jury, give him a little wave, do a Princess Di. I can't do a really good Princess Di wave. I haven't practiced. This is a thing that's happening. This is a thing that's happening. We're sending our love to the well, all the way down. Sending our love to the well, down that well.
Objections overruled.
All right.
If you feel most comfortable, sir.
Madam Court, are you ready? Can we see how it was that the two zipper parts were positioned when you say that Mr. Torres was able to get his hand out? If you want me to do it, I'm fine to take your direction.
From what I remember, this is how the suitcase works. This was up here.
Zipper get stuck? That'd be good.
This was not this hard either.
This is this is the thing that's happening in the courthouse right now. Zipper time is glorious time for you and me.
Oh, right there, ma'am?
Baby.
Sure.
Zipper time is glorious time
Closer.
for you and me.
It's not over there? Where do you?
You asked me where I zipped it.
When you say that it was zipped shut, show us.
Are you talking about how I zipped it, or?
When you're done zipping
With the
it shut and he's inside of it, where are the zipper components?
This is the worst version. This is the most bizarre version of putting the murder weapon in the defendant's hands I have ever seen of or contemplated before. This is one hell of a way to put the murder weapon in the defendant's hand. What is happening? Is this real life?
Yes, this one was already pre-finished, yes. From what I can remember. That's how he was coming with his hand out. It was like this from the corner part.
Okay.
We've now got 3 adults figuring out how to zip it up. As a judge and jury overlook the thing.
Did you ever change the position of those zippers once you put it in that position?
I did not.
That was interesting. I'm not really sure what we were trying to do, and I don't think we did it, but okay.
And so once he was zipped into there, there's some amount of time, but you don't remember specifically before you start taking the 2-minute video, correct?
Yes.
And then that's when you say what you say, and that's when he says what he says. We've all heard it, correct?
Yes.
And then between there and that second video of the 22 seconds length, it's at this point where he's beginning to get angry, and then that's when you take the baseball bat that's in evidence, and your testimony is you start poking him with the end of it.
Did you say this was the second video?
Between the two videos, that's when you started hitting him with the bat because he was getting angry and trying to escape, correct?
Right, I was not hitting him, yes.
Okay. Did you ever hit him with the bat while he was outside of the suitcase?
No.
So each time that he is hit with the bat, it's through this suitcase. And that's what leaves the marks on him because you didn't hit him with the bat outside the suitcase, correct?
Yes, if you'd like me to demonstrate.
No, that's okay. The suitcase will speak for itself.
The suitcase speaks for itself.
And then you take the second video.
Excellent.
And you go upstairs and go to bed, correct?
I apparently went upstairs and I used the phone to make a phone call.
Okay.
What is Latin for suitcase?
All right. And at the point in time when you left and went upstairs,
Probably something like
he was still
valet.
inside the suitcase, correct?
Right.
Correct.
Was he
Res,
still
valet,
asking for you
loquitur.
and calling your name?
Not that I can recall.
Did you say shh to him again?
I don't remember.
Did you tell him that this was his problem and it's on you again?
I don't remember.
Did you do anything to help him escape from the predicament that you zipped him up in?
No.
No other questions?
Wow.
Any
Really?
redirect examination?
We're done with cross? Really? Okay.
Ms. Boone,
I don't know what
just
just
asked you the
happened.
question that you poked him, and you didn't poke it. You poked every time you poked him hard with the bat. He was inside the
You're not going to
briefcase.
make her. You're not going to make her watch the video.
The suitcase.
You're not going to make her watch the.
But
You're not
you
going to make her
remember
watch
when he put
it.
his hand out. Did you not hit him in the hand
What are we doing?
outside the suitcase?
Yes.
Okay. So that was the only time the bat touched Mr. Torres's body outside the suitcase.
Yes.
Was when you hit him with a hand. But all the other injuries were with you poking him pretty hard. I mean, you bruised your hand, correct? Doing that. Thank you. That's all I have.
Ma'am, you can return to counsel's table.
Judge, can we approach you?
Just a moment. Let me get her situated at table, and then we can approach.
Can they bring her back during rebuttal? I don't know technically whether or not they, strictly speaking, can or not.
All right,
I
come on up,
also
Gail.
don't know how that would work practically. I don't know if anyone's ever tried before. I mean, I guess they could try to bring her back during rebuttal. I just don't know how that would even work in principle. I'm not sure I've ever seen anyone ever try it before. But I guess. Yeah, that was a very, very lackluster cross. They've had at least 30 days to prepare on that cross because they knew this was happening like the whole time. They've had time to prepare for this cross. They had the entire weekend, last weekend, to prepare for cross. And this is what they've got. It was a very, very lackluster, disorganized, lackluster. They didn't even make her watch the video. They didn't make her watch like the police interrogation video and like point out every one of the lies or contradictions. I mean, that's like my first thought. My first thought is like, make her watch the video. It was like, didn't you say this? Didn't you say this? Didn't you say this? Make her watch the police. Okay, so this was a lie. This was a lie. Maybe point out every single one of the lies. I mean, that's my first thought. I don't know if it's necessarily a good thought, but it's my first thought. And they didn't do any of those things. And they started with math. Like math is going to prove or disprove this. Didn't you say you were feeling the effects? Well, isn't it true the alcohol had gone out of your system? What a thing. You guys said he was going somewhere with that. You guys tried to say he was going somewhere with that in chat. Remember you guys in chat? Own up. You guys said in chat he was going somewhere with that. He was not. You were wrong. Apologize. You were wrong. So it was just wasted energy. She's sure she's won.
Hi, members of the jury. Thank you so much. It is 5:42. At this point in time, the court's going to go into recess for the evening. I thank you again for your continued service and your attention in this matter. We're going to start tomorrow again at 9 a.m. here in 12 Alpha at the Orange County Courthouse. I'll read you another instruction. I know you've heard it. I'm sure you're sick of it, but I got to keep reading it. So thank you. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are at the courthouse, at home, or anywhere else.
They got her lying about the cheating.
You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, I'm going to excuse you for the balance of the evening, and thank you so much.
She claimed on the stand he didn't cheat from her. She also said that she thought the pornography was cheating. So it was kind of ineffectual.
Thank you. With regard to these medical records, the court previously today had required by 5 p.m. to address those. Unfortunately, they have not yet been addressed. It is imperative that the state knows what it is we're culling down or redacting. And I understand that you may want to be seeking those into evidence maybe tomorrow, and the state needs to be advised as to what it is that you're seeking to utilize. So where are we in figuring that out?
Can I have 1 minute with the client?
Yes, sir.
If the defense manages to pull this out, after all that, man, what can you say? What can you say except the defense is very, very good. If the defense manages to pull out a win out of this, what can you say? They may well do. They may well do. Sarah Boone has read her domestic violence literature. She's read the pamphlets. She's read the books. She knows the right buzzwords and right phrases. She's got it down.
Judge, we've had discussions with Ms. Boone, and she claims that every time that he went to the hospital and the medical records would show that it was in relation to some type of domestic violence involving her, we've expressed to her that we do not wish to pursue it and introduce those records of George Torres, of his medical records of the different times he went as it relates to their difficulties. Do you understand that?
Okay. Ma'am, earlier we had discussed, anything else to add to that, Mr. Owens?
Just that I've explained to her that the lawyers make those decisions.
Okay.
And I believe she's in agreement now. I just wanted to get it on the record.
Understood. All right, so ma'am, I just got a couple follow-up questions, similar to other conversations we've had over the last couple of days. I don't want to know about the specifics of any conversations you've had with you and your attorneys, just whether or not you've had them. You recall earlier today I'd asked you questions about certain rights that you had the ability to decide. Do you recall that conversation that we had, ma'am? It was before you testified.
Yes.
Okay. Do you recall that I advised you that the lawyers get to make most of the strategy determinations at trial? Do you recall that?
I do.
And do you recall that you said you understood that?
Yes.
And do you also recall that I advised you of certain rights that you have? Do you recall that?
I do.
And one of those rights was the right to testify or remain silent. Do you recall that?
Yes.
And did you understand that?
Yes.
So this decision is a trial decision as to whether or not there's certain evidence that your lawyers are going to seek to utilize in your defense. Do you understand that?
Yes.
Do you understand that they are exercising that trial strategy at this time not to pursue those medical records?
I do.
Okay. Do you have any questions about that?
I don't.
Are you on board with that strategy?
I am.
Are you still on board with the strategy utilized in your defense?
All of it, yes.
Are you satisfied with your lawyer's representation of you in this matter?
Yes.
All right, thank you. State, anything else we need to address before we
My
retire
understanding,
for the evening?
sorry.
That's okay.
My understanding is the last civilian witness they intend on calling is arriving at MCO at 9:03 in the morning tomorrow.
It was either 9:03 or 9:05, yes.
And plan will be to depose her in the evening at 5:30.
Okay.
Then, just scheduling purposes, we're trying to figure out when we would need our rebuttal expert, Dr. Werner, to appear.
I know Mr. Owens had said they were endeavoring to finish by Friday, but I don't know if Dr. Harper's availability issues for tomorrow is going to change that anticipated timeframe.
I'll try to reach out to her by text. That's usually how we communicate. But
Well, assuming she testifies on Thursday, are you still in a position to rest on Friday, or would that kick us to the next week, sir?
well, no, I want to finish this week if at all possible. If I'm hoping that Dr. Harper could be here tomorrow when Dr. Brannon is here, but let's just say she's tied up in bed.
Let's do worst case scenario.
Okay. She's here Thursday morning. I think we would try to finish our case right then and give the state a chance to rebut. I would say Thursday. I would have.
Okay, my understanding is our expert can't be here in the afternoon on Thursday. I'm going to have to check her availability for Friday.
If you would be so kind, and we can address that tomorrow morning.
Thank you.
Okay, anything else, State?
Not
Anything else from the defense? All right, the court will be in recess till, yes, sir.
I'm sorry, just to give everybody some scheduling, this might help everyone with scheduling. There are going to be 2 officers here in the morning who are going to be ready to testify. There will also be some other witnesses, officers, like the detective who testified, that I need to call back because of some impeachment issues of one of the witnesses. And then we'll get into everybody else's witnesses. So there's about 3 or 4 that I have in the morning time that we'll be proceeding on, then we'll go from there.
Okay, all right, appreciate the lay of the land. All right, we will see you all, that's what, one more, Mr. Owens. Yes, sir.
This flying in from New Jersey, I think, is Wednesday at 9 a.m. I think the flight, she's scheduled to fly out Thursday at 9 a.m. So if there's any way we could depose her, maybe in the morning or at lunch, and then have her testify Wednesday afternoon.
That's an unreasonable demand on my time, given everything I've been doing to make sure that we can get this pushed through. I need to do things like to get ready for expert cross-examinations and other things need to get accomplished at lunchtime. Happy to do it in the evening. My understanding that she was supposed to be coming in today so that we could do it tonight, and that didn't happen. But I don't think I should be forced to accommodate a lunchtime deposition.
Anything further?
I'm just telling you what our plans were.
Deposition will be at 5:30 tomorrow, or at any other, if we got to have it later, depending on how we go. We'll address it at that time. All right, thank you both very much. We will see you tomorrow morning at 9 a.m. Court's in recess.
All right. Well, we'll wait a second for Jules to call. But yeah, that cross was pretty ineffectual. I'm also surprised at how short it is. I'm also surprised that the state didn't sort of want to buy themselves the day, because they were getting pretty close to the end of the day anyway. I'm surprised that they tendered the witness back over to the defense. Like, even if they had planned, to tender them back over first thing in the morning, I would have lawyers like to keep options open, is what I'm trying to tell you. As a typical rule, lawyers like to keep options open, right? So if my option is, hey, I could tender her back right now, or, if I can keep this going for another 30 minutes or ask for an early close or something, I can, tender her back in the morning. Then I want the option because, maybe me and my friends are going to go to the office and think of all new exciting questions to ask, so it's I want to preserve my options. Even if I can't think of anything now, it's maybe I'll think of something later. But, by tendering her back, I don't have that option. So for me, it's just it's strange because, you're already at the end of the day. You have to buy 20 minutes. So have her go through something. I don't know, just waste time for 20 minutes. I can come up with 20 minutes worth of bullshit questions just so I can make it to the next day. And then I can come, forward with all kinds of new exciting cross questions that me and my friends came up with. I really should have done this, on last weekend, but, since I didn't, maybe I can do something tonight, whatever. So I just don't really quite understand that strategically, unless the state really thought that their own cross was just unbelievably great. If they think their own cross was everything they hoped for, and so there's nothing left to be done, then I guess, but I didn't really feel that way. So it doesn't make sense to me. So I don't really know what was going on with that. The cross was forgettable. It was unorganized. They really should have stepped through in some sort of topic way. They should have stepped through things. I would have shown her the video again, made her confront it. I don't know. I would have thought I didn't really think show and tell on the floor with the suitcase really did anything. It didn't really do anything for me. Defense, I think, won the day. I think is a fair characterization. So I think that, the defendant's testimony was better overall than I thought it was going to be. She certainly had a lot more evidence to support domestic violence than I thought she was going to have. She has a lot more there. And, the jury could just wind up hating the guy and not really care very much about the details. So I think the defense won the day. The defense's presentation of the evidence was much better than I expected. They had more stuff to give, and they still have more witnesses apparently that they're going to call to talk about some of this stuff. So I think that the defense won the day. So disappointing. And crossing the defendant is every lawyer's dream. It's the thing. It's something you live for. Is crossing the defendant. But they did not bring their A game today, in my opinion. Their cross was unorganized. I didn't really know what they were talking about. There was no logical there was no flow to it. There was no flow. There was really no indication from the topics what questions they were going to ask, or in what order, or about what. And they started so weak. Didn't you say you were feeling the effects? Wasn't it true that you chugged this bottle and this bottle and all the rest of it, blah, 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 and all the rest of it? Hello?
Are you still on?
I'm on with you.
Oh, okay. All right. Well, you're not live streaming. All right.
I am live streaming.
All right. What questions do you have?
No, I'm just curious what your perceptions and also the jury's perceptions of both the
The demo-
direct and
the-
cross were. What? How did you think the jury was responding to the direct, and how do you think they responded to the cross?
I thought the jury responded well to the direct. I'm not sure what if they're thinking the way I'm thinking, then it's not a good response for the cross, because I expected more out of Mr. J on that cross. So I was disappointed in the cross. So I don't know if the jurors are thinking that. I will say they all stood up, as did I, everybody in the gallery as well, during the Suitcase demonstration. That I thought was brilliant.
Really?
But
I didn't really think it was very effectual. At least to me, it didn't play very well for me. I didn't really know what they were trying to really play. I mean, what they're effectively trying to do is put the murder weapon in her hand, but I didn't really think it worked.
Okay. All right.
But you tell me what you thought it was like in the room, because our perceptions are not the same, and I'd love to hear yours.
Right. Well, I thought it was effective because of the fact that it got every juror up on their feet, watching and note taking, and same as in the gallery. The only two people that did not stand in the gallery was George's daughters. They remained seated. On that. So yeah, that's how that went. Now, it is what it is. I thought Sarah did a good job on both direct and cross. I thought she held it together. Whether she was believable or not, it's hard to say. I did see two female jurors nodding their heads, like nodding in agreement, when she was asked, like, why did you stay? And when she was explaining that, it seemed like two of the females nodding their head up and down, to me, is that they're in agreement with what she was saying. So, again, I don't know, though, if there's only 6 that are going to deliberate, so I don't know if either one of them are, on the panel.
Right. Well, I certainly agree with you that the direct was better than I anticipated, and the cross was also much more ineffectual than I thought. I had a problem with understanding if there was a flow for the cross at all. I was unable to anticipate, based on the prosecutor's questions, where they were going or what was going to be the next question. Did you have difficulty with the flow as well?
I did. I thought what was effective when he pulled out the 1.5 liters of wine, and then and he drove home the point that both of them weighed 100 pounds, and between the two of them they drank these 3 magnums, and the jurors were taking notes on that. But and that's where she stumbled, in my opinion, because he was asking her about well, you don't remember taking the videos, but yet you remember this. Basically, do you concede that you were inebriated? And she's like, somewhat. So he did get her to stumble a little bit here and there, but I honestly thought that it was just going to be more aggressive, and it wasn't. And
I was surprised, for example, he didn't make her watch the video again, or didn't even make her watch the interrogation video and break it down as okay, when you said this to the police, was that true? Basically just pointing out every lie.
That's what I expected myself, Kurt, and it did not happen. I thought what would have made it more effective when he was asking her, well, you did this to him to teach him a lesson, and she's like, no. Why didn't he break out that video and show
Right.
again, the things that she was saying to him as he's begging her to be let out. That would have went well with his questions. You know what I mean? Earlier today, you asked about the lady in the pink blazer. Okay, she's part of the local. See how I do things? When somebody asks, I find out. She's part of local. The local news, Fox 35 here in
I buy that.
Orlando.
Yeah, she has a very sort of newscaster look. I buy that. Yeah.
Oh, that's her. Okay.
Yeah. That makes sense.
All right. Yeah. Anything
So
else?
it sounds like this thing is coming to a road. So if you had to predict what you think is going to happen now, what do you think? Are you less confident in the result than when you thought initially?
I think it might hang.
Yeah, I think you're right.
I think
the defense is doing better than I thought. If you need to go, I'll let you go.
Yeah. Do you want me to call you tomorrow or what?
Yeah, why not? That'd be fun.
Okay, fine.
I love talking to you, Jules.
Oh, thank you, Kurt. I like talking to you too.
I only wish I was down there in person.
I'm telling you. Well, maybe you should come for the Stephen Stearns trial. I mean, are you going to be covering that?
I'm not familiar with that trial off the top of my head.
I'll send you some information on it. I'll email you some information on it.
Well, if it means time with you, Jules, I'll come down for it.
Oh, you're so sweet. You're so sweet.
Maybe we can play hide and seek together.
Oh, Lord have mercy. Fox 35, don't you dare hit my car.
I'll talk to you later, Jules.
All right, bye.
Bye-bye, Jules. That was our good friend, Jules. We love Jules. She's the greatest. Down there on the ground. So, yeah. All right. Well, we'll see how it ends, I suppose, for tomorrow. What a day. What a day. Yeah, no, I'm still back on the legal problem with the imminent threat. I'm still back on the objective thing. I'm like, yeah, I don't know. Yeah. Madeline Soto case. I'm no wiser. I'm no wiser. Who was the Stephanie Stearns and who was the Madeline Soto? I'm no wiser. Yeah. So those names don't mean anything to me off the top of my head. But okay. All right, I guess I'm going to go ahead and sign off for the day. We will see you tomorrow, bright and early, 9 a.m. Eastern. Tomorrow is Wednesday. We may finish this trial this week. Do I think she could walk? I think it's certainly more probable than when we started this. I think it's more probable. You know, I think she was more convincing overall. I think the cross was completely ineffectual. Didn't point her out to be the lying liar that she is. Blown opportunities, man. So, yeah. Sarah outsmarted us all, yeah. I think he laid the groundwork for rebuttal and closing. Maybe, but I don't know, man. I feel like there were opportunities that were lost. I don't know. All right, I guess I'm going to sign off for now. I'll see you guys tomorrow. Bye-bye.